Hello.
With especially aggravated kidnapping. We're also charged with aggravated kidnapping. We're also charged with aggravated kidnapping. We're also assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
By gosh, make them work for it.
9 out of 10 judges prefer watching the Recovery Addict's live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican, please. Verbal
That is literally not true.
I didn't ask you to interrupt.
Is that correct?
Oh, for Trump's sake.
All right. We got it figured out. Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. A little rough start this morning, but it's early. Well, it's 10. It's 10. Okay, it's early. It's earlier than it's been before. Oh, where's the right remote? All right. We are going to be going to Florida here in just a little bit to pick up a little trial. Drug trafficking trial. That's what we have. So we'll be going there in just a minute, but hold tight. We have to pause right there. Have to welcome, first of all, let me get all this working. Turn that on and this on. Have to welcome Mommy Sharshar first in chat today. Congratulations, Mommy Sharshar. You are in fact the internet owner. Everything IP related worldwide is your responsibility. Because you were first in chat, we're going to punish you for it. So thank you very much. It is a podcast Thursday. Big shout out to Thomas, who got the podcast already yesterday. It was already, and it was pretty much all him. Thomas definitely pulls the lion's share of the workload on the podcast, and I appreciate him for that. He's amazing. It's so much fun to be a podcast co-host with him. All right, Katie, I came on when the Letitia trial was on. Katie, that makes you an OG. Katie, that's awesome. How is everybody doing this morning? Happy Thursday. Happy Thursday. We're gonna sing happy birthday. We don't have to start court right this very moment. Because let me tell you what's happening in court. This is it. Let's see if we can go there. Judge comes in, pops a squat.
Bay County Courthouse Annex Courtroom 8, State of Florida versus Christina Heath. Mr. Prince, you just filed a notice of appearance. I know that Mr. Gilton, I've been told he's here. And Ms. Heath has not made it yet.
Ms. Heath has not made
Middleton
it.
indicated that somebody here told him that she got stuck in traffic. There was an accident around Dothan. So I guess he's outside trying to ascertain.
Around Dothan?
Yeah.
Okay, so we're just missing a defendant is all. We need one more defendant than we currently have, and then we can start trial. But we'll be down there in just a minute for that drug trafficking case. Methamphetamine and a fair amount of it. Let's see where that goes. This is the only courtroom where I think just walking in to your jury trial, if you're charged with any sort of drug charge, you have already about a 50-50 chance of winning. I don't know why. I don't know why Judge Clark's courtroom is like that. But yeah. Happy birthday to Kaylee. Let's sing happy birthday to Kaylee, and then we'll kick off the court watch today. So, excuse me, I got a little carried away. Wherever you are, if you're able and it's legal, of course. Stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. That's beautiful. I was singing a little Larkin Poe this morning in the studio. Had it going on my headphones while I was late. Anyway, here we go. We're gonna sing happy birthday to Kaylee. Happy birthday to you. Happy birthday to you. Happy birthday, dear Kaylee. Happy birthday to you. Happy birthday, Kaylee. Kaylee Rose. Big 21. I don't know how many years in a row that's been, but 21 years old. Am I the only one? Kaylee, it's just you. It's just you on this Thursday. You're that special. The The best part about this, Kaylee, is the dancers are all dancing for you. Hello, Walker's husband. Enjoy your morning beverage. Let's get your day started. Kaylee, I realize there are many wonderful days, but today's your special day. And there are a million people let me start over. There are a million people there are a million places you could have been and a billion people you could have been with, but you chose to be right here with us. The privilege, pleasure, the joy, the honor, that is ours. Hopefully we can turn that back to you, make your day a little more special, or begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, and its grill, Bob Evans, and Cracker Barrel. There we go, all those options. Yes, 80s, we can definitely see who has been practicing and who stretched before the performance. It's all right, guys. Recovery Addict's just having a tiny stroke. I'm feeling good today. Welcome. It's the best way to start the day is singing. And I honestly believe all of you are singing with me. Right? You are all singing with me. And doing the air drums.
Happy birthday. You look good.
More dancers than we've ever had. This is crazy. 80s, your recruiting definitely paid off. We've got dancers galore. So, did I catch up on sleep? Yes, they say you can't do that, but I did. I caught up on sleep. It started by going to bed early, which I didn't realize was part of the equation. I thought you could only catch up on sleep by sleeping in. But no, I went to bed early. Well, before midnight. And then I just woke up. So, yes, I got plenty of sleep. It was wonderful. It also helps not to wake up in the middle of the night. That's also a big plus. Debbie, the Creative Bee Shop, member for 41 months, says, best place on the internet. I love my RA family. There's no place I'd rather be. Debbie, that is awesome. Thank you very much, Creative Bee, on that one place. Why can I not remember your... It's not Pinterest. Debbie, the early onset amnesia, I was joking with the mods about this, but I just forget some things sometimes. Not Instagram, not Pinterest, Etsy. There it is. Etsy, the Creative Bee on Etsy. Thank you very much. Debbie, you are, in fact, an OG, or in this case, an OB, but in a good way. Kim, our member for 38 months, also an OG, 38 months with the best place to be on the YouTubes. Thank you very much, Kim. Wouldn't be the same without you here. Glad to have you for sure. 38, 41, that's a lot. Speaking of forgetting, I can't remember the last time I forgot something. Well, lucky you. That is awesome. That's also, I can't remember the last time I forgot. All right, we are in a holding pattern with Judge Clark. We can't go there now because he turned off his stream. So we're just going to chill for a second while we wait for the 14th Judicial Circuit to find their defendant. And if it takes too long, I'm sure we can employ some bailiffs or sheriffs who are anxious to see justice pursued. 14th Circuit Judicial... I can't get this right. There it is. It understood what I meant. Okay. All right, we'll hold tight right there for just a minute. What's your thoughts on the Letitia retrial? It has to be done right. As much as I hate that trial happens over again, and the people who, the entire community that got dragged through that trial and had to see everything from the hair fort to the shared water cups and everything about that trial, except for the jury instructions, which I loved, and the jury questions, which were great. I hate that it's happening again, but at the same time, I see the need for it because the process has to be followed. And if we don't follow the process with one person, we say it's okay to not do it right with one person because they're really guilty. the next person that we do that to could be not guilty. So, are we watching the jury divorce trial? Yes. I don't know if we're going to watch all of it. I have not pre-watched. Well, we're going back in time, and then we're maybe going to get the closings. We'll see. I think you do better on lack of sleep. Thank you, Josh. Appreciate your vote of confidence from the mod extraordinaire who didn't find this trial for us, but found it before us and decided to watch it without us. Now she's going through the insanity defense. You know, when at first you don't succeed, change it up and try again. So I guess the definition of insanity or stupidity is doing the same thing over and over and hoping for a different result. And at least in this way, she's mixing it up. We're going to see a little of David's testimony today. We are. We probably are only going to see a little. We have a thumbnail for it, but yeah. Let's see. I'm oddly invested in that divorce trial. It is oddly. I'm interested purely on the how does this work side of things. The mechanics of a divorce trial with a jury. It's like your peers get to choose which one of you is right. It's awesome. You know, I've always thought of divorce involving judges, and the judge makes the rules, and everything's presented, and they lay down the law. This is the way it is. And if you get a bad judge or judge, you know, people say, "Oh, I got a judge that hates men," or "I got a judge that hates women," and that's why the divorce went this way. Well, now you've got a jury, and what do you blame at that point? That's, you know, if it doesn't go your way. Let's see. I hear you, Josh. I think we're gonna do this. This is what my thought. We're gonna get a little bit of David, probably more than we want, and then we'll court hop and possibly catch the closings. I'm worried that it will go where no trial should go before, or ever again. We want to know who gets puppy dog, for sure. But the more I listen, the more I think, why is this a divorce court? Why is this not a criminal court? Are we not hearing a crime that was committed and perpetuated almost in perpetuity? It's a lot. It's a lot. Yeah. We'll bail. We're not gonna. We're gonna see the decision, but we're not gonna stick around for all the dirt. Let's put it that way. Judge Wolf really doesn't like us. I don't know how else to say this. I've been trying to hold this news from you. He really doesn't like us. There's a good chance Judge Wolf would try to subpoena me from out of state to face him directly and face his wrath and contempt if we went to his court. I don't know who it was that did him dirty, because I've said nothing but great things about his Heavenly Wood courtroom. But somebody on the tubes of you did Judge Wolf dirty, and now we can't go there. He is threatened in no uncertain terms litigation personally. If you go to Judge Wolf, which, you know, we have a right to do. We can, it's publicly available, and we can go there with fair use. I mean, constitutionally, I'm fine. I just don't want the expense of the defense. Yeah. And I might have to drive through his state one time. I don't want to ever be facing a ticket in his courtroom. It is a shame. It is a shame. But I think it was, I don't know the situation, but it sounds like someone just took the court feed and used it to mock or ridicule or publicize or dox or did something they really shouldn't do. with it. And I'm fine with a little bit of mock. It's in public, and how you behave in public is, fair game for public to judge. But I think it probably involved children, involved sensitive situations. Just stay away from Fulton County for traveling. I'm staying out of Georgia. Really, Georgia is. That's the first state I crossed off of my list when I decided to move. Georgia, nope. Good advice.
You are banished from the state of Georgia.
I think I may avoid Atlanta too. I won't even fly the airports. What's the hub that goes to Atlanta? Is that Delta? Can't fly Delta anymore. All right, let's see if we've got. Let's see if we have. Judge Clark looks to be. Not here yet. Judge Brantley Clark. Yeah, nobody, not even Judge Mercer is live right now out of 14th Circuit. So we'll keep an eye on that, and we'll go there in just a bit. Utah and Florida seem to be the states to avoid. The thing is, I understand Utah law. Growing up there, it makes sense to me. I feel more confident, going through. I know what's legal. I know that I can have my radar detector, for instance. Not to speed, but just to be aware of where the police are in case they might be pulling onto the street. For safety reasons, I have a radar detector. But in Virginia or Tennessee or something, I don't know. If you have a radar detector, if I'm just traveling through, does the Constitution allow me to use a radar detector while I'm in the state or not? Or, is that am I going to get pulled over? Do they have radar detectors? Divorce trial doesn't start till 1 p.m. today. Yes, it's going to be closings. We're going to try to catch the closings for sure. We're trying to get this system to automate and turn on by itself instead of having to manually turn it on. And so my son's working with a couple different programs, and it's not working yet. Any big trials in the pipeline? Yes, as a matter of fact, we're just waiting to hear back from Nevada because we have a trial that starts. The Keefe ED trial starts next week with jury selection. Let's see. See if they've done that already. Top Mark Media. Proposed order submitted. Register for electronic service. Yeah, we're just waiting for them to respond back. Fun fact, I might go out there. I'm just tossing that out there. Might go out to Nevada if depending on the trial. I've seen the schedule. They sent me the schedule, the hours of trial for the 3 weeks or whatever it's scheduled for. And with this request for coverage, they're also going to put me in the pool of potential in-court reporters. And depending on how far in advance they make that lottery drawing, because there's massive interest in that trial, I'd fly. I'd fly for sure. Anyway, that's the idea. So, as someone who drives from Florida to New York and whose husband got a ticket for having a radar detector just sitting in the passenger seat, yes, you can get a ticket for having it in the car in Virginia. There are some states you're not allowed to have a police scanner in, and I'm not confident that. You're not allowed to have a police scanner while committing a crime. So if you're speeding with a police scanner, it's a crime. I'm not confident that me with my ham radio or my legally licensed GMRS radios or something like that, that an officer would be able to tell that this is not a police scanner. Yes, it's capable of picking up police transmissions because it's in fact a receiver and a transceiver, but it's not a police scanner. I just think I'd get busted for that, so I'm always cautious. Warren County 3 has a trial on retail crime. Warren County does. We can't rewind on Warren County. We just have to pick up where they're at. Warren County Courts 3. What's happening there? That's not it.
Onto the store to confirm the theft, and it was said that the two suspects had left the store. So at that point, I was, for lack of a better term, roving the parking lot,
Okay,
attempting to locate based off of a description.
I see. Were you able to find anybody matching that description that day?
I did not.
Were you involved in gathering the evidence in this case?
Not necessarily gathering the evidence from the store. At that time, I was working part-time detective, part-time road patrol,
Okay.
to assist with the thefts at the mall. And I believe on the box file that Mr. Mueller spoke about, I downloaded those and
Okay.
had those available for the case.
I see. And is this a particular expertise of yours, is the retail theft?
Yes, sir.
All right. And so was there, as far as that was concerned that day, what was the issue about this?
Okay, a loss prevention officer does not perk my interest this morning. Let's do this. Let's satisfy our curiosity and get to hear a little bit from David. Let's see. Let me go back. Let's go to let's get openings. Let's see if this works properly. Let's get openings and then go from there. Do you have openings here?
A little bit more to my client. So Mr. Piner is 41 years old. He is employed and he is good at what he does. So he works with computers and technology. He's also a gamer. He has skills and talents that he has developed over his own years and hard work and dedication to his profession. And he has always supported himself. He's never expected anyone to carry his financial weight. Now, here's what the evidence is going to show about the opposing party. He is 31 years old. He is young. He is healthy. And he is perfectly capable of working. And yet, for the entirety of the party's marriage, he has chosen not to work. He did not stay home to raise any children. There aren't any children. He did not stay home because of a disability. There's not a disability. He stayed home because he wanted to, and he is still under the belief that he deserves to be taken care of. As bad as the financial and domestic situation was, it actually gets worse. So because this case is not just about money, it's also about abuse. So the evidence is going to show through testimony and evidence that we present through exhibits that the opposing party, Mr. Terry, physically abused my client. He manipulated him, he controlled him, so much so that there's actually an active protective order between the parties. So there is a temporary protective order right now in place that protects the opposing party from even being around my client due to the abuse. And to take it one step further, he's been convicted of his abuse towards my client, and he's actually on house arrest right now by way of a ankle monitor. So the man that has been so abusive to my client is now sitting here asking you all to force my client to keep taking care of him financially while he doesn't work. 31 years old, mind you. So let that sink in.
Let that sink in.
The opposing party is going to make claims in this trial. He's going to claim that my client got rid of marital funds or he wasted and hid money. I'm not quite certain how much you all know about filing a divorce and going through a divorce process, but what generally happens is when you file a divorce case, you're able to go through something that's called discovery. What happens is discovery is you're able to discover the finances or anything else that you would like to find out about that your spouse has that you don't have a clue about. So You can request bank statements. You can request retirement statements. You can request deeds, assets, credit card statements, etc., to be able to trace, to see the parties' money. You can do that for upwards of the duration that the parties have been married. What I will say is that the parties in this matter participated in discovery, requested all the documentation from my client. There was no discovery disputes, and they are not going to be able to prove or show any evidence, any bank statement, any receipts, any document of my client hiding any money. And they had every right to do so during the discovery process. The opposing party believes, well, he wants you to decide whether he should get alimony. He wants all of you to say that my client has to keep paying for a man who abuses him. The opposing party believes that because he was married to my client for 8 years, he is entitled to be taken care of for the rest of his life at 31, mind you. He believes he can sit at home, do nothing, abuse his husband, and collect a paycheck. And that is what he wants. That is what he wants you all to do for him. Here's what we're asking for. We're just asking y'all to end the marriage. We're not asking y'all for anything. The marriage is irretrievably broken. There's no hope of reconciliation. We're asking that you deny his request for alimony. He needs to go get a job and employment. We are asking that you assign their debts fairly. My client is willing to keep all of the debts that are in his name. We're asking that he keeps his debts. You all get rid of the marriage and deny his request for alimony. My client would also like to keep the dog. And other than that, that is all we need you all to do. This is a able-bodied man who is sitting here trying to get 14 of you all to award him my client's money because he doesn't want to take care of himself. And I believe that the evidence is going to show that that simply is unfair, and you all just need to confirm the divorce.
Thank you, Ms. Yarber. Mr. Polanco, are you giving an opening now, or are you reserving?
Oh, he's giving it. And then we'll have, I think, David.
So as Ms. Yarber said, I want to thank every single one of you for taking the time to fulfill your civic duty and be with us possibly for the next 2 days. I think if we run at a good pace, we might be able to get through this in 48 hours by tomorrow, Wednesday. When my client, Christopher Terry, learned that he was getting divorced by Mr. Piner, he was in jail at the Fulton County Jail. Now, when you receive papers out of jail, it makes you question, well, is there something else going on here? Right? That's certainly the question I had when I went to visit him at the jail in August of 2025. Now, at the time, Christopher Terry, who weighs maybe 130 pounds, if I'm being generous, looked into my eyes and said, I'm in this situation. I don't know what to do about it. I was given papers for a divorce and I have 30 days to respond. If I don't respond, divorce goes by default to my husband, right? His name is David Piner, and this is his story. Now you're going to be hearing a lot of that story over the next couple of hours, and possibly, a couple hours. And both Ms. Yarber and I will have opportunity to speak with Mr. Piner and ask him, what this is all about. Now you've heard from Mrs. Yarber what this is about, at least in an opening remark sense, right? According to them, their side, they want to be granted a divorce, and just each side walks in their own, respective directions, and we call it a day. But like I said, Christopher Terry has a story to tell when it comes to all of that, because we didn't ask all of you to take time off of your jobs, your lives, to just dissolve a marriage where each party gets to walk in their own direction, because frankly, we could have done that ourselves, or they could have done that themselves. But Christopher Terry, my client, feels that he has a story to tell that no one up to this point has heard, and he would like someone to hear it. So as I said, my client was was served with complaint for divorce in September of 2025. and he had to answer within 30 days. He did so. But as part of the answer, he counterclaimed, meaning that David Piner was asking for the divorce to be granted on the ground of an irretrievably broken marriage, which is the 13th cause of divorce. There's 13 causes. Now, in the old days, there used to be 12, adultery, separation after a year, and you had to prove that your spouse had been guilty of one of those 12 causes before you could be granted a divorce by a civil court. But sometime, in the 60s, 70s, as sort of no-fault divorce became popular, they added this 13th ground, which is the irretrievably broken marriage ground. And basically what it means is that we just, we can't get along, we just want the marriage to be over. It's not that he was unfaithful or I was unfaithful, it's just that, this is the 13th ground. So that's what David Piner is alleging in his complaint for divorces. We just have an irretrievably broken marriage, we have irreconcilable differences is sort of a different way that it's known by, and that's what he assumed. But as part of the answer, we counterclaimed that there specifically one cause for the divorce should be granted, which is what my client is saying, is that the divorce should be granted based on cruelty. Because my client is saying that his husband, Mr. David Piner, has been cruel to him. Okay? Now, so that's the number one thing that you're being asked to decide, and I think Ms. Yarber spoke to it, is the ground for the divorce. What is the reason for the divorce? Is it going to be that we have irreconcilable differences, or is it going to be an at-fault ground of cruelty, which is what my client says that his husband was. Okay. So once the ground for divorce gets settled, the second thing that we're asking for is to, excuse me, to discuss the issue of alimony. Alimony is a word that comes from ancient Rome. It basically referred to nourishment or food sources, maintenance, and it's an old concept that applied usually in marriages where a man maybe was the sole breadwinner because women maybe didn't have sort of a job, sort of out there in the economy before the 19th century, and maybe they would be married to their husbands for 40, 50, 60 years, and then maybe they get divorced later in life, and then, so that's where the concept of alimony comes from. Now, alimony is a relatively rare thing to do. It's not something that's often asked for in cases. It's asked in certain types of cases, usually high net value cases, because sometimes where there is one party that is the only provider and another party that is not, there's a very sort of obvious imbalance of power. And in certain situations, the person that is the person that is not working maybe doesn't have the skills, doesn't know how to get a job, hasn't gone out there. That's somewhat, as you will hear, what's happened with Christopher Terry, but that's not entirely the story as to why alimony is being asked for. In a sense, alimony is also being requested in this case because of the treatment of and the nature of the relationship. Now, the evidence is going to show, and we're going to hear testimony from both sides, and for the most part, I think they'll agree on
the evidence is going to show should be on the bingo card.
But perhaps they may disagree on how to interpret them. But one of the things that you're going to hear is that they met approximately 16 years ago, okay, in 2010. They were both gamers, they met online, and they sort of established this sort of second life type of life, and they decided to meet, dated for a couple of years, lived together. Now, a lot of things happened during those years, and you may hear about some of them, until they get married in 2018. Now, legally, anything that a marriage accumulates during a marriage really only begins accumulating once you get married. So it's really 2018 onward that we should be counting as far as like the marital estate, right? Whenever we distribute, what belongs to which party, et cetera, et cetera. But during the course of the case, we want you to hear what exactly happened during that marriage. Okay. Now, every marriage is going to have difficulties, and and so there is nothing particularly extraordinary about this particular one, right? Every life has challenges. Every marriage has challenges. Just being fair to all sides. However, when you start hearing the details of this particular marriage, what you start seeing is sort of this recurring theme, okay? The recurring theme is going to be that Mr. Piner is the sole breadwinner in the relationship. He has a very relatively high prestige, high paying job. And my client is sort of staying at home, okay, and providing the getting the food and the cooking and doing all the housework, okay? But as part of that dynamic, there's sort of like a very obvious imbalance of power, whereby Mr. Piner is controlling Mr. Terry to such a degree that it's just a very obvious imbalance of power, okay? And the relationship is, as Ms. Barber describes, emotionally abusive. It's emotionally cruel. There's a lot of back and forth, and a lot of it's going to be evidenced by text messages, because we literally have text messages covering a period of 10 years where you can see literally both parties' description and wording as to how they're describing what they're going through. And there's a lot of emotional abuse. We're not alleging physical abuse. We never have. Okay. Now, however, as I said, Mr. Terry was served at the jail with a complaint for divorce. And the divorce paper said, we want a divorce. Each side gets to go its own way. I keep the dog. I keep everything. I give you my debts, but I don't give you any of my assets. Those are the terms. You have 30 days within which to respond. So when I first met Mr. Terry around that time in August of 2025, I didn't know what to make of it. I took the case entirely pro bono. I'm not getting paid $1 for this. I'm doing this entirely out of my sense of what justice means or is supposed to mean. Because I thought that what I was hearing was a bit outrageous. And you will be hearing the details of that over the next couple of hours. The text messages that you will hear and will be submitted and admitted into evidence are going to contain a lot of statements by Mr. Piner that describe exactly how he's viewing what's going on, right? In other words, go get me a soda and a burrito. Don't spend $20. So whenever the situation has to do to benefit him, he's very liberal and giving and caring. But when it comes to feeding Mr. Terry's and nourishing his needs, he can be quite selfish. The dog, you're going to see that one of the issues that is being discussed and being debated is gets to keep the dog. Now, we are definitely not bringing you here because of a dog dispute, but when Mr. Terry read in that complaint inside the jailhouse that the person that's suing him in the jail and put him there in the first place wants to keep the dog too, that was sort of like this ultimate offense, right, to him. And, and so he's asking for it at the end of it, okay? He's asking for alimony, not for the rest of his life, as Ms. Barber suggests. We are only asking for alimony for a relatively temporary period of time that he can get on his feet. Mr. Terry has not worked ever in his life, except for his husband, Mr. Pine, since he was very young. So you will see documents regarding vet visits, the dog contract, when the dog was purchased, who the dog belongs to, et cetera, et cetera. You're going to be reading the text messages where Mr. Piner opines about, different subjects, religion, and other things. And as you hear testimony from both parties, like the court suggested, take a close look at two things. Number one is just sort of their demeanor, and then number two is the consistency of their statements, right? Because you can sometimes see in a person, sometimes it's sort of shining in their skin, if they're sort of telling you the truth, right? On the other hand, and you can see what the motive is, right? No motive for them telling you the truth or the lie, whatever the case may be. But also look at the consistency of the statements throughout, right? Because one thing that you're going to see in this, and the evidence is very clear going to show this, is that the pretext that Mr. Piner is giving my client as sort of like a justification to out of this relationship after 8 years of being married together is religion. Jesus, Satan, and all sorts of stuff. And you're going to see those text messages, and you're going to see how Jesus and Satan are being invoked, literally invoked, in text message version format as a justification for ending the marriage on religious grounds. Conveniently, it also ends all financial obligations. And you're also going to see in these text messages scenes in which Mr. Piner is literally bragging about what a, quote, insane amount of money he makes, about what an insane amount of money he got to spend in 2021 and 22. And yet, sometimes he denies Mr. Christopher like a $20 meal because, yeah, it's not approved by him. So I do agree with the plaintiff and the petitioner that this marriage should be ended on fair and just terms. And so for that reason, we're asking for very simple things. Disposition of the dog, disposition of Mr. Terry's personal belongings, which he hasn't seen since he was placed in jail. And there's a lot of those personal properties. To delineate the marital estate, you know, what is it, like what belongs in that marital estate, how it should be equitably divided between the two. There's a Toyota Prius that's going to be discussed. There's going to be a Z350 Nissan that's going to be discussed. There may be some debts that are discussed as well. And so all of those things are things that you're going to hear about that may be part of the marital estate, maybe separate property, maybe communal matrimonial property, and you're going to sort of decide exactly, you know, what would be a fair and just determination of all of that. And okay, so one last thing. So there's been some insinuations that there has been physical violence as part of this marriage. Now, again, while you're listening to all these allegations, I just want you to focus very clearly on the consistency of the narrative throughout. Because we have 8 years to compare like these stories against. Look at the consistency. Has this been mentioned before? Or was it just mentioned in 2026 in the middle of a divorce litigation? And I want you to look at all those power dynamics between the plaintiff and the defendant, and I want you to sort of come to a conclusion of what is really going on here. And all of you, I can tell, are extremely competent, extremely capable, and extremely great at taking the time to serve as members of the jury for the next couple of hours. So thank you.
Thank you, Mr. Polanco. We are ready for first witness on petitioner's behalf. Ms. Yarber?
I'd like to call my client, David Piner.
All right, Mr. Piner, if you come on up to the witness stand, but before you take a seat, turn and face Deputy Gordon, who's going to swear you in.
Sergeant, Stephen, they got kicked out.
I've got Polanco in, the screen. The screen. Okay, yes, I'll do that in just a second.
We're not going to stay with this whole thing.
Testimony on here, the truth, the whole truth, and nothing but the truth of God. Yes, sir. Lord, I see.
We're going to get it just a little flavor.
The chair doesn't have wheels. That's so people don't roll off to their death. So you got to sort of scooch it around.
Stay this way today.
David Piner, David Piner.
Mr. Piner, where do you currently reside?
123 Sesame Street.
Live there?
Since November of last year so I would say about 8 months.
Where were you residing prior to that?
At an apartment in Alpharetta off of Old Milton at 2207 Summerwood Lane.
Were you residing at that previous apartment with the opposing party?
Yes, ma'am.
Okay. How old are you?
41.
Okay. And Mr. Piner, what's your current occupation?
Senior marketing technologist for a company called Virtual Marketing LLC, doing business as Fusion 92.
Okay. Is he going too fast for y'all? Or are y'all okay? Okay. If y'all need him to slow it down, and I'll tell him. Okay. Mr. Piner, how long have you worked there?
So I've worked at that company since, I believe, last year, so about a year and a couple of months. It was a transfer from a company called Fiserv. So I started work at Fiserv in September of 2016, but I had moved to this company through a transfer process from a full-time employee of Fiserv to a consultant at this consulting firm.
Okay. And can you describe to the court and the jurors the type of work that you do at your job?
So I manage B to B to C. So that's business to consumer marketing emails on behalf of over 500 financial institutions that are customers of Fiserv. And so as customers of Fiserv, they have clients. So if you think of Fiserv as a financial technology company, they have clients that purchase products from them. And then they have customers themselves. So your bank or credit union will have customers. And then what we do is on behalf of our client, which is them, and it's kind of confusing. I understand that. But essentially, we send emails for someone, say like Georgia-owned credit union, right? We'll send that email as if it's Georgia-owned credit union or Truist or Bank of America, et cetera. And then in that process, it'll look like it came from them, but we'll be the ones to actually execute on that email for them because of our products. Like
So
we do Zelle,
he makes spam?
we do like Transfer Now, which is a way you can move money between your own banks and like credit cards and those kind of things.
They spam for other companies?
Mr. Piner, do you have any secondary degrees or college degrees, anything like that?
No, ma'am.
Okay.
I finished 8th grade.
Okay.
Wow.
Are you self-trained in terms of learning how to do your profession?
Yes, ma'am. No
Okay.
college education.
Age of consent
Have
in
you ever
Georgia
been married
is
before this
16
marriage?
years
No, ma'am.
old.
Okay. And do you have any
16.
children from this relationship or any prior?
No, ma'am.
All right. Now, can you tell the court and the jury when you first met the opposing party, Mr. Terry?
Sometime in 2010.
Where were you all both living at that time?
He was living with his father in Arkansas, and I was living with my girlfriend in Indiana.
Okay. And briefly, how did you all meet?
We were on this video game called Second Life, and then also another video game called World of Warcraft, and we met on the video game.
Were you all online friends?
Yeah, we were online friends.
I might have played against this guy.
And at what point would you say, I know you all met in 2010, at what point would you say that you all maybe started dating?
I don't know how to answer that question because we never really traditionally dated. We were more friends and roommates throughout the time that we were together.
Okay, so at what point did you all decide to move in together and begin the roommate arrangement?
So he actually visited us sometime in July of 2010, me and my girlfriend and her great grandmother. And then he sort of refused to go home. And then at that point, he sort of just lived with us from that point. And then I ended up living with his grandmother for a while. I rented a room from her. And then
Was that in Indiana also, or you were not in Indiana at that point?
No, that was in Statesboro, Georgia. We moved to Statesboro from Indiana and rented a room from his grandmother.
Well, I believe the court was inquiring about when he moved in with you and your girlfriend.
No, I was inquiring about the grandmother. 'Cause you said
eventually you were renting a room from Mr. Terry's grandmother. I thought, well, that's a coincidence that that's in Indiana, but actually you and Mr. Terry, without your girlfriend, moved from Indiana to Statesboro, Georgia.
Yes.
And you and he, Mr. Terry, had that room in Mr. Terry's grandmother's house.
Well, he had his own room and I rented my room.
Got it. So you guys had separate rooms at Mr. Terry's grandmother's house in Statesboro, Georgia, not Indiana, where the two of you plus your girlfriend had been.
Right.
Okay.
What year did you start renting the room at his grandmother's house in Statesboro?
2011.
Indiana is
Okay.
also a
And how long
16-year-old
did you all
age
reside
of
there?
consent.
Until 2014, so I'd say about 3 years.
Were you paying the grandmother the entire time to stay there?
She let me stay there like a couple of months for free because I had some debt and I was trying to pay it back, but then they eventually wanted, some rent money.
Okay. What were you doing at that time to earn money?
So I was actually, and this is real, video game journalist. So what I did was there's this website called 10 Ton Hammer, and it basically published articles and guides about multiplayer online games. So you think about like EverQuest to World of Warcraft, Star Wars, The Old Republic, those kind of things. And so I actually got really lucky early on in my life and was able to get this job online writing about video games. So I actually wrote and managed other people who wrote about video games. And it was a 1099 sort of payment structure. So you had to do your own self-employment taxes. But I did that job for about 11 years.
What was the opposing party doing for work while you all both resided at his grandmother's house in Statesboro?
His grandmother took care of him at the time. He didn't have a job.
Okay.
And she was taking care of you too, apparently, if you're not paying rent.
At what point did you all get engaged? Can you describe that to the court?
As far as I'm aware, we never got engaged.
Okay, so how did it come about that you all got married and there was a marriage license?
So he had SSI and there was a redetermination occurring, and then the tax law was changing about dependents. So we made the decision to get married so that he could get benefits because he would lose his Medicaid if he lost his SSI. So we got married so that he would get benefits from my employer so that he wouldn't lose his health insurance.
Or just
did you all go to the courthouse to get married?
All sorts of crimes.
It was, I don't know if it's the annex building, the North Fulton Annex building. I don't know if that's considered a courthouse.
Quasi courthouse.
Yeah, it's the annex building in, North Fulton.
The fake courthouse?
Yeah.
Okay. And what year was that?
2018.
In 2018, where did you all move to?
In 2018, we were living in that apartment in Alpharetta. So that was the Summerwood Lane.
Okay. So you moved from his grandmother's house in Statesboro to an apartment in Alpharetta, correct?
Yes, ma'am. In 2016.
Okay. How would you describe your marriage to Mr. Terry kind of overall?
That's a question. I really don't know how to answer that. Difficult? Is that an answer?
That is an answer.
It was a very difficult thing because money was very, very difficult to manage in the relationship.
What were your daily routines like as a couple?
So it depended on how my work worked out. So if I was working from home, then I'd get up in the morning, get on my laptop, and then work until I was done, and then usually go cook dinner or whatever. If I had to work in the office, I'd have to get up, get dressed, drive in the office, then come home, and then, fix dinner and all that good stuff.
Did fixing dinner solely require a microwave?
Work a job, and then as soon as, I get off, so I have to work basically 9-hour days. I'd just, come home, play some video games or watch TV or whatever, and then go to bed.
How did you and Mr. Terry spend your free time together?
We often didn't spend free time together a lot. It really depended on what year or phase the relationship was. He spent a lot of time out of the house, with other his friends that he met and other people he was dating and whatnot. And then I would, basically stay home most of the time because I'd work and be tired and that kind of thing. When we did spend time together, it was usually we'd play like video games together, like World of Warcraft or League of Legends or something. But outside of that, we didn't really do much together.
Okay. So you stated that he would spend a lot of time hanging out with his friends and other people that he was dating.
Yeah.
Are you referring to dating as in romantic relationships?
Generally, yeah. I mean, he had a lot of different partners, and he had, he used a Grindr app a lot. So he'd go meet what he called friends on the Grindr app. I would call them boyfriends because, like they were in love with one another and that kind of thing. He would say it was friends, and I'll respect that. I can understand he has different views on things, but he'd go out and, hang out with, these sexual partners of his.
Okay. For the ones that may not be aware, may you briefly explain to the court and the jury what the Grindr app is?
So Grindr is an app for men that are interested in other men to hook up with. I consider it a hookup app for men to have sex with other men. He described that as him making friends with other people, but sex was just somehow included in that friendship. My personal view of the app, though, is it's a hookup app. It's so, you find sexual partners, and generally some people see it as a dating app. So sometimes it's dating, sometimes it's just hooking up and that kind of thing.
Did you and Mr. Terry ever have a discussion about being exclusive to one another during your marriage?
He had issues if I were to go to date anyone because he felt that since I was asexual and that I really didn't like dating people, that it was insulting to him that I would go and date anybody, which is kind of fair because I'm like aromantic or asexual, so I'm not interested in that. And then as far as he was concerned, he could go do whatever he wanted to do, and anything to the contrary in his mind was control. And to some extent, I would agree with him. I would tell him that that's fine. I mean, you can't tell someone what they can go do or who they have sex with.
Understood. How would you state, Mr. Piner, that you all divided household responsibilities during the marriage?
I don't know how we would divide those responsibilities because we never really had conversations about that. And if it was brought up, it would become an argument. Because he would want, if I wanted him to clean, he would want money for it. Or if I wanted him to do something, he would want to exchange that for money or something else like that. So it was either, I took care of it or I'd have to have a discussion with him that was generally not comfortable for me to have. So we really never officially divided this is that. I did most of the cooking when the kitchen was usable in the apartment. For the periods the kitchen wasn't usable, we would just get to-go food. And then, he'd clean up, cans and stuff, and I'd clean up cans and stuff as well. And then, he would do a lot of the dog walking because the dog had, he spent a lot of the time at home. He didn't have a job or anything. So he spent a lot laying on the floor holding on to the dog. And so the dog naturally was just, fine with him being walked by him. So he'd walk the dog a lot. I was also at work or working, so I didn't have a lot of time to do that.
When you say the kitchen was usable or not usable, what happened with the kitchen to make it not usable?
So there was a lot of hoarding going on in our home. And I would define hoarding as when the piles of stuff and clothes are yay high or higher. And so the kitchen oftentimes would get to a point where there was just to-go boxes and trash bags everywhere. And then at that point, you don't want to cook in something like that, right? And I'm a bigger dude too. So unlike him, I can't scoot around all of this small walkway to go and do stuff like that. You know what I mean? So when the kitchen was just inaccessible, there was just no way to cook. And the only way to get food would be to eat out.
So it wasn't that things were broken in the kitchen. It was that, I think you just used the word inaccessible. That meant we can't use the kitchen. I can't get in there. You want me to do the cooking unless you're going to airdrop me in there. I can't use it.
Right. Yes, sir. And
Okay.
then, the stove's got stuff piled on it. You physically can't use the stove without clearing it off.
Or setting the house on fire.
Yes.
Right. Okay.
So is it your testimony, Mr. Piner, that the opposing party basically did not help you clean unless you paid him some incentive for it?
Right. And even then, oftentimes he still wouldn't clean. And I don't want to fuss on that subject too long, but yeah, it was more of like I need to be incentivized to go clean, or he also would make an argument that he needed Adderall to go clean, and I need to go help him get a prescription for Adderall, and then I'm not a doctor, so I can't help with that, but that was what he would share with me.
I would like to show the court and the jury what we have, what is going to be marked as Petitioner's Exhibit 2. It's a compilation of photographs of the home. I have shared a physical copy with counsel before placing it on the screen if there are any objections.
Okay, so we're talking petitioners 2. That's the exhibit number. Mr. Polanco, you've got a copy of it. Any objection to petitioners 2?
No, but what was petitioners 1?
There isn't yet.
It's not a
So
one.
we're starting with 2. There may be a 1, there may not. There's no requirement, but so I will admit petitioners 2. Now that it's admitted, you're free to publish it.
Okay. Mr. Piner, I'm going to place images on the screen via Zoom, also for you all, the jury, to get an idea of what we're talking about. And I'm going to scroll through the photos, and I'd like you to just kind of narrate to the jury what it is that they're seeing on the screen, okay?
Yes, ma'am.
So they'd go out to eat, and they'd then leave the trash from their takeout just around the house instead of just throwing it away when they're done. Because I'm not seeing like last night's lasagna pan in the sink still. Piles of bags of garbage. Could you not be bothered to just carry it outside? Put it in the bin? Okay.
Okay, can everyone, yeah, I see y'all can see it. Mr. Piner, I'm going to scroll through, but I want you to kind of narrate to the jury what it is that they're seeing as I go down, okay?
All right. Do I start with this one?
Yeah, go ahead. I'm just going to keep going.
Okay, so after the temporary protective order was served, the apartment had failed a fire inspection, which if you fail a fire inspection, that's leading to eviction, right? So we had to get some of the stuff out of the apartment. And so that's a 10 by 10 storage unit full of Mr. Terry's stuff. It's a bunch of stuff he bought at Goodwill, or he got these lots on Mercari, or any of these shopping apps and eBay. So we stuffed it full. It's very full of the stuff that we were able to pull and extract from the apartment.
Now, what about the
Can you hit the little arrow that's a circle that should rotate things over in the lower right-hand corner?
There we go.
There we go. Okay. Thanks.
So this is after we went in and we hired the biohazard cleaners to clean everything out of the apartment. Plus me and some friends had to come through and clean stuff out. So we cleared the whole apartment out to move out so that we wouldn't get stuck with like an unpayable bill, because they charge like $25 or $50 a bag of trash. So we went through the apartment. You can see all the stains are basically where the walk-in paths were, but that was like the closets. That was some of the stains that were on the floor. So he would often pour trash on me. And so that specific spot right there is stained from like the wet stuff that would come down from whenever he'd pour trash on me.
That looks
was
like
the
where
secondary
your computer
bathroom.
desk was.
That was the bathtub in the secondary bathroom. This bathtub really wasn't usable. It was a little bit too nasty. That was the living room. That was the main bathroom. So that was the bathroom me and him both took showers in.
Yeah,
that was the second bedroom. That was the second bedroom.
That stained area on the floor is
that
the
was the
computer
utility
desk.
room. So I cleared everything out of the utility room. I got
Where he played
everything out of
games.
it. This washing machine. That was the kitchen and the stove. That's more of the living room. So if you could stop at that photo up there real quick. If you look down here, you can see a literal path where the stuff was sitting. And those dark marks is where like you could walk, right? So that's where the dog and me and him would walk through. But those lighter areas is where stuff was at.
So these photos basically are the compilation of after you've cleared it out without the help of the opposing party, correct?
I did all that myself with Jamie and then someone named Matt or Joseph Foley. He flew in from Chicago to help some.
They had to recruit help from Chicago. Oh, man.
Okay, I'd like to now introduce what is, we're going to call Petitioner's Exhibit 3 moving forward, which is going to be the biohazard photos. I've provided a copy to council.
Oh, right before lunch. Let's do this.
No objection.
Which number?
P3, Judge.
3. Okay, it's admitted.
The fact that the worst place in the whole apartment on the floor was the place where
I'm going to share my screen again, Mr. Piner.
Where he sat for hours on end.
Okay. I'm going to show you a compilation of photos just like the last, but can you start with this one?
Yeah, that's from him slamming the door really, really hard against the wall and the doorknob going through the door, the wall itself. This was a bookcase. That was the kitchen. This is an example of the kitchen being not really usable very much because there's just so much trash everywhere.
There's the bong.
This was taken around when the TPO was served. And
can you signify to the court the month and year that this was?
July of 2025.
Okay, let's keep going.
So there's the stove, and then you can't get to the refrigerator because there's all those boxes and stuff everywhere. There were a lot of Starbucks cups everywhere. There was a lot of Starbucks cups in that house. That's where he was residing most of the day. He would go and dance in the kitchen. So that's his bong, along with more of his Starbucks cups in the general area which he normally hung out in.
He would dance in the kitchen.
That was the living room. That was the sofa. That's his stuff, mostly all on top of the sofa. It was just a bunch of clothes, shirts, pants, anything that wasn't soaked in urine or stained or had a really strong scent of urine was what we were able to transport to that storage unit.
Now, why would anything be soaked in urine?
Well, one was the dog. It would urinate on things. And then 2, I would make allegations that he also urinated on things as well. Okay. That was the living room itself, and that was just the sofa. That was where he would packages would come in, or he'd go to Goodwill or whatever, and he'd buy something, and then he'd put it in this pile. Now, we had a storage unit back then, it was a much smaller one. If I took anything from the pile and moved it to storage, the pile would just get bigger somehow. So generally speaking, I'd leave that pile alone. This is a door. So one day he got into an argument with me and he ripped that door off of its handles. Now, doors are not actually in these apartment buildings full wooden doors. So they're actually made of and I got to see it firsthand when he ripped it off the wall and it fell apart. But they're a thin sheet of wood, and some wood boards between it. After he had ripped this door off, we got kind of worried about getting evicted from it. So he got some wood glue and we got some clamps and put the door back together.
Is this the hole in the wall that we previously showed to the jury?
Yeah, I believe so. Well, actually, is that the one behind the bed where he threw something? Is that one looks like the one that was behind the bed where he had thrown something one day and it put a hole in the wall?
Okay. So there were multiple holes in the walls?
There were a lot of holes in the wall. I plastered over them, though. That was just more of the kitchen, the countertop.
Some moldy buns.
And that's the kitchen. That's his bong, along with his soda cans, plates and stuff. Never got to really use that toaster oven because it's inaccessible to me. But yeah, that's mostly where he hung out at. After the apartment failed that fire inspection, we had to get the apartment manager was very clear. We had to have a walking path that was big enough for a person to walk through all the major areas of the home. So me,
it's called a fire exit.
Jamie, and eventually Joseph Foley, who flew in from Chicago, work to put things in contractor bags to go put them up in the outside storage unit so we could get that walking path clear to buy some more time before they'd evict us. So this is as I was making progress on cleaning it out. So this is after, I want to say about a month of cleaning. We were able to get all of the stuff, started bagging it up and everything. The funny thing about this photo is that this wasn't even the start. You would think this looks nice, but there's so much more trash. That's when the biohazard people came and to move the sofas and the furniture and a bunch of other stuff that like you didn't want to kind of touch. Underneath that sofa, there was a lot more trash, but this is just making progress. So this is us getting a pile of stuff off the sofa. You can start seeing the sofa again. You can start seeing his computer area again. We were able to kind of get through and over there. This is the back bedroom, the second bedroom. So this isn't the one we slept in. Well, he actually slept in this bedroom, but he slept in the floor for some reason, which it's another discussion for another day. That's the closet with his stuff. That's the bed. And you can see the urine stains on the bed and then, just trash and
You didn't
and
sleep
stuff.
on the bed, sir.
A lot of the possessions or items in the house were from his mother who had passed. So he had moved a bunch of that stuff in there as well. A lot of that got stored beside the bed. So that's the dog's bed right there. It's inside of that little container house thing. And then just more of his stuff and then those containers that he had his stuff in. Oh, yeah, that's the bed. I slept in that bed. Oh, Jesus Christ almighty. That's the back bedroom.
Fireball whiskey.
That's my computer chair. And then when we had it a little bit cleaner during the pandemic, the place it wasn't 100% always like this. It would ebb and flow. So it'd get really messed up and then it would get cleaned out and it'd get really messed up. But if you go back to that other photo, you'll see these like display racks in the back. He got those from Steinmart during the pandemic. And so he hung his stuff up there, but then over time, more stuff would come in the house and you couldn't even get back there to that kind of stuff. That was the bathroom and the second bathroom. That was the master bedroom closet with his stuff in it. There's Sozo.
Is this a dog in question?
Yes, ma'am. This is the dog in question. That's him sitting on the sofa after we cleaned it out a bit. I took this with the Ring camera. It has
Let me flip it, Judge.
Yeah, it has the date on it. But that was on 8/15, and that's about how much progress we had. Now, I do want to say that me personally and many other people had told me it smelled of urine. A lot of people use the word ammonia. I'm not a chemist, so I can't stand behind the word ammonia, but it smelled of urine. So we had to keep candles lit anytime someone came over to help clean because it just was getting really bad. I eventually had to get a respirator to go in there and work because, I'd start coughing or it was really hard to breathe while in that apartment.
Mr. Piner, how much did it cost to clean all of that up?
So I paid the biohazard company. I had to call a lot of them because it was freaking me out because they were giving me some crazy prices. I believe one of the quotes were approximately like $5,800 for them to come in and help clean. But I found a place that was willing to work with me for $1,600 to do a limited scope amount of cleaning. So mostly the sold things, the things that had to go and be bagged up and took into the biohazard place and all that. They came and they were charged me $1,600, but then I had to pay for contractor bags. I had to pay for disposal of things. I had to pay to move his stuff around. I can't give you an approximate number for that, but it was I would say at least $1,500 to $2,000 in additional costs just in the respirator and the bags and transport and renting because you can't just take bags and I bought about 300 contractor bags. You can't just take them to your apartment's trash receptacle and throw them in there. You got to take them to the dump. So there's a lot of just transport and moving stuff.
Did the opposing party help in any way with the cleaning or the cost associated with that?
No.
Okay. And while you were at work during the day, you stated that he was with his friends. Do you know of him doing anything else during the day?
So the most common activities I knew that he would do was either lay in the back bedroom in the floor on top of a bunch of squishmallows, those like really fluffy, like squishy things, or on top of a blanket, and he'd lay there with the dog for a while. If he wasn't doing that, he was dancing in the kitchen, listening to music. Generally, like, after smoking weed or whatever he did. Or he'd be on his computer playing video games. And that's the kind of things he was doing while he was at home. And then whenever he left the home, he was either going to church or he was going and hanging out with one of his friends from Grindr.
Okay. Did the opposing party
Church
ever
or
express
Grindr?
any interest in getting a job?
He would talk constantly about getting a job because that was always one of the things that me and him would have arguments and discussions about. Because it was a very sensitive topic with him. Because he would say that he'd want a job, but he would say that I had to get him the job in order for him to get a job, and that I helped my other friends get jobs, which I'm still not sure about what that meant. But that's what he would share with me, and I would try to explain to him that to get a job, you have to go apply for a job, which requires filling out an application. But then he would tell me that I'd have to fill out the application for him to get a job. Now, he did sometimes do stuff like door dashing. Sometimes he'd come home with money. I don't know where he'd get any money from, but he'd come home with cash. He, aspirationally talked about it. He converted to a Christian after his mother passed. He kind of redefined our relationship, because, as Christians, you really can't have a same-sex relationship. So it was kind of difficult to navigate the religious aspects of everything at that point. But a lot of it was like his church wanted him to get a job. So they would constantly be pressuring him to sort of like do stuff. He would meet with his church pastor a lot, Tyler or Taylor, and they would try to work on getting him a job. But in general, it was always an aspirational thing about him working and sort of like a hopeful thing. Like, if you do this, I will go get a job. If you do this, I'll get a job. Or I need this to get a job. Like, I need Adderall to get a job. Or I need a certain amount of money to get a job. Or you need to move to another apartment to get a job. Or you need to make more money and I'll get a job. Which were a lot of the conflicts and arguments that we had. But in general, I would say that in my opinion, my aspirations for him was financial independence, because the way we were living was not reasonable for any adult to agree to. And financial independence changes a relationship from, well, if you don't take care of me, I want to just go out and be homeless or whatever. And by the way, you're never going to let it get away from me or whatever. It changes it from that to, we choose to live in the same house together, and we both have the financial independence to make this decision to say, we want to live here together. And for him, it was sort of like difficult to get that sort of understanding. It's very difficult to explain.
I think
So,
South
Mr.
Park had an
Piner,
episode with a guy like this in
do
it.
you and the opposing party, have you ever had joint bank accounts?
We did have joint bank accounts, but I never put my paycheck in it. The first one was made when we lived in Statesboro, because his grandmother and his family also wanted him to get a job.
Just what year was it?
I want to say about, I can't give a really strong date on when that bank account was open, but I'd say around 2012 or 2013.
Did you deposit money into that account?
Not regularly, no.
Okay. At this current juncture, do you all have any joint accounts?
We have two joint accounts. One's at Bank of America and the other one's at Truist, but they've never really had any money in them. It just sort of existed.
So are both of them pretty much minimal funds? They don't have a balance in it, correct?
No, they don't have a balance.
Okay. He never paid any bills at the apartment in Alpharetta, correct?
When he had Social Security, he would pay into the bills. He'd pay like about $500, $600 a month towards things. Of course, that would come back out over time. I'd have to give him money to support him. But when he had disability, he would pay into things. But in general, he wouldn't. After he lost his disability, I think it was in 22 or 23, he wasn't contributing anything to the bills.
Okay. Are you aware of any debts that he has incurred while you all have been married?
Oh Lord, this gets into something crazy. So I know he had a Macy's card, and then he did a lot of buy now, pay later things. So this would be like, I need $20 or I need $30, and that's all this thing's gonna cost, and I'm not gonna buy anything else. You just gotta give me $20. Just give me $20. But it was actually a pay in four for $20, which meant you had to make 4 payments of $20. So it was actually like an $80 thing. I know he had Sezzle, Afterpay, Zip Pay. I don't think he had Affirm, but I know that he had definitely Afterpay, Sezzle, and all of those different kind of apps. Any of the different buy now, pay later apps, he had a lot of those.
All right. Does any of that have your name tied to it in any way?
He opened one in my name. I think it was I think he opened an Afterpay in my name.
Okay. Do you know what the current status of that is?
No, they haven't really come after me, so I don't really know.
Okay. Did he ask you before opening the Afterpay in your name?
No.
How did you find out about it?
He told me.
Now let's talk about the debts that you have. What debts would you say that you have currently?
I have a lot of debt because I've been sued a lot lately for it. I had a couple of lawsuits in the last year where
for what?
The debts occurred. So there's
Meaning creditors are coming after you, not that you were sued by someone for being in a car accident and you owe them $1 million.
No, it was actually it was installment loans. So I did debt consolidation loans to pay the credit cards off. But then that's a really bad idea because then the credit cards get maxed back out again.
Why?
And then if you take out another debt consolidation loan, the credit cards get maxed out again. So now you have these installment loans for, several $1,000s plus the original credit cards that are also now maxed out. So I have a lot of consumer debt and a lot of installment loan type debt from like Upstart and these like installment loan companies. And in the past year, those installment loan companies have begun suing me, and I've had to pay a lawyer to defend myself against it to avoid garnishment because I do work in financial services, and my credit is one of the key things that I need to keep in some kind of good quality to keep my job. It's not been doing well lately because there's just been so much debt. But, essentially my aspirations is after this divorce, I'll have enough income to start working on paying a lot of these balances down.
Okay.
Are the debts you just described, Upstart and these other things, are those debts that you accrued because you also buy things, or are you attributing those debts to Mr. Terry?
I would say about 20 to 25% of the debt may come from my own purchases or just bill payments or payments for the home. The rest of it would have been consumer items like clothing, the Apple Pays, Affirm, Buy It Now stuff, or him purchasing stuff off of Mercari. A lot of it's that stuff that's in that storage unit or the stuff he took with him when the temporary protective order was served.
All right.
But somehow that debt is...
Judge. We're going to pause right there. Y'all got the picture you needed of that one? I cannot believe it works in financial services. It's like my credit is that's my good name. That's why people listen to me for financial advice. So I have to keep my credit score good, but I buy all these things on installment payment plans and everything else. Judge Clark, hopefully that served everybody. Here's the problem. It gets pretty gross and pretty nasty in areas that we don't normally go. So we're not going to follow that all the way through there. Possibly we're going to look at the closings, but let's jump to Judge Clark, where they're about
February
to do
2nd, 2025.
Openings in the case.
Members of the Bay County Sheriff's Office Special Investigations Division, the Narcotics Unit, were doing their job, keeping controlled substances and drugs off the streets of our community, when they came across this defendant, Christina Heath, who was trafficking methamphetamine, who brought almost 1,000 grams of methamphetamine from the state of Georgia down to our community.
Trying to have court. Don't raise your voice.
You're going to hear from Investigator Thomas LaRoche. He's one of those investigators with the Bay County Sheriff's Office today. And he's going to tell you that In February of 2025, Ms. Heath was traveling down Highway 79 and got pulled over for speeding. During the course of this traffic stop, K9 ran around the vehicle, alerted to the presence of narcotics, and the vehicle was ultimately searched. You're going to hear from Investigator LaRoche that he spoke with Ms. Heath, and she told him exactly where in the car he would find the drugs. And you're actually going to see part of that because Investigator LaRoche is running the body camera and opening it up, and you'll see what was found. You're going to hear that what was found in Ms. Heath's vehicle was sent to the Florida Department of Law Enforcement for testing. And you're going to hear from an analyst today, Rebecca Chandler, who's going to tell you that the substance that was found in Ms. Heath's vehicle was in fact methamphetamine, and that she weighed it, and it weighed over 900 grams.
That's a lot.
We talked a little bit Monday during jury selection about what trafficking is. You're going to hear that I have to prove that this defendant either possessed or brought into the state of Florida more than 14 grams of methamphetamine. We talked a little bit about the different levels, and that the highest level of trafficking methamphetamine starts at the 200-gram level. And you're going to hear that this defendant, Ms. Heath, had almost 5 times that amount. Ladies and gentlemen, this should be a relatively short trial. It's not a very complex trial. You're going to hear from those 2 witnesses today. And I expect that after you hear from those 2 witnesses, there will be no doubt that this defendant brought that large quantity of methamphetamine to this community, to our county. And I ask you to find the defendant. At that time, I'll come back before you and ask you to find the defendant guilty of trafficking methamphetamine. Thank you.
I'm going to defer opening to the beginning of the defense case in chief.
Defense defers.
Oh, you may call your first witness.
It's Thomas Stickles, Thomas LaRoche.
This is live, by the way. We're in with Judge Clark in the 14th Circuit down in Florida for this case.
Yes.
A kilo of meth, give or take. This will be a quick trial.
Raise your right hand. Madam Clerk.
Do you solemnly swear or affirm that you have to keep this whole truth, nothing but the truth, so help you God?
I do.
I'm sure you have a seat to speak into that microphone. And Mr. Sullivan, you may inquire whenever you're ready, sir.
Thank you. Good morning, sir.
Good morning.
Can you please introduce yourself to the jury?
Yes, my name is Investigator Thomas LaRoche.
Investigator LaRoche, where are you employed?
I work at the Bay County Sheriff's Office.
How long have you been with the Bay County Sheriff's Office?
Since 2019.
And what do you do as an investigator with the Sheriff's Office?
I work in the Special Investigations Division.
What is the Special Investigations Division?
Narcotics Unit.
Have you worked in the narcotics unit the entire time you've been with Bay County?
No.
Well, how long have you been specifically working in narcotics?
Since 2023.
I want to take you to February of 2025. You're obviously working in narcotics at that time?
I was.
Generally, what do you do as a narcotics investigator?
We investigate all sorts of narcotics, trafficking to possession cases.
Did you have occasion to be involved in a traffic stop on February 2nd, 2025?
I was.
Where was that traffic stop located at?
We stopped the vehicle around School Avenue and Highway 79 near West Bay Elementary.
What was the purpose of the traffic stop?
Initially, it was for her speed.
When you say her, who was the individual that was stopped during this traffic stop?
Miss Heath.
Was she the only individual in the vehicle?
She was.
You see Miss Heath in the courtroom today?
I do.
Can you please identify her?
She's the lady right here in the blue and white dress.
So this traffic stop is conducted, and what do you do? What's your involvement?
I observed the initial traffic, the probable cause for the traffic stop, the speeding itself, and then I arrived shortly after. Deputy Mullah Turk, conducted the traffic stop.
Deputy Mullah Turk's the one who actually pulled her over?
Correct. He was in a marked vehicle.
You were not?
I was not.
So after Ms. Heath's pulled over by Deputy Mullah Turk, how long did it take you to arrive on the scene?
Within maybe a minute or two.
Were you the only Special Investigations Division narcotics investigator to show up?
I was not.
Who else showed up?
Investigator Cummings, our canine handler, Sergeant Head, and Investigator Pettyjohn.
When you arrived on scene, what did you do?
I initially made contact with Miss Heath, asking for her driver's license and initial vehicle documents.
Was she ultimately removed from the vehicle?
She was.
What was the purpose of removing her from the vehicle?
Investigator Cummings had deployed his canine to deploy or do an open air sniff around the vehicle and told me that she positively alerted to the odor of narcotics emitting from the vehicle.
Based off of the canine's alert, what happened?
We did a probable cause search of the vehicle.
During the search, did you speak to Miss Heath at all?
Investigator Pettyjohn did.
Did you make contact with her at all?
I did after the initial search.
Now, are you issued a body camera as part of your duties?
I am.
Were you wearing it that night?
I was.
Was it on for a portion of this search?
It was.
You may approach. Training, it's been marked for identification as 6 Exhibit 1. Is that a disc with your clip from your body camera on it?
It's a disc, and I would assume that my body cam is on it.
Have you reviewed your body camera prior to coming to court today?
I did probably a month ago.
Your body camera captures your interactions with Miss Heath that night?
Yes.
It's time to say that you were 6 Exhibit 1 and evidence.
Any objection?
There you are.
State's Exhibit 1 will be accepted into evidence. You may publish whenever you're ready.
The screens.
All right, I'm going to hide so you guys can see what's on the video.
When you first began searching the vehicle, kind of walk the jury through, I guess, how was a vehicle search conducted? What do you do?
I usually do my searches pretty much the same every time. I usually start at the driver's side, and I work my way around clockwise.
And when you did that in this particular case, did you find anything immediately?
I believe there was some things within arm's reach of Miss Heath.
Ultimately, you found a large quantity of controlled substances.
That's correct.
Did you find that upon your first look in the vehicle?
No, I did not at first. Investigator Pettyjohn advised me that he had spoke with Miss Heath and she had informed him that it was in the back seat.
I could have one moment, Your Honor. Yes.
Struggling with the HDMI cable. The attorney's on his knees now. He's either praying to the IT gods or plugging it in again. LG. We may not hear this.
After initially searching the vehicle, is that when you went over to Miss Heath yourself?
Yes, sir.
More than a key in the car? I'm gonna let you know something right now. I've been investigating you. I understand. I've been investigating you for a while. I know you've been coming down here from Atlanta. You were in Collier or whatever it was called last night. You've been up there for about 3 days, just south of Atlanta. Just where you live. Okay, so I know what you're doing.
I admit it is.
So where's it gonna be?
It's in a box right there in a gift bag.
In a gift bag? In the front of the bag?
It's in the bag.
Okay, the bag?
I said like in the middle.
Like where
Would you
people
mind
sit in the
if I
bag?
send it to you, sir?
No, that's fine. I don't want you to grab nothing. Give me 1 second, okay? You can grab a camera real quick.
Wow. Cop says, I know what you've been doing. Your employer has you doing this up in Atlanta, driving down to just tell me where it is. So was she like a regular drug runner?
First to grab a camera.
But ultimately, you went back to
Correct.
take a search of her vehicle. Her vehicle had a lot of items, a lot of things in it, right?
Correct.
It was pretty full.
I would say so.
May I approach, Your Honor?
You may approach.
Showing you what's been marked for identification in states 2A through 2I. We could just flip through those real quick.
She put the traffic in trafficking.
Do those photographs represent what you found in this state's vehicle?
Yes.
I'm saying with states 2A through 2I in the evidence.
A through I. Any objection?
No, Your Honor.
Case Exhibit A, was it 2A through I?
Correct, Your Honor.
Exhibit 2A through I will be accepted evidence. You may publish whenever you're ready.
All right, let's see them.
Let's give the roach. What we're looking at here is states Exhibit 2A.
It's kind of blurry, but that white bag with the pink and blue on it, it's like a I don't want to say birthday, but like a present type bag that you would get from like Target or Walmart to put a gift into.
Target.
Now this green foliage in the upper right-hand corner.
We have foliage.
She had like a little tree in the back of Steve as well.
Yeah, some sort of plant.
It's a bush. It's definitely not a shrubbery. Happy birthday.
It is.
As you take it out of the vehicle.
Correct.
Was that box inside of the gift bag?
Yes.
Did you ultimately open it up?
I did.
Is that what you're doing here in 2D?
Yes.
2E, is that how the box appeared as you first opened it up?
Yes.
Did you remove what's inside of the box?
Yes, we did.
Is that essentially what you're doing here?
Yes.
I want to focus on two things. You've got a black bag in your hands, but then there's still something in the box.
Yes.
What does that appear to you to be in the box?
It appears to be methamphetamine.
Was that bag that's still in the box in this photograph, was that collected?
The one at the bottom of the box?
Yes.
Yes.
Approach, Your Honor.
You may approach.
Marked for identification, it says 3A.
Okay.
Is this essentially what was in that box in this photograph?
It is.
Okay. In this particular exhibit, the items in the Ziploc bag that's depicted in that photograph are both in this exhibit.
That's correct.
That's time Sarah moves into evidence states Exhibit 3A.
Any objection?
No, Your Honor.
Case Exhibit 3A will be accepted evidence. You may publish whenever you're ready.
Now that 3A, after it was collected, was that ultimately sent to the Florida Department of Law Enforcement for testing?
It was.
Now, you said you've been a narcotics investigator for several years. Have you had occasion to come across various controlled substances?
Yes.
How often do you say that you deal with controlled substances?
Probably at least 3 or 4 times a week, if not more.
Specifically methamphetamine, is that a substance you're familiar with?
Very much so.
How many times in your career as a narcotics investigator would you say you've come across and dealt with methamphetamine?
Hundreds, if not thousands.
Do you feel that based on your training experience that you are able to identify methamphetamine when you see it?
Yes.
Now, going back to these photographs in 2G, so in 2F, you've got this black package in your hand. In 2G, is that where you begin to kind of unravel that black package?
It is.
And 2H, is that what's found inside of that black packaging?
Yes, those 2 packages, yeah.
Okay. Well, so I want to focus on 2 things here. On the left-hand side, you've got the bag with the kind of the pink Ziploc top.
Yes.
Is that what's been admitted in evidence as 3A that was found in the bottom of the box?
I believe so.
Okay. And in your right hand, you've got, it looks like the package that's got a blue and a green Ziploc bag.
That's correct.
Is that what was found in the black package?
Yes.
Okay. Now, the package that's in your right hand with the blue and the green, is that what is depicted here in 2I?
That's correct.
The 2 separate bags.
Yes, they were both in the wrapper that they're sitting on top of.
Now, when you find items like this, you didn't separate them, did you?
I just took them out of that package.
So I guess that was a poorly asked question. When you found them, they were in 2 separate baggies like they're depicted in this photo.
Correct.
And when you collect them and put them into evidence, which you did in this case.
Yes.
Okay. You keep them separate, do you not?
That's correct.
An armed approach? Approach. I'm showing you it's been marked for identification states 3B and 3C. Are those the 2 baggies that are depicted in that photo?
That's correct.
At this time, the state removed 3B and 3C in evidence.
Any objection?
No, Your Honor.
You see, State Exhibit 3, B and C will be accepted in evidence. You may publish whenever you're ready.
Now, these 2 exhibits, were they sent off to the Florida Department of Law Enforcement for testing?
I believe so. I marked them to be.
Are you familiar with FDLE's rules on, what sometimes they test drugs, sometimes they don't?
I know it changes quite frequently.
Okay. In your experience as a narcotics investigator, have you sent drugs for testing and then FDLE will only test some of them?
Yes, absolutely.
Okay. Based on your training and experience, are you able to testify to what the substances are in all 3 of these bags?
I can tell you what I believe them to be, yes.
And what is that?
I believe them all 3 to be methamphetamine.
Now,
that's messed up.
You mentioned that. Well, let me back up. After collecting these substances, did Miss Heath have a cell phone on her when she was pulled over?
I believe it was in the vehicle, yeah.
Was that collected as part of your investigation?
It was.
Did you get a search warrant to search that cell phone?
I did.
After the search, was the search warrant granted?
It was.
And after you received that search warrant, did you conduct a search of Miss Heath's cell phone?
I did.
Were there messages that were located in Miss Heath's cell phone that you reviewed?
I did.
If you could look in the book of photographs, if you could look at State's Exhibit 4A and 4L. Investigator Lorch, do those photographs depict the messages that you found in Ms. Heath's cell phone?
Yes.
Now it's time to say we move States 4A through 4L in evidence.
Any objection?
No objection.
States 4A through L will be accepted in evidence. You may publish whenever you're ready.
Investigator LaRoche, I want to talk about some of the evidence a little bit in this case. You sent the suspected methamphetamine to Florida Department of Law Enforcement for testing. Did you request fingerprints or DNA on any of these items?
I did not.
Why not?
She admitted ownership over it on the side of the road.
You mentioned that you were not the only investigator that was involved in this.
That's correct.
I think you testified earlier that Sergeant Jeremy Head was present.
That's correct.
Did you see Sergeant Head present on scene?
I did.
Was he also wearing a body camera?
I believe so.
Did Sergeant Head speak with Miss Heath at all during this interaction?
I believe he did.
Her Johnny? Showing you it's been admitted into evidence as State's Exhibit 5. The body camera footage that, or the body camera that Sergeant Head was wearing, did that capture this interaction with Miss Heath?
I believe it did, yes.
It's time to say we move State's Exhibit 5 in evidence.
Any objection?
No, Your Honor.
State's Exhibit 5 will be accepted in evidence. You may publish whenever you're ready.
My name's Sergeant Head. I just want the. You do Miranda? Yeah. Okay. Super popular, very nice.
Just been trying to pay my bills.
What do you got in the car?
Yeah.
Do you have a camera? You guys got a break? Coke or meth? Meth. Okay. Where's it at?
I told him where it was at. It's in a gift box.
She was just trying to make her payments.
Is that essentially your involvement in this case?
Yes.
No further questions.
Yes.
Questions? Good
morning, Investigator LaRoche.
Good morning.
One of the things that you do after finding drugs in a vehicle search situation is weigh the drugs, correct?
That's correct.
All right. And the total weight of the drugs found inside the Amazon box that you showed us pictures of was 1,286 grams. Is that right?
Altogether, yeah.
Together. I just want to ask you to reconcile one thing for me. You did an incident report in this case, correct?
I believe so, yeah. Yes.
Okay. Your Honor, may I approach?
May approach.
1,200 grams. Is a brick a kilo?
That's your report, right?
I won't judge if you know.
Yes.
Okay. While I'm here, I want to ask you, you indicated a minute ago that the total package weight for the drugs found in the box was 1,286 grams, right?
If that's what I put in the report.
Well, that's what I want to ask about. So could you reconcile for me right here? You indicate item number 1, and then you indicate the quantity is 1,253, description 1,253 grams of methamphetamine. That's the same, we're talking about the same drugs, right?
That's correct. There's also another one down below, 0.3 here.
Mm-hmm. So is that the distinction between item number 1 here that's 1,253 and what you were talking about 1,286 before?
I'd have to read my investigative report again to see why I separated it that way.
Sure. Would it refresh your recollection if I let you look at the report?
Yes. I'm at the actual investigative report, not the incident.
All right, I approach the witness again.
You may approach.
For the record, is that your investigative report that you were referring to?
Yes.
Same question for that. That'll refresh your recollection, correct?
Yes. I'm assuming it must have been some sort of clerical error.
But just to be sure, make sure that we're talking about the same drugs. May I approach again, Your Honor?
May approach.
And I'm referring back to his incident report now, not the investigative report. This item right here that you listed as 1,253, item number 1,
Mm-hmm.
we're talking about the same drugs. These are the drugs in the Amazon box, right?
That's correct.
Okay. Now, you indicated you sent the drugs to be tested to FDLE in this case, right? The Florida Department of Law Enforcement?
I noted for them to be, that would be our evidence technicians that actually send it, but yes.
I got you. And it's important to do that because even though you do have training experience and that looks like methamphetamine, it's possible that it might not be, right?
That's a possibility, yes.
Is it true that sometimes drug dealers like cut other substances, non-narcotic substances with drugs to be able to sell more of it and like basically expand their profit margin?
We've seen drug dealers cut drugs before with other substances. I've also seen fake substances where it's not actually methamphetamine, but you can usually tell when it's a fake drug.
Sometimes not though, right?
When it's cut, yes, you usually can't tell if it's cut.
You can tell if it's cut. But
you cannot.
Cannot tell, okay, all right. And there are other substances, both illegal drugs and other substances that could look similar to methamphetamine and
like rat poison,
more or less, right?
I've had people try to sell me fake drugs, but I've usually spotted it.
Well, I guess I just make the point. You send the drugs to FDLE because they do chemistry testing. I just want to be sure, right?
Yes, sir.
Like it is possible that you could be wrong.
It is a possibility, yes, sir.
And besides just looking different, like some drugs may be chemically similar, but not chemically identical. Is that right? Like,
yes, sir.
If you guys use, for example, a field test kit, methamphetamine and MDMA are similar enough that it could make it pop for the same test as MDMA and meth, correct?
The tests for MDMA and methamphetamine are the same test kit.
They're not the same test kit?
No, they are the same test kit.
And that's because they're, while not the same drug, they're
very similar.
Chemically similar, right?
Yes, sir.
Okay. And so, bottom line, in order to be sure about the drug before you charge somebody, or I guess it's after, but before you bring the charges to the state attorney for prosecution, you send it to the Florida Department of Law Enforcement to make sure that it's what you think it is, correct?
Yeah, they confirm our field test.
So meth and Molly are the same?
You redirect.
Yeah, just quickly.
The 1,200 number that you have in your report, that includes all three of these packages.
The
correct?
baggies.
That's correct.
Okay, I've got no further question.
Anything else? Can the witness be excused?
I asked that he remain under subpoena, Your Honor.
Or you're still under subpoena, you can leave, you need to leave the courtroom, however, be available to call back to testify. Mr. Sullivan, you may call your next witness.
Rebecca Chandler. Approach, Your Honor.
You may approach.
Thank you for the 205 likes.
All right, please, man. We're gonna come up here, stand by the chair, and the clerk's gonna swear you in.
If you have a seat, speaking to that microphone, Mr. Sullivan, you may inquire whenever you're ready.
Thank you, Your Honor. Good morning, ma'am.
Good morning.
Please introduce yourself to the jury.
My name is Rebecca Chandler. First name Rebecca, last name Chandler.
Ms. Chandler, where are you employed?
I'm employed with the Florida Department of Law Enforcement in their forensics labs.
What do you do with the Florida Department of Law Enforcement?
I'm a crime laboratory analyst in the Seized Drugs Department.
How long have you been with the Seized Drugs Department of FTLE?
Over 3 years now.
And what type of education, training, background do you have that allows you to do your job?
I have a Bachelor's of Science degree in chemistry from the University of West Florida and a Master's of Science degree in chemistry from Florida State University, and I've completed a 13-month training program provided by the Florida Department of Law Enforcement.
And as a analyst in the seized drugs section, what do you generally do as part of your day-to-day job?
Day to day, I analyze items of evidence for the presence or absence of a controlled substance, and then write a report based off of my findings.
And with your time at FTLE, how many times would you estimate that you had occasion to analyze some item to determine whether it's a controlled substance or not?
Including my training, it's close to maybe just under about 10,000 times now.
Specifically, have you dealt with items to determine whether it's methamphetamine?
I have.
Can you estimate roughly how many times you've dealt with methamphetamine?
Probably half of the time.
As part of FTLE, do you undergo what's called proficiency testing?
I do.
First off, what is proficiency testing?
Proficiency testing is when a sample is provided to me. It is treated as a case sample. I analyze that item as I would any other, and then write a report and submit that report. And another report is generated on if I have completed it correctly or not.
And how often do you undergo proficiency testing?
Annually.
Have you ever testified as an expert in court before?
I have.
How many times?
Close to 25 times now, including depots.
FTLE, that's an accredited organization?
It is.
That means you have standards and procedures that you must follow?
That is correct.
All right, this time I'll attend to the witness for Wadi. No, Wadi. Ask that she be able to render an opinion.
Render her opinion.
She's an expert.
Ms. Chandler, were you submitted evidence in this particular case?
I was.
What were you submitted?
I was submitted a sealed clear plastic bag that contained 2 different clear plastic bags. One was heat sealed that contained a crystalline substance, and one contained a crystalline substance residue.
May I approach, Your Honor?
May I approach?
Stringer has been admitted in evidence in State's Exhibit 3A. I believe it's got FTLE item number 1 on it. You recognize that?
Yes.
Is that the item that was submitted to you to analyze?
It was.
Now, can you walk the jury through kind of your process and your analysis when you receive an item like this?
So prior to receiving an item, my supervisor will assign the case to me. I will then, when I'm ready to work the case, I will request that the item be transferred into my custody from our vault. It is brought up into our section from the vault by a forensic technologist in the section. She then transfers the evidence to me, and I will store it in my secure locker until I'm ready to work the item. Once I'm ready to work the item, I'll remove it from my locker. I will document the outer and the inner packaging, as well as the item and anything inside of the packaging. I will then obtain a weight of the item, followed by a chemical color test or 2 chemical color tests, and then 2 instrumental analyses.
What are those instrumental analyses?
Gas chromatography, mass spectrometry, and gas chromatography.
What is the purpose of doing the chemical color test and then the 2 instrumental analyses?
The chemical color test is a presumptive test. It can give me an indication of what the substance of interest may or may not be, and at what concentration, so I can gear my sampling for the instruments based off of that color test. That way I'm not overwhelming the instrument. And then I can then take a subsequent sample for the instruments using the appropriate solvents.
And what do those instrumental analyses ultimately tell you?
They tell me what the identity of the substance is.
And is that what you did in this particular case?
It is.
Were you able to determine the chemical analysis of what that substance that you received is?
I was able to make an identification, yes.
And what were you able to identify that substance as?
Methamphetamine.
Did you weigh the methamphetamine in this particular case?
I did.
How do you go about weighing the methamphetamine?
For items, I will put a piece of paper or a weighboat onto my balance, and I will hit what is called the tare or 0 button, and that makes sure that the balance reads 0 and subtracts that paper from what I'm about to weigh. I will then put the substance of interest into that weighboat or on that paper and place it onto the balance and record that weight.
Now, as we sit here today, the methamphetamine is in several plastic bags. Do you weigh the methamphetamine inside of those packaging, or do you weigh solely the methamphetamine itself?
I weigh solely the crystalline substance or substance itself, yes.
And in this particular case, were you able to determine the weight of the methamphetamine?
Yes.
And what was the weight of the methamphetamine?
984.69 plus or minus 0.21 grams.
Now, you mentioned that your supervisor assigns you the case.
That is correct.
Would it be the supervisor's job in determining what exhibits FDLE accepts from the agency?
Yes.
Are you familiar with FDLE's policy on testing multiple drug items? And sometimes, I guess let me ask you this way. Are there situations where you receive multiple drug items for potential analysis, but you only test some of them?
Yes.
And why is that?
There is a policy at FDLE to test substances to substantiate the highest charge per defendant per submission, or to work all trafficking cases.
And in this particular case, the highest charge for trafficking methamphetamine would be the 200 gram level?
It would be the 400 gram level for this one.
Okay. And that's okay. I understand what you're saying. In this particular case, that exhibit is more than 400 grams.
That is correct.
So may I approach, Your Honor?
May I approach?
So if the agency had also submitted these 2 smaller bags of methamphetamine for analysis, would that have been something that you would have analyzed as well, given you reached that 400 gram threshold already?
No.
Is it likely that your supervisors would not have even accepted those bags, given the weight of the other bag?
That is correct.
I've got no further question, Your Honor.
Brent?
Very clear.
Ma'am, when you receive drugs to be tested from a law enforcement agency, is one of the things that you receive in the submission packet from them and then an electronic packing slip that lists the different items of evidence to be tested potentially?
There is one generated in our evidence section that I would not see.
Okay. May I approach you? Sorry. May I approach the witness?
May I approach you?
You're not the one that said presentation. Is this document that I'm showing you the electronic packing slip for this case?
It's something similar, yes.
But this is the actual form for this actual case, correct?
Yes.
Okay. And I want to ask you about these 3 packages of suspected methamphetamine here. First, I'll ask you about the total package weight for those 3 items. What were the individual total package weights for those 3 exhibits?
Sorry, I just want to make sure.
Sure.
So to just read those 3 out.
Yes, ma'am.
For item 3, the one I analyzed, total package weight was 1,035.9 grams. For what was listed as item 4A, 134.2 grams. And for the item listed as 4B, 155.3 grams.
All right, and you indicated to Mr. Sullivan on direct that you yourself weigh the weight of the drugs without the packaging, correct?
That is correct.
And what was the weight of each of those 3 individual exhibits without packaging?
Item 4A and item 4B never was received into the lab, so I never weighed those or worked them.
Yes, ma'am.
But for item 3, it was 984.69 plus or minus 0.21 grams.
Yes, ma'am. Thank you. And just to be clear, the agency exhibit, meaning the exhibit number assigned to the item by the submitting law enforcement agency for the one you tested, was agency exhibit number 3, correct?
That is correct.
And then you didn't weigh or test agency exhibit numbers 4A or 4B, correct?
That is correct.
You didn't test those, correct?
I did not test 4A or 4B.
Thank you. No further questions.
You redirect. Yes, Your Honor. I want to talk specifically about the item that you did. So your testimony that it's 984 grams of methamphetamine.
Yes.
Mr. Prince asked you about the total package weight, and I believe you read off it was 1,035 grams.
That is correct.
Now, total package weight is different than what you test or what you weigh.
That is correct.
Total package weight includes all of the baggies that it's in as well.
That is correct.
And specifically regarding these numbers, you're not familiar with what scale this is, sorry.
No.
You don't know if that scale was accurate or not.
That is correct.
You don't know if that scale, had ever been aired like you mentioned.
That is correct.
And that's why you do your own weighing of the methamphetamine itself.
Yes.
Or for the book.
Anything else for this witness?
Okay.
Can she be excused?
Yes, sir.
Ma'am, you may go about your day. Mr. Sullivan, you may call your next witness.
Some state rest.
Ladies and gentlemen, we're going to take our morning
Hey,
break.
hey.
11 o'clock, we're going to take a 15-minute break and start back at 11:15. Leave your notepads in the courtroom. Do not discuss the case among yourselves or with anyone else. Don't check any media sources or use your electronic devices to find out any more about the case you know right now. See anybody you see in the courtroom, do your best to avoid them. I'm telling them to do the same thing if you'll follow the bailiff in the back. Thank you.
So we have reached the break point.
Take a short break.
That was perfect time, Red. That was perfect. Gonna take a sharp break. The jury walks out. Curious what the defense is going to do on this one. She literally got pulled over. They said, "We know what you're doing. Just tell us where it is." She says it's in the back.
Everyone can have a seat.
It's got a brick of meth.
Chris, do you have a motion?
Oh, yeah.
No judgment of acquittal motion.
We ready to go forward?
Aaron, I think I know what her answer to this question is going to have to be, but could we step out and talk to?
Absolutely. Deputy Dexter, you just make sure the jurors are cleared, and you can step out and.
I would discuss that when they're down the hall like you did.
This one?
Yes, sir.
Yes, sir.
This is the do you want to testify
Okay, right.
question.
We
Follow
call
the,
the record.
follow the white shoes, ma'am. Hubby or dad or somebody is there. She says, "Come with." She's out on bond. What was it? Northwest 125,000, 175,000, 126. 126,000. I think in Florida you can do 10% of that. So somebody's got 12.5K on the line. So she's not going anywhere. But when they come back, defense is going to be trying to figure out how to turn this pile of crap into a birthday cake and possibly skate out of here with something less than the offer, which was 15 years, right? What was the offer she got here? 15-year offer. Florida's pretty hard on traffickers, even they catch them, and they caught her. Blah, blah, blah. It was a bad situation. Had no choice. They made me. She claimed zero income. I guess she testifies and tells us a sob story. I don't know. When I hear those sob stories from somebody who's just committed a really bad crime, like trafficking meth, which kills a lot of people, you've got to be like, why, if all this is bad happening, you know, if you've got all this kids dependent on you or family, or you're the sole supporter for an ailing relative or something, why would you put that at risk by potentially committing this felony and putting yourself in jeopardy of losing your freedom? No, the offer was 12 years, but that was less than the minimum mandatory. Okay, we got that one earlier. So the minimum mandatory is 15. That's what she was going to take, the 12. That was funny. We actually saw the paper fly in front of the witness camera that the defense attorney just threw into the garbage. What part of Florida? This is up in the Panhandle area. So if there's a mandatory minimum of 15, that's what she's facing upon conviction. If they find her guilty, she needs to be found not guilty to get anything less than that. And that's the minimum. She claimed no minor children on paperwork. You think she just trying to come to court and look cute and hope they're nice to her? Seems a bit naive. Who in the world told her not to take the 12? She was going to take the 12, Bap. That's the funny thing. But that's why we're following this case. We watched that plea deal fall apart in real time, because she was going to take the 12 years, which prosecutors said we would go less than the minimum. The judge says, no, minimum means minimum. I can't accept that. It's going to be 15. Do you still want to plead? And she said, no, I'll take a jury trial. Jury can't go below the minimum either. So this is just stalling? Is that all they're hoping for? Just another day out? Before she goes away for 15. Okay, judge is back. He's texting, not Tindering. Right, the state would have to change the charges to get 12-year, but I mean, the way it's written, the laws state if you're caught with over a certain amount, it's trafficking, and they'd basically have to charge her with, you know, impeding traffic or double parking at this point to get it to go much lower based on what she had. In theory, the jury could convict on lower offense if lesser includeds are offered. Yeah, she was well over the threshold. 15 would be a break in Florida. Have to consider similar priors. That would go in sentencing. That's going to come up if she's got priors, and I don't know if she does. She's from Georgia, right? She's from out of town, driving it down for distribution. Judge McBurney's court was where the divorce trial was. They won't be started till about 1 o'clock. He's in Fulton County, Georgia. It's all over Florida. It's all over everywhere, unfortunately. It is prevalent, and it's found its way pretty much to every little corner of our society. Fran, I don't know if 15 means 15 in Florida. Depends on a lot of different factors, and her behavior might be one of them. 15 years would be 12, so she has to do like 75% of it or something with good behavior. So that would be put her right back in the deal position. But 12 years would have been what, 10? If she got sentenced to 12, which she can't. Years ago, ex-girlfriend's sister was busted at Washington State border with 100,000 ecstasy tabs. I'm guessing that was not treated lightly. Joe, yes, they're out discussing her options right now. Hopefully one of them is not, well, if you run now. No, just kidding. She's put up a bunch of bond, or somebody has put up a bunch of bond to keep her free until this moment, but this might be her last day of freedom. Let me go ahead and unpin this message. Earlier, after showing up late, the judge ordered she cannot leave the courthouse. Yeah, he knows where this is heading, or where it's likely heading. Red Pen has invited us over for lunch. We're smoking full brisket right now. Smells so good. Just tell us when and where, Red. We're just kidding. I know you didn't make enough for the whole class. Showing up late to court is definitely a decision. Yes, especially when it's a jury trial day. Make the jury wait. That's a bad idea. Needs a few more hours. Oh, it's supper. I misread the invite. I'm sorry. I saw the food and got hungry. Linda Marie, thank you very much for the gift. Appreciate the jewels. My husband just got a ticket in the mail for lane violation on our trip to Grand Junction last week. Oh, my goodness. Thank you, Flock. I'm not sure if it was Flock brand, but cameras everywhere. Y'all have time to get here? There we go. Just start heading to Northwest Idaho, or Iowa, excuse me, Red Pan. I just assigned you to the potato state. And dinner will be around 6:30 Central. So if you didn't have plans, and you can hop in the car. Oh, you are having potatoes as well. Are they Idaho potatoes? We're starting to see a lot of cases, flock cases. There's one that's going viral on Twitter right now where there's a man, I believe in West Virginia, that has been deflocking cameras, deflocking the town from flock cameras. And the funny part is this was posted that he was arrested because, you guessed it, it's caught on camera. And they arrest him, and then like 20,000 people have been replying to this message, this post of him being arrested for doing this. And they're all saying, no, it couldn't have been him. He was with me. And everyone's giving him an alibi. Like, no, we were on the moon that week. He was with me. I mean, we were fishing in the Bahamas. It's crazy. It's crazy. There's a great video out there. I have to look for it to see who I think it's it's like Digital Esquire. I think, don't quote me on that, but I think that's the YouTube channel. He's a lawyer, does YouTube videos. And he does a video about flock cameras, and it's snarky, and he definitely has an opinion where he's not in favor of them. But he breaks down the legality and the issues that are at play right now, not just the fact that generally people don't like them, but the issue of the whole mosaic picture that a flock camera paints, and that the courts, there have been Supreme Court decisions that determine that when you gather enough publicly available information about somebody and put it together, you can actually be encroaching on their rights. So it's an interesting video. I watched it yesterday. Several North Carolina PD have been fired and charged for misuse of flock cams. They'll sell it to anybody. I mean, you can buy one personally for your driveway if you want. I think this lawyer in the video did, just to do some research on it. But license plate is public view. Here's the thing. The information they're gathering that is supposedly controlled by the client. So if you have a flock camera, or your HOA puts up flock cameras all around your neighborhood, they can access all that information and determine what hours you're there, what you're not, based on what time your cameras were caught you on different areas of the community and the road patterns. They can determine if you were speeding, even if it was not on camera. It's a flock camera is generally a license plate reader, an LPR. It's a camera, but it does more than that. It also can identify cars based on unique features like dents or damage, or pulling a trailer with a bobcat, or something like that. It creates a database of all these videos, and if you have an entire flock network, which is often shared with police, because that's the whole prevent crime part, because the police can then scan and look for people who were bad actors or stolen vehicles and things like that, and they access all the private networks as well as the public networks and get all this information. It's quite intrusive, even though it's just public information. It's a lot of public information that, once assembled, paints a vivid picture, even to the stores you frequent, what days you shop, when you shop, who's in the car with you, because sometimes that's captured on cameras, who you're hanging out with. All this can be discerned by these cameras. I don't like I like you have to catch me first idea when it comes to tickets. If I speed my motorcycle down a nice windy road in the mountains, I don't want a robot giving me a ticket. AI enhanced? No, just high resolution. They're fantastic cameras. I mean, if you're looking for license plate readers that can read the license plate of a car that goes by at 100 miles an hour, a flock camera can do it. They're very good at what they do. High resolution cameras, and it just all talks to Big Brother if that option is selected, which most of them are. And then you have this massive mesh database that anyone in a law enforcement position has ability, even though there's rules about how they're supposed to use it, they have the ability to access and check it. It can be used for stalking. It could be used for a lot of things. And we've seen misuse already. There's a website you can use to look up your license plate and see if yours has been used. I bet everyone's on there. Flock camera found a family member who was lost while driving. Oh, it has good purposes. They're great for Amber Alerts. Oh my goodness. They'll find the car before anyone can call it in. They're fantastic that way. Amber Alerts, Silver Alerts, good stuff. They're also really good for finding, the BOLOs, the be on the lookout for vehicles if somebody's running from the law. You can find them real quick with this flock network. But they also collect all the other data. They don't just collect the information about bad people. Yes, if you have a private network, the HO, like if you're in an HOA situation, say your community or your city has these cameras, within the organization that owns the cameras or that has the contract with the cameras, you can access all the data in that organization. You have to be law enforcement to access information from other organizations that are shared with law enforcement. So there's 2 levels of data that way. Police have had license plate reader systems since the 1990s. Yeah, and I'm generally okay with that. Like the ones that sit on top of the cop cars and scan the ahead of them to the left, to the right, and they're just driving through and they'll be notified if they get a hit. I'm okay with that. It seems quite intrusive, but I'm okay. It's the ones that just scan everything, all traffic, any activities. Don't stream while doing illegal activities. I agree. We need a constitutional amendment for right to privacy.
Your Honor, after discussing it with Ms. Heath, she is indeed going to testify.
Okay.
I've explained to her that she doesn't have to testify necessarily, and that, again, if she didn't testify, that the court would instruct the jury, as it did previously, that they're not allowed to hold that against her. It is a matter of strategy that she needs to testify here because she had essentially abandoned voluntarily participating in the conspiracy, but was being threatened to continue doing so. That evidence is not in the record right now. I've explained to her that the only way to that affirmative defense is to testify, and so she wishes to testify.
All right, I'm going to ask her a few questions about that decision. Ma'am, if you'll raise your right hand.
That's an interesting.
Swear or affirm the testimony about this truth, the whole truth, and nothing but the truth, and nothing but
All right, ma'am, you can state your name, please.
Can we have her sit down in front of the mic?
Sure.
I'm sorry. Yes, sir.
State your name, please.
Christina Heath.
Ms. Heath, Mr. Prince has indicated that you made the decision to testify in this trial.
Yes, sir.
You understand that's your decision to make?
Yes, sir.
That it's perfectly advisable and to listen to your advice of counsel, but ultimately that decision to testify is yours. You want to remain silent. You understand that?
Yes.
You understand if you testify, if you answer Mr. Prince's questions, that you'll have to answer the cross-examination or have to be subject to cross-examination by Mr. Sullivan. You understand that?
Yes, sir.
You just can't stop after your testimony or your direct examination, yet that you'll have to answer the state's questions.
I'm sorry, can you repeat that one?
Yes, ma'am. Mr. Prince is going to call you as a witness. He's going to ask you questions.
Uh-huh.
Once he finishes those questions,
this
the
is a
state,
jury trial.
Through Mr. Sullivan, will have an opportunity to cross-examine you.
Yes,
sir. He's to ask you questions.
Yes, sir.
That you have to answer those questions if you make the decision to testify. You understand that?
Yes, sir.
You just can't stop it halfway.
Yes, sir.
Is anyone making you testify?
No, sir.
Are you doing this of your own free will? Are you under the influence of any drugs or alcohol today which would impact your ability to make this decision? Have you been diagnosed with a mental illness that would affect your decision to make, affect your ability to make this decision?
No, I haven't been diagnosed.
All right, you understand that up until the time Mr. Prince calls you as a witness, you can change your mind. That if you think about it and the jurors come in, and before Mr. Prince calls you as a witness, and you to change your mind, you can let him know, and he won't call you as a witness. Do you understand that?
Yes.
Mr. Sullivan, Mr. Prince, Mr. Milton, are y'all satisfied with those questions and answers?
Yes, sir.
All right, can we bring the jurors in?
Move the podium here.
Sure.
Is anyone forcing you to testify? No, as opposed to when I was carrying the drugs. Yeah.
I was moving it here just to remind you, because I know it's strange. I usually don't do it myself, but I am going to do the opening.
Okay, very good.
Isn't she going to be over on the witness stand on the other side? Shouldn't you face her a little bit? Bailiff's going to turn this podium. He's like, what? Why is it facing there for closings? Oh, defense opening. That's right. Thank you, Northwest. I'd forgotten he had reserved till the later half. Thank you, Drama Llama. So we will have the witness testify as soon as defense closings are done. Now, I don't think... I'm not sure if he can use the argument in his open that she was forced to do this. It has to be asserted first, right?
George, you may have a seat when you get to your chair. Else can have a seat. Let the record reflect all the jurors are back in their place. Mr. Prince, you may give your opening.
Thank you. Good morning, ladies and gentlemen. My name is Nate Prince, and I'm sorry I wasn't here with you for jury selection. I was picking another jury. Mr. Middleton and I were cooperating on cases a lot of times. But same as with the state's opening statement, this is an opportunity for me to tell you what I expect the defense evidence to be. Let me just acknowledge, like, this seems like a pretty clear-cut case, right? You stop the vehicle, only one in the vehicle, she's got drugs, she tells them before they even find out what it is, boom, 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 that should be it. But I expect that the judge will instruct you at the end of this case that in Florida, there are certain types of defenses that are called affirmative defenses. And one of those is that I expect the court will instruct you about is called the duress or necessity, all right? And Ms. Heath is going to take the stand. She's going to waive her right to remain silent and have you not consider that against her. And she's going to tell you how she got into this position and what was happening on the date that she was arrested here. So backing up, several years before this offense occurred, she had gone to Hawaii because her daughter and her son-in-law were having health problems related to a vaccine that they had received. They're both in the military, stationed out there in Hawaii, and were having all kinds of health problems. So she goes out there to help them. She's out there for a couple of years. While she's out there, shortly before she comes back, and came back because she had to get medical treatment, she was injured badly, helping them move something that was real heavy. She'll tell you about that in more detail. But bottom line, her health insurance wouldn't apply out there. So she had to come back to Florida after trying to pay bills and everything. She's in a tough financial position and ends up through a sequence of events making some bad decisions that got her in with some bad people. The way that went was basically her other daughter had a boyfriend that was in prison. Some business transaction, illicit or otherwise, don't know for sure. But some business transaction that he had with somebody on the outside of prison went in a way that person owed him money. And he asked her if she could pick up money for him and send a picture to show that he had received the money that he was due. So she did that. She sent money, she picked up the money, sent him the picture of the money, and he was supposed to be sending it to some other person who Ms. Heath didn't know that person or who they were or anything else. But for whatever reason, the daughter's boyfriend, who was incarcerated, couldn't forward the picture. So that guy provided contact information for Ms. Heath so that she could show that the money had been received and send that person the picture. Shortly after that, she starts getting contacted by that person. Now at that point, she doesn't know that this person has anything to do with a cartel or anything like that. She just knows that this person is now offering her, hey, that was nice of you to go pick up money. Would you like to make some money? And talking back and forth. Now, to be clear, she knows at that point and is being explicitly asked at that point to engage in illegal activity. Pick up drugs, run drugs for a fee. That's what this person is asking her to do.
That's trafficking.
Now, you're going to hear about communications that she has with this person. This person is not the one that she's afraid of. She's been communicating with this person sort of flirts with her. And while it does ultimately turn out that person is cartel affiliated, that person is never who she's afraid of. That person is never the one that threatens her. But she does this. She willingly, knowingly engages in a conspiracy and does deliver drugs for this person. At some point, she wants to be done. She's done this for a couple of months now. She wants to be done. She doesn't want to do it anymore. That's when she finds out that this person is cartel affiliated because she is not allowed to get out. At that point, cartel members start showing up. They take pictures of her kids working at her shop. They show up at her house in ski masks parked in the driveway. Her dad moves away, flees, arms himself, and goes to live someplace else because he's afraid. She's afraid for her kids. She gets calls and they tell her that they're going to kidnap her daughter and force her into human trafficking. So she is afraid. And so she agrees to do it. But at this point, it's not voluntary. Now, this isn't a situation where the gun is literally pointed at her head or that her daughter is in a trunk being, taken to Mexico as they speak. But she also wasn't obligated to do anything yet. The threat became real and imminent. She'll explain to you when they wanted her to go deliver the drugs for them, bring them back the money. That's when it became real. And so at some point, shortly before her arrest in this case, that's when she got the call. She had to get the drugs. She had to deliver the drugs. She did what she was asked to do, and she got caught. And she cooperated with law enforcement. She told them, like, everything that she told them is not on the side of the road right there. She goes and she tries to help them. And she'll tell you, like, she knew at that point, like, the reason that she couldn't go to law enforcement before is because she was being watched. They're following her, they're taking pictures of her kids, all of that. They know where she is while she's still an asset to them, while she can still deliver stuff for them. Once she's burned, they don't want anything to do with her. Why would they? Why would they work with somebody who's been arrested and ostensibly has reason to cooperate with law enforcement? So she'll tell you herself that's why she was comfortable talking to law enforcement afterwards when she'd been burned, but not trying to go to law enforcement beforehand when she knew she was being followed and knew at any point they could hurt her or her daughter or her father or anybody else. At the end of the trial,
have you guys seen this movie?
That the judge will instruct you on the necessity or duress defense, and there are elements that you will consider, and you'll have to make a decision about, under the circumstances, whether a reasonable doubt exists about that defense. I just ask that you remain open-minded, follow the court's instructions in evaluating the evidence, and make the decision that's compliant with the law in this case, which I would submit will be not guilty.
And now,
Your Honor, this time we'll call Ms. Heath.
She'll come forward and remain standing to be sworn.
Sorry, what did you say?
Yes, ma'am, just come up here and remain standing to be sworn in.
You're by the chair.
Yes, sir.
she has to give the performance of her life here.
Raise your right hand, please. You do solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
All right, ma'am, you can have a seat. You'll speak directly into the microphone. Mr. Prince, you may inquire whenever you're ready.
Thank you, Your Honor. Ms. Heath, can you please start by stating and spelling both your first and last name for the record?
My name's Christina Heath, and it's CHRISTINAHEATH.
I want to just kind of cut to the chase and walk the jury quickly through kind of what led up to you finding yourself in this situation. So about how long before you got arrested in this case, did you go to Hawaii to help your daughter and son-in-law?
It was probably about 2.5 years.
Okay.
Since I first went to Hawaii.
All right. And so how long were you there for? How long were you helping them out?
I was there for 2 years.
And at some point, did something happen over there to you?
Yes, sir. I was moving them and I got crushed by a dresser. No one was helping me.
Okay. And you don't have to go into details, but were you very seriously injured in a way that would require different types of
Yes.
medical care and treatment?
Yes, sir.
To include surgeries and things like that?
Yes, major abdominal surgery.
Okay. And were you able to get that treatment in Hawaii?
No, sir. My insurance wouldn't work over there. I had to come home.
And where was home?
To Georgia.
Okay. Roughly how long, you don't have to know exactly, but roughly how long was that you came home to receive treatment before your arrest in this case?
Maybe 8 months.
Okay.
9 months.
Now, at some point after you came home, you have another daughter, right? Not the one who was in Hawaii?
That's correct. I have another biological daughter, and then I have several adopted daughters. You know, the ones that grew up at my house.
All right. Now, your daughter who is over here, not the one in Hawaii, did she have a boyfriend who is incarcerated in prison?
Yes. That was my adopted daughter.
Okay. Your adopted daughter. Okay.
My adopted daughter.
At some point, were you asked to pick up money that was owed to him?
Yes, sir, I was.
Can you explain kind of how that went and why you, and like just what happened there that you found yourself picking up money for your daughter's boyfriend in prison?
Well, he trusted me to go get it, and he knew I would make sure that he got the money back, and he offered me a few dollars to go get it.
How long had you known him for?
A few years.
Okay. So it wasn't like you just met this guy or met him while he was in prison or anything like that?
No, I didn't know him real well, but I knew we passed, in passing. She didn't start really dating him on a regular basis until after she moved out of my house.
Okay. So regardless, you do agree to go pick up the money that was owed to him. Is that right?
That's correct.
You're gonna get paid for that?
That's correct.
All right.
How much?
How long would you say that was before your arrest in this case? Just again, roughly.
Maybe a couple months.
Okay. Now,
I'm not sure exactly how long it was.
yes, ma'am, I understand. So I guess tell me how that goes. Like you're supposed to go get money. Do you pick it up at some point?
I did. I went and met him at a certain location.
Was that up there in Georgia?
It was.
Okay. And you were supposed to send him, meaning the daughter's boyfriend who's in prison, a picture of the money to confirm you received it?
That's correct. I sent a picture to confirm the amount and everything.
Okay. And you were going to get paid for picking it up?
Yes, sir.
All right. Now, did you send him the picture like you were supposed to confirm receipt of the money?
I did.
And was he able to provide that picture to whoever it was he was supposed to provide that picture to?
No, he wasn't. Something about the signal in the prison.
Right.
Okay.
This is the story.
So what did he come up with as an alternative so that whoever he was trying to confirm receipt of the payment for would know that you had picked up the money for him?
He gave me a phone number and told me to send it to that number.
Did you do that?
I did.
At some point after that, did that person or somebody using that number start communicating with you further?
Yes.
And how did that go?
He just started talking to me at first, and he knew I needed to make some money after we were talking.
And so how did he propose you make some money?
And by hauling stuff for him.
Illegal drugs.
Mm-hmm.
And to be clear, at that point, nobody threatened you.
Nobody threatened me at that point. No, I was just trying to make money to pay my bills.
Yes, ma'am.
My health insurance.
And you did understand that it was illegal to do that, correct?
I did.
Okay. But you did it anyway.
I was desperate.
And so, how did that, just in terms of logistically, how did that go? How did you pick up drugs? How did you deliver drugs? How did you sell drugs or make money off the sale of the drugs? How did that go?
They would tell me where to go pick it up and tell me where to take it.
And how did they get paid from your sale of drugs?
How did they get paid for my sale?
Like, how did they make money off that? Did you have to pay them before you got the drugs, or did they front them to you and then you pay them once they were sold? How did that go?
Most of the time, I had to pay them.
Okay. So the first time you do it, when you're in a bad financial situation, that time, do they let you transport the drugs and get paid on the back end?
They did.
But after that, you have to front the money yourself. Is that what you're saying?
I would get the money from the customer and get it sometimes.
Okay. And so that goes on for, best guess, how long, where you're actually doing that for them voluntarily?
Maybe a month or so.
Okay. And you made a number of deliveries during that time and had customers that you could deliver to and all that?
That's correct.
Okay. At some point, once you'd made some money, did you decide you didn't want to do it anymore? Didn't want to deliver anymore?
Yes, sir. I didn't want to do it anymore. I was finally able to go back to work, and I didn't want to do it.
Okay. Did you tell the person that you had been communicating with that you didn't want to do that anymore?
I did.
Okay. Now, to be clear, at any point, was that the person you were afraid of? The
No,
person that you've
not
been
at all.
communicating with all along?
Not at all.
Okay. tell me about what ultimately made you afraid and why it made you afraid that you couldn't get out or that you couldn't stop at that time.
They were threatening my daughter.
How?
They went to my store and they took a picture of her at the store and sent it to me and told me how pretty she was and that she would make them a lot of money if I didn't make them money.
What else? Did you receive calls from these people?
They came to my house. They came to my work.
Was there ever a point where they parked outside your house in ski masks? Was your dad at your house when that happened?
Yes, my daddy seen them and my daughter seen them.
Did your dad move away?
He did.
Why didn't you feel like you could go to law enforcement about this at that time?
After I was arrested?
No, back while they're threatening you and you haven't been caught yet. Like, why didn't you go to law enforcement?
Yeah, makes sense.
Because they weren't going to hurt me or anything until they needed me to go do what they said, and I didn't. Then they would hurt me or hurt my daughter.
How often did they make it known to you during that period of time after you said you didn't want to do it anymore that they were watching you or watching your family or following you? How often did they make that known?
Often. They would text me what color dress I had on, or my daughter and my grandson, what day she took him to work with her.
Where are these texts?
Now, since some of those threats, we'll jump ahead and then come back to where we are chronologically. We saw that law enforcement had some text communications on an app that they obtained shortly after you were arrested in this case. But ultimately, text messages themselves that showed these threats, like you don't have a string of text messages that are threatening you or anything like that. Is that correct?
And they always did the delete.
Explain how after you got arrested and everything, you had to get a new phone, like the iPhone. I'll explain that process, how that went.
I had to file on the insurance to get a new phone.
Because your phone had been seized and taken into evidence.
That's correct.
Okay. And in order to do the insurance claim, do they have to remotely turn off location services and delete?
They automatically, I guess, did that, yes.
And delete whatever communications you had on the phone?
That's correct.
Okay.
Faraday bag.
Eventually you get your old phone back from law enforcement once they've had a chance to search it, right?
Uh-huh.
And by that point, did you have those text messages still?
No, I did not.
Okay. So now you did explain to law enforcement kind of what had happened even back then when you got arrested, correct?
That's correct.
Okay. All right.
I actually took the new phone to them.
And so going back in time to where we were chronologically before I asked you about the phone. So, you indicated they're showing up, they're threatening you, they're talking about your daughter being human trafficked and all that. At some point, does it come time to do the delivery they want you to do?
Yes.
And so how does that go? How are you contacted? How are you notified? And what is supposed to happen?
And they sent me messages through, I think it was WhatsApp.
Okay. And are those messages from the people threatening you or from your contact or handler or whoever that guy is?
No, it was through the people that were threatening me.
Okay. So they tell you it's time to do the delivery at that point.
That's correct.
Okay. And so what do you do?
I went and got it and delivered it, and that's when I got in trouble.
So you have the drugs, you have the drugs, you're delivering it to wherever you're supposed to be delivering it to and get pulled over at that point.
That's correct.
Okay. Did you believe that you could safely go to law enforcement without them knowing about it and taking action to kill or seriously harm you or your family members?
No.
Prior to getting arrested?
No, because they were following me.
Now, after you get arrested, you cooperate with law enforcement to the extent you can and tell them what's going on. Why were you no longer afraid to cooperate and be truthful with law enforcement at that point, after your arrest?
After I was arrested, then it was up. I was no good to them anymore.
So you
I would
can't make them
be, I would be being watched by the police, obviously.
So as far as you understood at that point, you can't make them any more money. You're
Exactly.
burned. So they don't have any more interest in you.
Exactly.
But you
I
couldn't go to the
understand
police.
you got into the original arrangement of your own volition and committed crimes of your own volition. True?
Yes, sir, that's correct.
The drugs that you were caught with in this case, would you have been out of the conspiracy and not committing that crime, but for the fact that you truly believed yourself and your family's lives were in danger and they could potentially be taken if you didn't comply with what you were being ordered to do?
That's correct.
I have no further questions at this time.
All right. Now they're going to pound away at the story, see if it holds water.
Chief, you agree with me that February of 2025, when you got caught by law enforcement, that you were bringing methamphetamine into the state of Florida? Correct?
It was March. But yes,
You got arrested on February 2nd, 2025.
no, sir. It was March 2nd. I know that for a fact because my store opens back up for our season on March 1st. That's why I would not have been doing that if I wasn't being forced.
So your testimony is in March 2025, you get arrested.
That's correct.
Okay. And on that date, you would agree with me that you were bringing methamphetamine from the state of Georgia to the state of Florida.
Yes.
Okay. And you brought a brick of methamphetamine, is what you told law enforcement that night.
Yes, sir.
Almost 1,000 grams.
Yes, sir.
Now, let's talk a little bit about where you're coming from. You're coming from Conyers, Georgia,
That's where I live, sir.
and that's just outside Atlanta.
It's 20 miles east of Atlanta. Yes, sir.
And you would agree with me that there's probably a lot of law enforcement agencies in Atlanta, a lot of police officers.
That's correct.
And to get down here from that area, you drive through Columbus, Georgia.
It just depends on which way I drive, but yes, sir, I did that day.
Okay. Columbus is a fairly decent sized city. You'd agree with me, right?
Yes, sir.
Probably has quite a few law enforcement officers.
That's correct.
You drive through Phoenix City, Alabama.
Yes, sir.
Same thing. Law enforcement in Phoenix City.
Yes, sir.
What about Eufaula?
Yes, sir.
Dothan?
Yes, sir.
And then you get down here into the Panama City Beach area.
That's correct.
And you'd agree that you didn't stop anywhere in any of those cities to speak of law enforcement at all?
No, sir, they were following me.
You didn't call and tell anybody, call any law enforcement at any point and tell them, hey, this is going on?
No, sir, they would have hurt my daughter.
Okay. The testimony today is that you're so afraid that your dad had to move and relocate?
He did.
What about you? Did you move and relocate?
Sir, my car was packed because that's what I was doing.
In fact, you're still living in Conyers today, aren't you?
I am back in Conyers now because I cannot be where I was because of my charges. My daughter's military.
You had some family in Hawaii. You testified today,
They
right?
moved back to Florida, sir.
But you could have moved to Hawaii.
How? I don't have the money to move to Hawaii on my own. I was staying on base with my daughter, sir.
My point is, though, you're still living in Conyers today, even though you're so afraid of these people up there.
Sir, I'm not afraid of them anymore. I'm not an asset to them. I can't make them money anymore.
So
They don't want anything to do with me now. They don't care.
your testimony is that, well, let's talk about why you were afraid. Your testimony today is that you were afraid that they were threatening to hurt your daughter in the future.
No.
Well,
When I refused,
have these people ever hurt your daughter?
have they hurt my daughter?
Yes.
Thankfully, no.
Have they ever hurt you?
Thankfully, no.
So they were threatening to hurt you at some point in the future.
If I didn't do what they said when they said it.
The night of March 3rd, when you drove down from Georgia, they were not actively doing anything to put you in danger. They were threatening to hurt you in the future.
They threatened me that they would hurt my daughter if I didn't do what they told me when that time came. And that's when they,
And at that time, you had a store in in outside Atlanta and Congress, correct?
No, my store's in Jonesboro.
Outside Atlanta?
Yes, it's south of Atlanta.
And that store makes you money?
Yes, sir, it does.
That store actually made you pretty decent money, did it not?
Yes, sir, it did.
About $50,000 a month during March?
Yes, but then you have all winter that it makes absolutely nothing. Because all the lakes close from October 31st till March 1st.
What was she selling? I'm in the wrong
Now,
business.
Your testimony today is that you got these threats over the phone, over text. They sent you text messages.
They sent me text messages. They came to my house. They came to my shop.
Your testimony today is that you don't have these messages anymore because you had to get a new phone.
I don't have them because they got erased. Yeah, when
Because you had to get a new phone.
Right.
Okay. You had to file an insurance claim to get the new phone?
Well, yes.
Why?
I didn't have money to buy one.
What did you tell them the basis was for having to get a new phone?
I told them it was taken from my car, and it was.
Did you tell them who took it?
No, I sure didn't.
So you weren't honest with them about why you needed a new phone?
Well, someone did take it from my car.
Okay. So your testimony today is you had to get a new phone, and then in order to do that, they had to wipe all your data.
I didn't know that was going to happen.
That's what your testimony today is, right?
Yes.
When you were on the side of the road, did you show any of these threats to law enforcement?
And they didn't let me show them anything, sir. I
You
even
didn't-
asked them to call
Did
the
you
feds.
tell them, hey, I'm only doing this because that guy's following me?
No.
Did you tell them, hey, I'm only doing this because that guy over there is threatening my daughter?
No, I asked them to call the feds.
Did you tell them, hey, I'm only doing this because look at these messages I've got on my phone right here?
No.
Let's talk about the person that you were communicating with. What was that person's name?
I don't know his real name.
If I got the screens, please.
All right. Prosecutors on the
I'm
roll.
showing you what's been admitted evidence as states 4A.
My friend.
And I think you just said it. He's in your contacts as my friend.
That's correct.
Not big scary cartel guy.
That's not the same person.
Not these people are threatening me.
No, this guy's not the one that threatens me at all.
But your testimony today is that he's associated with that.
Well, I found that out later, sir.
Let's talk about some of these messages. Your Honor, permission to direct the council table?
Yes, you may.
Let's look at 4B. Ms. Heath, these messages, the green on the right side, these are the messages that you sent, correct?
Yes.
And on the left side, the white messages, they are your friend that you're speaking to.
Right.
So these messages here, you say, well, I am headed back to Florida tomorrow. I found it down there. Was trying not to go anywhere else. My people can't wait any longer. Correct?
Mm-hmm.
And then he says, okay, what you're talking about drugs, getting drugs in these messages, aren't you?
Yes.
And
money.
When you say my people can't wait any longer, you're talking about the people you're going to sell the drugs to. Correct?
I'm really not sure.
Okay. And then you're accusing him of playing games with you and lying to you about picking up the drugs. Correct?
I think we were talking about money.
Okay. Well, let's go to the next
He would
one.
tell me he had.
So at the bottom of this message, it says, well, explain why, still nothing, correct?
Right.
And let's look at the next photo. 4C, the top of it, still nothing. I need you to tell my people this is the very next part of that conversation, correct?
Yes.
And the individual you're talking to sends you a nice photograph of a lot of methamphetamine, doesn't he?
Yes, he does.
And your response is, well, why don't I have it yet? Does that sound to you like somebody who's scared and afraid?
That's not the same person, sir. That's not the person I was scared of.
look at the next photo, 4D.
It's more than one person.
It's trafficking
4D.
for a lot of people. Oh my goodness.
You're here talking, and you tell them you're in Florida. Correct?
That's correct.
And he says, okay, and you say, I will try to come back. I have a couple good customers in Georgia. So you're in Florida and you decide to voluntarily go back to Georgia, where these people are. Correct?
That was before the threat started. That's when I was still voluntarily doing it.
Wow.
Well, let's see here. Your next photograph, 4E. These messages, yeah, and I've been begging for a while. I was in Georgia. You didn't have anything for me. You really hurt my feelings. I've made you good money. Give me money when you needed it. This is what I get in return. Sounds like you're the one angry with this guy and your suppliers. Correct? You don't like the way they're treating you. Correct?
No, because I couldn't get the money that they needed.
4F. I can't make nothing at this price. I would take 2 more right now, but it's not worth it if I don't make anything. I thought the stuff was going to be way better for that price. Just the same old half-ass stuff. They ain't going to pay that when they get better, cheaper. You're mad because your suppliers are giving you low quality for a high price. And you don't think you're going to be able to go make any money off of it.
I couldn't make them the amount of money that they wanted.
Why are other people getting better prices? Makes me look like an idiot. You're upset because you're not able to make the money that you would like to make off of these transactions, aren't you? 4G. Yes, this will make me lose my biggest customer. He can get through Jake cheaper and better. You're afraid of losing your customers because of what your supplier's doing, aren't you?
Yes. Then I can't give them the money that they needed.
So let's talk here, 4H. You're given an address to go pick up this substances, correct? 2203 Georgia 20, Conyers, Georgia.
Let's just read the drug house address out in court.
Okay. And it turns out, your message at the bottom says that is the city of Conyers Police Department. They sent you literally to the police, did they not?
Yes, they did.
And you didn't think, oh, that was a good time, maybe I should go say something. I'm literally at the police department.
What, while they're watching me?
Okay. And your response, really? Why would you give me the police address? 4J, why send me to the police department? 4K, okay, tell me why the police department? I'm scared, I ain't playing games, you send me to the police. Not once did you think to go into the police department and say, hey, look what's going on. Show them the threats?
No. They would hurt my daughter or me.
So your testimony is that you only did what you had to do because you're afraid of this future harm. And you were afraid to tell them no.
No, when they tell me to go pick something up, that is when.
And you were afraid to tell them no because you were afraid that they were going to harm your daughter sometime in the future.
Not sometime in the future. If I didn't do what they said when they said, they would hurt my daughter.
And that's why you were afraid to tell them no.
That's why I was a what?
Is that why you were afraid to tell them no, you weren't going to do this anymore?
I did tell them I wasn't going to do it anymore.
Okay. But
my friend, but not the other people. It's 2 different people.
This photograph in 4L. They tried to get you to sell cocaine, didn't
they? Yes.
And you refused outright to do that, didn't you?
He was asking me to get.
So yes or no question. Did you refuse outright to sell cocaine? Yes or no?
For my friend? Yes.
Okay. So you agreed to sell methamphetamine, but you're not too afraid to tell them no. about cocaine?
This isn't going well, ma'am.
It was two different people, sir.
Now, after you get arrested, did you tell law enforcement who these individuals are?
By the time I got out of jail, they were gone. I did try to help them and tell them.
Did you know information about them, names, phone numbers, ways to communicate with them?
The only numbers I had were in my phone, and I did not know anyone's real name. They make sure you don't know.
Fair to say that in the year and a half that you've been still living in Conyers, that they haven't kidnapped your daughter?
They haven't, because
they haven't threatened or
I'm of no use to them since I got arrested.
They haven't killed your family?
I don't associate with them anymore. I got arrested. I'm no good to them. Why would they threaten me now?
Well, I mean,
they disappeared.
Any information that you can give on getting them arrested would not be helpful for them, would it?
How could I give any information? They disappeared. I tried to give you that information. I even brought my phone and I sat outside of the police department waiting on the investigator to come so I could open the box. And when I got
Objection, non-responsive, Your Honor.
Sustained.
Let's talk a little bit about how afraid you were of these people. So, you're so afraid of these people that you agreed to move methamphetamine for them, correct?
Yes.
Okay. If they had asked you to go collect money from people, would you have gone to collect money?
I basically did.
Okay. If they had gone and asked you to go beat up somebody to collect money, would you go and beat up somebody?
If they were threatening me to.
If they had asked you to go burn somebody's house down, would you have done that?
If they threatened my daughter, yes, sir.
And would you have kidnapped somebody else's daughter if they had asked you to?
I couldn't hurt somebody.
Okay. And if they had asked you to go kill somebody, would you have done that?
I couldn't hurt somebody, sir. They wanted me to make them money.
Sorry, what was that?
They wanted me to make them money.
Okay. And you were also in this to make money, weren't you? That's why you did this.
To begin with, yes, sir.
And you continued to, and you got mad when your supplier was giving you low quality drugs and charging you more than other individuals, weren't you?
I couldn't. Can you repeat the question, please?
You got mad that your supplier was giving you low quality drugs and charging you more than they were charging other people because it was cutting into your profit margin.
It was cutting into their profit margin.
No further question, Your Honor.
You can redirect.
Yes.
Who is they? Who set the prices? Whose margin is it cutting into? Is it all the same person?
Just to be clear again, because law enforcement erroneously testified about the date of your arrest here, that won't be an issue since there's a charging document here which charges the correct date. I'm sure the jury will be instructed about that. But let's talk about your text messages that Mr. Sullivan was just asking you about here. The text messages where you're complaining about the price. Do you remember off the top of your head what date those text messages were?
I don't.
Would it refresh your recollection if I showed you the date of those text messages?
Possibly.
May I approach, Your Honor?
May approach.
Let the record reflect I'm shown was admitted into evidence by the state as Exhibit 4D. What date were those text exchanges taking place on?
February 19th.
That was a couple of weeks before your arrest in this case on March 2nd,
That's
correct? Same thing with state's Exhibit 4E. What date or two dates do those text messages cover?
February 20th and
The day before, correct?
it doesn't show it on there, but
Going from Exhibit 4D to
yes.
4E, it's
Yes, sir.
basically it's February 19th to February 20th, correct?
yes, sir.
Okay. So, and you've acknowledged you got into this to make money.
I did.
And the reason you wanted out was also because you weren't making the money that you thought you would make. Fair enough?
That's fair.
Okay? That wasn't the problem though, was it? I mean, yes, you wanted out because you're not making money, but that's when the circumstance changed. Is that right? I'll rephrase. The reason is it true that the reason you became disillusioned and didn't want to do it anymore?
Objection waiting. Sustained.
What is the reason you didn't want to sell drugs for them anymore?
Because my store was not making money.
Okay.
I couldn't make a living without having to do it anymore.
So you don't even debate what the state was saying about wanting out because you're not making money or making money like you want to, correct?
It's all about money. She has no feelings about.
Is that why you told them
it was illegal? I
cartel
felt bad
people
for
you
breaking
wanted
the
out?
law.
Or told your contact, whoever it was you told you wanted out, is that why you told them you wanted out?
I told them I wanted out.
And is that the reason why?
Yes.
Okay. Had you ever been threatened prior to telling them that you wanted out? And however exactly long it was before your arrest on March 2nd, a week or whatever it was, if they had not threatened you, threatened your family, would you have still been delivering drugs for them on March 2nd?
No, sir, not at all. My store opened on March 1st.
Now, once you got burnt and weren't useful to them anymore, you did try to cooperate with law enforcement, right?
Yes, sir, I did.
You had a meeting with them. You were there. Mr. Middleton was there. Law enforcement was there, and you tried to tell them what exactly was going on, correct?
I sure did.
You told them you were threatened.
That's correct.
You weren't the only one scared, right?
No, I was not.
Is it true that law enforcement was so worried about cartel guys that they came to that meeting with you wearing ski masks themselves?
That's correct.
No further questions.
Any redirect? I mean, any cross?
Law enforcement came to the meeting wearing ski masks.
You may have a seat. Let you call your next witness.
At this time, the defense will rest here.
If you'll have a seat, ladies and gentlemen, we're going to take another break.
Lunch
break. Take a 10-minute break, start back at 20 after. I'm going to have some lunch brought in for y'all, okay?
Take a short break.
If everybody's ready to keep going. Everybody ready to keep going? All right, I'll have some lunch brought in. All right, you'll follow the bailiff from the back, leave your notepads in your seats. In case among yourselves or anyone else, in case the media sources, use your electronic devices. Find out any more about the case you know right now. Follow the bailiff from the back.
You're on that one, right?
Yes.
Thank you.
All right. As a defendant, I'd be a little concerned that I just admitted to committing this crime other times, that I seem to have no problem with committing crime as long as I'm making money. And
Everyone can have a seat.
The story sounds
Courtroom.
unbelievable.
Anything else? All right, we're ready for a charge conference.
This will be quick. Judge is really fast at this.
I'm ready to go forward. I'm on page 2 of the instructions that Mr. Sullivan has provided. Basically, the instructions on the trafficking and methamphetamine. Any issue with those?
Defense? That's a question for you. It's not rhetorical.
I haven't seen any issues with it.
All right, then we have the issue of the arrest.
Not disputed.
At least put on a prima facie showing that the instruction should go.
Mr. Prince, any issue with the instruction of duress that Mr. Sullivan has provided?
No, Your Honor. It looks like he's quoted the standard verbatim.
The defendant has entered a plea of not guilty. Any issues with that?
No, Your Honor.
All right, I'm on page 6. About the
I guess I'll note for the record that I do know, and that this is the new instruction, that the instruction just recently changed, and this is the appropriate instruction, the new version.
Judge is on his A game.
All right, we're on page 6, 1 through 10. Some of the things that jurors should consider. Number 9, number 10, 9, 6. Any issue with 6 coming out?
No, you're not.
7. Any issue?
I don't think it would apply. I agree. It feels like it should because of what we're talking about, but I don't think that actually applies here.
All right, number 8 should come out. Is that correct?
Yes, sir.
9 and 10 would as well.
Yeah, I've already said 9 and 10.
All right.
I started with E. 9 and 10. All right. Expert,
No objection to that.
it's entirely proper lawyer. The defendant has become a witness. So number 9, the second paragraph would come out. And you want the first paragraph to stay in on page 9?
Yes, sir. I would prefer to stay in.
General rules that apply to the discussions. Any issues with that?
Okay.
And then the verdict form. Any issue with the verdict form?
Amber, thanks for that.
No objection.
And then page 12 and 13 is submitting the case to the jury. Any issues with that?
No, that's all standing.
Okay. I've got lunch ordered for the jurors, so unless somebody jumps up and down and persuades me else, I'm gonna go ahead and go right forward with the closings and final instructions.
And then go to lunch.
Give it to the jury.
All right, we're getting this done.
All right, we have what? What did I say, 20?
Police in Wisconsin used Flock to
506?
track a man who
I'll be right
traveled to Michigan. Flock
Please.
cameras to track a man who traveled to Michigan, where marijuana is legal. Then back to Wisconsin, where it's illegal. Then they used his travel as part of a probable cause justification to search his car for weed, and he was arrested. Huh. That's a tweet from Philip Lewis. Flock, on the other hand, tweeted yesterday with Flock, 4,200 stolen plate alerts, 1,444 stolen vehicles, 1,354 wanted person vehicle hits, 124 missing person vehicle hits. Top 3 stories: 6 arrested with stolen dog and explosives in North Carolina. Murder suspect arrested in OKC, and crime spree stopped in Texas. The one they missed was the one that Amber sent me. Mooresville, North Carolina police officer Elizabeth Snowman arrested while at work Wednesday for using the Flock camera system to track her boyfriend's ex-wife. Flock is a camera database that reads license plates and is used for law enforcement. Mooresville Police Department Police Chief Ron Caporacini said Snowman used it 31 times to track her boyfriend's ex. 2 of those times she was off duty. Fun times. Let's see. Taylor Frankie Paul. What's the Taylor Frankie Paul case? Just got a Utah PIO notification about a feed we have access to. People magazine is pool for WebEx only. Must be somebody famous. People Magazine is the. I've never seen People Magazine be the pool on a court feed. Domestic violence. It's an aggravated assault charge. So it's the Mormon wives one. Is that the case? Secret Lives of Mormon Wives. It's the lady who threw the chair, right? In the presence of the child. Okay, got it. Got it. Okay, we're probably not going to go to that one. There's a child in that case. It's just a. Let's see what the hearing is. It's a final review hearing, so it'll be quick. The chair is innocent. She didn't just throw the chair; it hit the daughter. I did not know that. I thought it was in the presence of. I haven't followed that story, but it's typically outside of our little wheelhouse. Brian Anton tweeted 2 hours ago about a story out of Tennessee with a lady charged with murder for shooting the stranger that she found under her child's bed. Red, did you do a poll? You did. Let's see. Did the prosecution prove anything here? Christina is pure as the driven snow. Christina is guilty. Christina is guiltier than guilty, or she should not have testified. Oh, man, these are good answers, all of them. Red, that's awesome. Thank you. Northwest, Jennifer Gledfill, trial for December. We'll keep. Hey, we are. December is a hard month to fill with trials, so that would be good if we have one. December's the month where we don't pay the bills. Let's put it that way. It's a tough month. We have a couple months here throughout the year where that's the case, but December is really rough. Just because no judges like to have court during December around Christmas time. No jury wants to be sequestered over the holiday. Red, you did great with the poll. I nominate you to do polls from now on. To be fair, she removed to drive the snow. Yes, that was funny. We do have a new command. Smurl, the company that makes my counter, this one right here, which is working, gave me an affiliate link where you can get 10% off. It doesn't pay me anything, but it does give me a coupon if I want to buy another one. So I'm not sure if I have to say I'm an affiliate, because if enough people buy a Smurl counter using my link, then I just get to buy a cheaper one. I don't know if that counts or not. But it's a counter is the command, ! Counter. They make these. They work really well with Facebook. So if you're in charge of a Facebook group, or a Instagram page or something like that, or a business that has those postings, this is really a fun way to let people come into your store. Scan the QR code, and then see that they are like number this, or their follower number that. But anyway, so that's out there. I figure if I can get you 10% off, I wouldn't buy it unless you have a good use for it, because it is a very unique item that way. I love it. I love what it does. As you see, it clicks and counts and keeps track of the likes, which are 266 right now. There's a dad joke in the link. If you like, the like part, I put it in quotes, air quotes. You claimed your discount. Sweet. I will say that my son's smart, but he can't program everyone's. So if you decide to get a custom one like I have that works for YouTube or something else like your sales floor, they have these in businesses all over the place. It'll show that you can track the sales during the day or how many calls have been received or any metric anywhere. You can program this thing to show. But if you do choose to do that, I can't help you on that front. You have to find somebody who can program it. Okay, where are we? Are we back? Attorney's putting our coat on. We're getting ready. I've got a spam call. Hang on, I know we're coming back right now, but just 1 second. Hello? 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 Bummer. They heard the clicking. Can it count down? If you if only one.
Take a short break.
If only one of you unlikes, they will count down. It can show any number you want. Like I could force it to show. Let's see if I can find my Smurl counter. You can manually get it to show something.
Ms. Heath is back in the courtroom. Mr. Prince, is there something you want to address prior to bringing the jurors in?
Yeah, I'll just preserve it. Mr. Sullivan has prepared instructions that are in compliance with the controlling first BCA precedent and the conflicted circuits that result that doesn't appear. So the Fifth District Court of Appeals essentially says once the defense introduces a prima facie case of duress or necessity, the burden shifts back to the state. For the first DCA in Tyler, the state 131.7, third 811, that's the first DCA case from 2014, says that the burden remains with the defense. That would be controlling, of course, in the absence of
Very good. All right. Are we ready to bring the jurors in?
Yes, Your Honor.
Sure.
So with that affirmative defense of under duress, the burden shifts back to the state to prove that she was not under duress? Is that what I'm hearing? Is like a self-defense?
Your Honor, since I hadn't, did I?
Jury's coming.
Yeah.
Your Honor, we haven't gotten to that point. I think I would like to call investigator LaRoche for just one rebuttal question, two rebuttal questions.
Defense
I don't
overplayed
know
the
that change anything. If it's too late, I understand.
It's not too late, but I mean, gosh, mighty y'all have.
I know. You already arrested in front of the jury? No. I arrested at the end of my case, but I don't know that.
I didn't ask for any rebuttal.
And that's
my fault. Tell me.
Hold on.
Go back out, jurors. Hang on. Defense played the card.
It's just going to be one question.
All right. Go ahead and bring them. You can go ahead and bring them in.
They played their hand too soon.
Have a seat.
They played their hand too soon.
It just dawned on me that.
All right, go ahead and have the juror call. That
was funny. That was an interesting tactic. They played too soon. Defense is mad now because the state went back and said, on second thought, we are going to call a rebuttal witness because
Sure, you can have a seat when you get to your.
we do have to
chair.
prove
Everyone else can have a seat.
that this was not under duress.
Did the state have a rebuttal witness?
Yes, Your Honor, I would like to recall Investigator LaRoche.
Investigator LaRoche, you're still under oath. If you'll come and have a seat, speaking to the microphone. Mr. Sullivan, you may inquire.
Thank you. Investigator LaRoche testified earlier today that you got a search warrant and located messages on Ms. Heath's phone.
That's correct.
During that process, did you ever locate any threatening messages?
No.
Prince, any questions?
Briefly. You captured those as screenshots, correct?
The pictures, I have a physical download on a USB of the entirety of the phone. And then the pictures that Mr. Sullivan presented are from my camera that I took. It's just easier to look at.
Right. And so the messages that we have pictures of, those aren't regular text messages. Those are messages between her and her handler or contact, for lack of a better expression, on some messaging app. Is that correct?
Yes.
Thank you for the questions.
Anything else for the witness?
Your Honor.
You can have a seat. Mr. Sullivan, any other witnesses?
No further.
Ladies and gentlemen, both the state and the defendant have now rested their case. The attorneys now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Mr. Sullivan, whenever you're ready.
Thank you. Ladies and gentlemen, as I told you this morning, this wasn't a very complex case. There's really no dispute as to the elements of this offense. The judge is going to tell you in just a few moments that I have to prove three things beyond a reasonable doubt. One, that Ms. Heath either brought into the state or possessed a substance. Two, that substance was methamphetamine. And three, the methamphetamine weighed more than 14 grams. You heard Ms. Heath, she testified basically to all of that today. That's not really why you're here and what you're to determine. I've proven beyond reasonable doubt those three things. What you're going to be asked to prove or to determine, though, is whether the defense has proven the defense of duress. Typically, in these trials, the burden is on the state to prove the charges beyond a reasonable doubt. And that is still the case in this particular case. But because the charges themselves are not really in dispute, we need to talk about the duress defense. Normally, and I think Mr. Middleton mentioned it during jury selection on Monday, the defense doesn't have to present anything. They don't have to present any evidence. But in this particular case, they have raised what's called an affirmative defense, which means the burden that is normally on the state to present evidence is actually on the defense to present evidence of their particular defense. And that's important because you're going to have to ask yourself, has the defense met their burden in this particular case? And the judge is going to read you all the instructions. And as part of the instructions on page 3 and 4, this is the instruction that deals with the duress defense. And I'm going to talk a little bit about this because I think it's important. The defense has to prove 8 things to you in order for you to find that the duress defense applies. They have to prove that the defendant reasonably believed an emergency existed. The defendant reasonably believed the emergency would cause death or serious bodily harm to herself or another. The perceived harm of death or serious bodily injury was imminent and impending. I think that's important. We're going to come back to that one and talk about in a minute. The defendant did not intentionally or recklessly place herself in a situation in which it was probable that she would be forced to choose the criminal conduct. Well, that's important because you heard her testimony today. She put herself in this situation by voluntarily getting herself involved with these individuals and voluntarily agreeing to sell narcotics for them. The defense can't show that she did not intentionally or recklessly place herself in that situation. Therefore, the duress defense doesn't apply. That in and of itself. The defendant had no reasonable means to avoid the emergency except by committing the trafficking in methamphetamine. You heard the testimony. She could have called the police. She could have gone to the police in Conyers, in Atlanta, in Columbus, Phoenix City, in Dothan. When she got down here, she could have called the cops. She testified that she had been working with them for several months, several weeks. She could have called law enforcement officers in any of the places that she went during that period of time. You saw the messages. She was actually even sent to the police department at one point. She had reasonable means to avoid this emergency. The trafficking of methamphetamine is committed out of duress to avoid the emergency. The perceived harm that the defendant avoided outweighed the harm caused by committing the trafficking of methamphetamine. And the defendant ceased her criminal conduct as soon as the necessity or apparent necessity for the criminal conduct ended. Now, I told you we were going to come back to talk about the imminent and impending. The judge will tell you that imminent and impending means the emergency is about to take place and cannot be avoided by using other means. Importantly, a threat of future harm is not sufficient for this defense to apply. So let's assume for a second that Miss Heath got these messages, these threats. Those threats would have been for future harm. And that's why one of these elements requires her to take reasonable means to avoid the emergency. Because when you have a threat of future harm, you have the ability to take measures to avoid that future harm without committing criminal conduct. Any potential threat that Miss Heath may have received or gotten was a threat for future harm. There was no impending and immediate emergency the night she drove from Georgia and brought this ginormous bag of methamphetamine to our community.
Ginormous bag of
Now,
meth.
I told you, let's assume for a second she got those messages. The defense has the burden of proving this defense. What proof, what evidence have you seen that these messages ever took place? That these threats ever existed? You've not been presented any text messages? You've not been presented any photographs of that were allegedly taken of her daughter and sent to her? And I want you to ask yourself, why is that? Now, you heard the testimony that, oh, I couldn't get them because I had to get a new phone and they had to wipe my old one. They didn't have the old one to wipe. It was in the custody of law enforcement. And ask yourself, why? Why? Does that even make sense? Why would they have to wipe the old phone to get the new one? Anybody who has bought a new phone has gone and they've transferred things over. Verizon, AT&T, whatever carrier, they plug it in, they transfer things over, get both phones back. You don't need to wipe the old one to give you a new phone. That doesn't make sense. What also doesn't make sense is when law enforcement got into the phone and looked at the messages between Miss Heath and this individual, there were no threats for Investigator Roach. The advantage that Miss Heath has is she's able to sit here through all the testimony. She can hear what everybody's saying, all the evidence that's presented. Investigator Roach, she's not able to. He has to sit out in the hallway. He can only testify when it's his turn. So he has no idea what Miss Heath testified to today. He told you that there's no threats when he looked at that phone. They're not there. At the end of the day, ladies and gentlemen, there's no evidence that these threats, this duress, existed outside Miss Heath's testimony. And your job is to determine whether she's credible or not, whether you believe her or not. And I submit to you that she is the only person in this case that has anything to lose. And the judge will tell you in a few moments that that's one thing you can use to determine credibility. Clerk, if I got the screens, please. And
you need me to move?
when you are determining credibility,
sorry, Judge,
you have to ask yourself, well, what does she have to lose? What does she have to gain by telling us a story? What do the other witnesses have to lose or gain? This photograph, it's in evidence. I'm going to zoom in. I know they're probably hard to see. When I went through them earlier with Miss Heath, you may or may not have been able to read them. You will get copies to take back. They're a lot easier to read in the notebook. But I'll zoom in a little bit here so you can see. Because on redirect, Mr. Prince made a big deal out of when some of these messages were sent. You know, they're sent a couple weeks before. Well, you've got that date there, March 2nd. So you know the messages sent right before that were sent right before March 2nd. So 2 days before she ultimately gets arrested. And what is she talking about 2 days before she gets arrested?
When does your office
read those
open?
Messages?
Why are other people
Ask
getting
yourself,
better
do
prices?
they sound like somebody who's afraid?
Makes me look
of what
like an
she's doing?
idiot.
Or do they sound like somebody who's mad with her supplier,
He can get better through
who's
Jake.
trying to make a buck?
Cheaper and better.
Mr. Prince asked her herself, you know, why did you decide to get out of this? My store was making money now. That's all she was in this for. It was money. Simple as that. Ladies and gentlemen, the judge will tell you that if the state has proven its charges beyond a reasonable doubt, which I have in this case, your duty as jurors is to find the defendant guilty. And I ask you to do that in this case. Find the defendant guilty of trafficking in methamphetamine more than 200 grams. Thank you.
Are they going to take the meth back into the break room, the deliberation room?
I'm not going to spend a ton of time talking about it, but there is an issue that I want to talk about relative to the question of whether Ms. Heath actually possessed the substance that was tested and entered into evidence in this case.
Oh, yeah?
That's not going to be the main part of my argument, but I do want to discuss that with you. Before I get to that, though, I do think it's important that we kind of focus on what the analytical framework for addressing that question is. Because while it is true that the defense has to prove by a preponderance of the evidence that Ms. Heath acted under duress for that affirmative defense to apply, again, that's not the same standard that the state has to prove their case to. We just have to prove that it's more likely than not, essentially, that by the greater weight of the evidence that Ms. Heath did indeed act under duress at the time she committed the specific offense in this case. Okay, we don't have to prove that she acted under duress when she committed any other act or crime. It just pertains to the offense at issue in this case that occurred on March 2nd. That's the date of the offense. I know there was some confusion about February. It is March. That's the date charged in the information. The instructions will make that clear. But again, I do want to briefly kind of touch on what the framework for that analysis is before I get to the first element of the offense here. So a lot of times in a situation like this, you know, the state will talk about it. It seems like a foregone conclusion that obviously, you know, the most reasonable interpretation of the evidence by far is that the drugs that were tested are the drugs that were in the car. And that's a fine argument to make. But the question isn't like what seems most likely, what seems clearly and convincingly true. Those are other standards of evidence that don't apply in a criminal case. And the court will instruct you on what the standard of proof is in a criminal case. You're going to get a packet of instructions from the court, and you'll be able to take those instructions back with you into the jury room so that you can use them to guide your discussion as you're going through the process. And the court's going to instruct you first and foremost that the burden in this case is not to introduce the better or more believable or more convincing version of the events, but to exclude or eliminate every reasonable doubt. And here's what the instruction says. The defendant in this case has entered a plea of not guilty. This means you must believe or presume that the defendant is innocent. This presumption stays with the defendant as to each material allegation alleged in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. So that's the standard, okay? That's the question ultimately that you have to answer about the elements of the offense before you get to the affirmative defense. And again, it's the state's exclusive burden to prove that, okay? And I know it doesn't make sense yet why I'm saying, or even talking about, I mean, we heard the evidence, why are you acting like there's insufficient evidence potentially that she possessed the drugs that were tested. I'll get to that in a second and tell you why there is a doubt that comes from the evidence and from the lack of evidence here. But for purposes of our discussion here, it's important to remember that it is the state's exclusive burden. Also on page 5 of the instructions that the court will read you and then give you, they'll instruct you to overcome the state's presumption, to overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed and that the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Again, on page 8 of those instructions, the court will likewise instruct you. The Constitution requires the state prove the accusations against the defendant. It's not necessary for the defendant to disprove anything, or is the defendant required to prove her innocence. It's up to the state to prove the defendant's guilt by evidence. And when we talk about like how high that burden is, exclusion means what it means in everyday life. Okay, like unless the court gives you a specific instruction or definition for a particular term in the jury instructions, it means what it means out there. So it doesn't mean like obviously it's true that those are the same drugs, or clearly it's true that those are the same drugs. The standard here is exclusion, elimination of every single reasonable doubt. Now that term, reasonable doubt, that term is defined, and it doesn't mean exactly what you might think it means outside the courtroom. Outside the courtroom, I would submit if somebody says, that sounds reasonable, what they're really saying is that sounds like that's probably correct, that sounds like that's probably true. And that's how we all make decisions, right? Like we make the best decision that we can based on the information that we have available to us. But in here, reasonable doubt doesn't mean I believe that doubt to be true. Reasonable doubt doesn't mean probably. Reasonable doubt has a definition, and the court, as part of that definition, tells you what it's not, and he tells you where it comes from. This is again on page 5 of the instructions that the court will provide. The law does not require proof beyond all doubt on the part of the jury before a verdict is returned of guilty. A mere possible doubt, speculative doubt, imaginary or forced doubt is not a reasonable doubt. So that we know that's not a reasonable doubt. You know, if you're involved in conjecture or speculation, that's not a reasonable doubt. On the other hand, reasonable doubt as to the guilt of the defendant may arise from the evidence, the conflict in the evidence, or a lack of evidence. That's critical. That's how we know what a reasonable doubt is, because of where it comes from. If the doubt comes from the evidence, if the doubt comes from a lack of evidence, then it's a reasonable doubt. And now just because a reasonable doubt arises, that doesn't necessarily mean the defendant is automatically not guilty, but it does mean that the state then has to come forward with other evidence to eliminate or exclude the doubt that has arisen from the evidence, conflict in evidence, or lack of evidence. The way that I like to illustrate that point is to talk about a bank robbery. If the state has somebody that's being prosecuted for bank robbery and they march in witnesses and, you know, the witness says, I was at the bank, I was a teller, that's the person that robbed me, I see it sitting right there. If they put on video surveillance footage and it shows, hey, that's the person that robbed the bank, looks like the same guy. And then the defense attorney gets up in closing argument and says, well, the state didn't introduce any evidence to indicate my client doesn't have an identical twin. How do we know he doesn't have an identical twin? Their evidence didn't prove that. That's speculative and imaginary. Not because I say so, but because of what the judge says. It's speculative and imaginary because it doesn't come from evidence or a lack of evidence or conflict in the evidence. It's totally speculative. That's why it's not a reasonable doubt. On the other hand, if the defendant in that bank robbery case took the stand or called a witness and the testimony was, he's not a bank robber, but he does have an identical twin, and the identical twin's a bank robber, and the defendant had an alibi at the time, that could be true, it might not be true, but now a reasonable doubt has arisen because that evidence, that testimony is evidence. And again, it's not automatic that means not guilty. It just means that the state then has to come forward with other evidence which excludes that reasonable doubt. The other part that it's important before we get into argument to remind you of, I think, is that the state can't exclude reasonable doubt with argument, okay? Reasonable doubt, once it arises from the evidence, it has to be excluded by evidence, only evidence, not argument. Like you might think his argument's smart, you might think the argument's slick, might think he's probably right, but that's not evidence. And you can't exclude reasonable doubt with argument. And again, that's not me telling you that, that's what the instructions say. Going back to page 5 again, the presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it's been overcome by the evidence to the exclusion of and beyond a reasonable doubt. Further back in the jury instructions, where the court lists the rules for deliberation, the court will instruct you, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits in evidence, and on these instructions, on the evidence and the law, not on argument. What the attorneys say, while intended to aid you in your analysis, is not evidence and cannot be the basis of an argument that, like, reasonable doubt has been excluded. Reasonable doubt can only be excluded by the evidence. And it's important to remember as you go through this analysis and do the job that you've taken an oath to do here, that we trust you to do this, because this is the only way to ensure that the process is going to work. If the process fails for some reason, fellow citizens are supposed to be the ones that follow the law. You guys don't have an interest in anything happening here except that you have an interest in a just system.
Have I told you about jury nullification?
It's so critical and important that you follow the law, and the court will remind you of how important that is himself as well. On the instructions that you'll receive here, the court will instruct you. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending on you to make a wise and legal decision in this matter. And the last thing he'll tell you before he sends you out, in closing, let me remind you that it is important that you follow the law as spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law, and no juror has the right to violate the rules we all share. What does that mean?
No jury
And
nullification.
why does the court instruct you that way? Because it's not natural to decide anything based on exclusion. Now, I got 3 little boys, and they're all terrors. And we always go to Michigan for Christmas time. And a few years ago, we're all upstairs, and we hear them playing downstairs, and all of a sudden, I go downstairs, and this 85-inch TV is shattered. I don't sit my youngest down and turn to the other 2 and say, all right, you don't have to prove or disprove anything. You don't have to introduce any evidence. You 2, exclude every single doubt, every reasonable doubt about whether youngest here broke the TV. That's not how we think. That's not how we make decisions. But it is how you have to make decisions in here. You can't just say, my gut says this. You can't just say, it's probably this. That's not the oath that you took. The oath you took is to hold the state to the requirement to exclude every reasonable doubt. So regarding the elements of the offense here, I do want to, at least briefly, and spend a little bit of time talking about where I think a reasonable doubt arises and where you should consider a reasonable doubt having arisen from the evidence in this case. Again, the state does have to prove that the substance was methamphetamine. That's the second element of the offense. The substance, not some substance she possessed previously, not some substance that she believed was present. They got to prove that bag that was tested was the bag she had. That's what they have to prove beyond into the exclusion of every reasonable doubt. And there is at least some reason to question that. And I'm not going to sit here and say that it's probably not the same dope. It probably is the same dope. I can say that because probably is not the standard. But there was testimony and conflicts in the testimony, which did give me a question about this. And the reason I say that is, when I was questioning the detective, I asked him about a weight discrepancy. I asked him about the fact that the narrative report that he had indicated that the weight of the drugs in the box aggregate was 1,286 grams. I pointed him to another section that showed that the weight was 1,253 grams. My purpose in doing that,
they might have had
was
to use
not
some of it.
so much to focus on that weight discrepancy, because he was saying, like, regardless of what the weight was, it came out of that area and that ultimately was tested. But it's not insane to think, because it has happened, it does occasionally happen at least, that the wrong exhibits can be sent under the wrong number. And I would submit that there's evidence that supports that conclusion in this case. And the reason that I say that is, and I was very specific to ask him this, and I asked him it twice. And if you don't remember this, and you probably don't, there was no reason that it would have stuck out as significant at the time, but I did ask the detective twice, what was the item number of that exhibit, that agency number, that item number for that drug that you tested, that you sent to FDLE, what item number? It was item number 1, agency exhibit number 1. I know you don't have notes about that. I know you probably don't remember that, but you can ask for a readback. If you don't remember that, you can ask, once you go back to deliberate, if you want to know, you can ask the court reporter to read those portions of the testimony back to you. You come out here, the judge will have her do that, and she'll read it back to you. That was agency exhibit or item number 1. What item did FDLE tell you that they tested? They said it was item number 3. Approach.
This is a Hail Mary. They're all going in the back office. We're not going to fight this out in court. Jury, you stay right there with the defendant. And the observers were all headed back into chambers where someone's going to get a spanking. I don't know who. Someone's getting a little paddling. Oh, man. He was going way too fast. He is. He's very excited about this. And maybe it's because he thinks he's got the ace in the hole. The lab adds their own case numbers. Oh, they're done already. Oh, no. Wait, we need some documents. The lab did not testify that they added their own number. It's terrible. She admitted to having a brick of meth. I mean, that's on camera. I got a brick, meth, in the back. It's in the birthday package. How much is a brick? I didn't think we heard on testimony how much a brick is, but I think a brick is a kilo, right? That should make sense. Who's getting a whooping? I think defense is here. But this judge is a no-nonsense judge, and this might be a little much. Oh, what's he doing? They're not in the back. They're leaning over the bar. I thought they were in the office, but I see judicial booty. There's judicial booty still in the picture, so he's not left the room. Brings a new meaning to the word justice. Justice. I'm sorry, that was terrible. If you want more like that, please join us for the podcast tonight, the Not Relevant podcast, 8 p.m. Thomas and I will be here talking about all sorts of things not relevant to true crime. Amber's throwing tomatoes. Oh man. Yes, just justice, and justice for all. Why did you edit out the you? Why do you edit out the you? Just us. Yeah. Come for the silly stories, stay for the dad jokes. Got it. Somehow I got Googling. You know when you Google and you start and you're like, I need to look up the details of this case, and then you end up and you're like, how did I get here? I haven't done the trace back to how I got here, but I'm shopping for a backyard shed that can be converted into a greenhouse now. I'm pretty sure I started on Tennessee court system. That's where I started. I don't know how I got here. There was a rabbit hole, but now I'm looking at backyard offices that can double as a greenhouse. If somebody can connect those two for me, that would be great. Sheds scare you. I have a shed. I know this because I see it every time I'm outside, and I'm like, I've never been in there. Did you click on an ad? I don't think I did. I think it was from one Google to the next Google. I can probably go back to history and trace it back. The backyard streaming office. I've thought of this. You ready for your free lunch? What are you going to get for your free lunch? My wife made fried rice, like egg fried rice. So it's got the veggies, the peas, the carrots, the rice, the scrambled eggs, and yeah, it was delicious. And I thought this will make wonderful leftovers for tomorrow, which is today now. And then I promptly ate it all. Melissa and Chris, member for 22 months on the jury. Melissa and Chris, thank you very much. Wouldn't be the same without you here. Appreciate your support. And 22 months definitely makes you an OG. Thank you very much. This sidebar is taking longer than I expected. I don't see anything shaking up there on camera, so I don't think the judge is letting them have it yet. Is this the lady that tried to get the plea deal earlier this week? Yes. She wanted the 12 years. She was signing up for 12 years of incarceration. That's her mindset going into this case. Yes, lock me up for 12 years. But the plea deal was blown up by the judge when he said, you can't do that. There's a minimum mandatory for trafficking that much meth, and it's 15 years. And they said, fine, then we're going to a jury trial. Which still has a minimum mandatory of 15 years if he's convicted. So I don't know if it was just get a little extra time out. The defense, I think, did a great job. Just chasing things. They're rabbits or wild gooses or something. Let's see, I've got a couple of membership messages to read. Debbie, Creative B, 41 months, we got you. And Kim R, both OGs, 38 months. Thank you, both of you. Shelly Small gifted 5 memberships. Thank you. Blue Star, 11 months. Good morning, all crazy work schedule. Can't wait to catch up with y'all soon. That we can't wait as well, Blue Star. Looking forward to that. Shelly Small sent some super chats. Says, why? Would love to see the condition of both places where they live now. That was about the husbands, or the wasbands, as the case was. Shelly Small also said, why isn't her dad or daughter there to back up her story? I think dad is there in the gallery in this one, Shelly. Thanks for your support, by the way, of the channel. And Melissa, Chris, 22 months on the jury. Judge sits down, shakes his head, stands up again, gives us the same view we had before with a slight variation. This one's a little more profile. Know if that was on screen. I had turned off the screen for some reason. All right. Debbie, the Creative Bee, thank you very much. Kim R, thank you so much. Both of you OGs. Shelly Smile gifted 5 memberships. Blue Star member for 11 months. Can't wait to catch up with y'all. I can't wait as well. Shelly Small gifted 2 super chats. One commentary about the condition of the 2 husbands, and the other one talking about this defendant and why her dad isn't there to back up the story. And then Melissa and Chris, member for 22 months on the jury. OG. There we go. Now it's on screen. Gotcha. Apologize for that. I've been putting things on the screen for a while now. So whooping is taking a while.
Yes.
Continue.
Y'all heard what the evidence was. What I say the evidence is in the evidence. What he says the evidence is in the evidence. The law is in black and white, and you took an oath to follow it. Moving on then, talk about duress. The state's right, we do have the burden to prove the elements of duress. It's by the preponderance test, greater weight of the evidence. Okay, that doesn't mean we have to exclude every reasonable doubt. Doesn't mean that it's got to be clear and convincing that all of these elements are present. So I want to talk about what those elements are. Number one is the defendant reasonably believed an emergency existed. And the state wants to make the argument that there's no evidence that that's true. Well, there is evidence that that's true. First of all, she told you that. And you're allowed to consider the factors under weighing the evidence that the court will instruct you about. Did she seem to have an accurate memory about that? Yes, I would submit that she did. Did she seem honest and straightforward in her testimony about that? Did that seem, let me just pose the rhetorical question. Did that seem like feigned emotion when she was talking about the threat to you? Did she seem like she was up here acting to get a benefit? And if she was going to lie, why would she admit that she got into this herself? That creates a problem for her under the element that says the defendant didn't intentionally or recklessly create the situation or put herself in the situation. We'll talk more about that element in a few minutes. But I'm just making the point, if she's going to lie, why say you put yourself in this voluntarily? Why wouldn't she just say, I went to pick up money for this guy. Next thing I know, they tell me I have to deliver drugs or they're going to kill my daughter. If you're going to lie, that's the lie you tell. That's not what she said. She told you honestly, she got involved because she wanted to make money. She knew it was a crime. She did it anyway.
That's guilty.
And why do you think she's charged with trafficking on March 2nd and not conspiracy for a greater amount? Because she proffered to law enforcement as she told you she did.
That's not an evidence.
Sustained. You heard testimony that there was a meeting between the defendant, Mr. Middleton was there, she went there, and she told them she was threatened. She told you that's what happened at that meeting. Don't you think if it weren't true, by the way, that law enforcement also took this seriously and was also afraid, and it wasn't true that they were wearing ski masks? Don't you think in rebuttal, the detective would have told you that? They were scared too. That's why they're wearing masks like they're in a movie. Folks, you should take that testimony and consider it as corroborative, strong evidence that there was really something to be afraid of here. And if the state wants to argue that there was nothing in the phone that could be interpreted as a threat, look, he's looking at the messages in the app. That's what the pictures you have are. That's what he's looking at. If he looked at text messages, he wouldn't necessarily know that that specific picture of her daughter was intended to be a threat. Either way, it's not before you. You said they took a digital copy of the phone. Okay, if you got a digital copy of the phone, introduce it as an exhibit and let you guys decide if there's something in it that's threatening. You don't just get to state in conclusory fashion without even offering that you've looked at the actual text messages that there's nothing threatening. Of course you didn't see anything threatening, right? He didn't go through and ask her specifically, what's the threat? What's the threat? That's not the testimony. That's not the evidence. She told you that she told them that she was threatened. She told you, and you heard, that there was a meeting at which Mr. Middleton was there and they were there, and she conveyed that to them. If that weren't true, the detective would have told you there was no meeting. That wasn't true. We didn't come in ski masks. He would have told you that, but that evidence is not before you. I would submit, by the greater weight of the evidence, we have established that there was a real emergency. The second element of duress is the defendant reasonably believed the emergency would cause death or serious bodily harm to herself or another. This is pretty much inextricably intertwined and linked with the first element. If there is a real threat, then obviously, since the threat is to cause death or harm to her or a family member, then number two is proven as well. Number three is the perceived harm of death or serious bodily injury was imminent and impending. And that term is that phrase is defined. So let's go down and look at how the court has instructed you regarding the definition of imminent and impending. Imminent and impending means the emergency is about to take place and cannot be avoided by using other means. A threat of future harm is not sufficient for this defense to apply. Okay, so it doesn't mean at this exact instant. If death is impending, you're not already dead, right? Every single threat that's ever been made in the history of the universe is by its very nature about something that's going to take place in the future. What the court has instructed you is that it has to be in the very near future. That's what impending, instead of already happened or happening right this second, means. Impending refers to the future. So look, this doesn't
I'm going to turn it down a little bit.
Rocket scientist to understand what the law is attempting to get you to understand about imminent and impending. It can't be 6 years from now. So like if the threat had been, at some point in the future, we may do something wrong for you, wrong to you, may do something wrong to your family, but they haven't asked her to deliver drugs yet, then the threat's not imminent and impending yet.
The reason that the threat was imminent and impending in this case, that the emergency was imminent and impending, was because, one, it's a threat of an ongoing nature. And the threat didn't become right until she was given the instruction to do the thing that the threat pertained to. Once they told her, now's the time for you to deliver, now the threat's real. Now it's imminent and impending. Now her daughter's in danger, now she's in danger. That's what imminent and impending means. Not some vague future threat, some threat that's gonna happen in the near future now because the orders have been given. And if I violate those orders, something bad is gonna happen to my daughter, to me, or to all of us. The fourth element, the defendant did not intentionally or recklessly place herself in a situation in which it was probable that she would be forced to choose criminal conduct. For folks that don't get involved in criminal conduct, it might seem like any engagement with criminals is likely to produce a situation where you're going to have to commit other crimes. But that's not necessarily the case. Right? Not all criminals are created equal. I mean, do you think law enforcement walks around everywhere they go with masks on? No, because not all criminals are created equal. Certain criminals present a much greater and more grave risk to people. And Miss Heath told you she didn't know she was getting involved with cartel guys when she first got involved in this. The guy that she's texting with is not the guy she's afraid of. The guy that she's communicating with isn't the guy that she's afraid of. She's afraid of the people who are supplying him. She's afraid of the people who show up at her shop. She's afraid of the people that send her pictures of her daughter. That's who she's afraid of. And that's not the person or people that she was interacting with when she made the decision to get in the first place. Was it stupid to get involved in this? Yes. Was it illegal to get involved with these people and agree to deliver drugs? Yes. But not every drug dealer who slings dope or carries dope for other distributors higher up the chain gets in trouble with the cartel. That's not how that normally goes. This is a unique situation. That's why law enforcement acted uniquely when they took or conducted the meeting with Ms. Heath in this case. The next thing that the court instructs you about is that, number 5, the defendant had no reasonable means to avoid the emergency except by committing trafficking in methamphetamine. And the state keeps making the point, well, you could have stopped this law enforcement agency, you could have stopped in this town, you could have stopped in this town. And what is that little town going to do for her daughter wherever she is? What are they going to do for her? Like, can she call law enforcement? Sure, she can. But if she's being followed and her daughter's being followed, and is law enforcement going to stay with them 24 hours a day and babysit them? No, of course not. She didn't believe that would be the case, and she shouldn't believe that would be the case. This was a real threat from real criminals, and she had no reason to believe that law enforcement would be able to protect her when they still wanted something from her. And that's a critical point too. You know, because anytime I look at duress, the question that I always ask myself is like, okay, so you try to cooperate after the fact and you're willing to say all this stuff now. What's different about now? Like, if you can talk about this now, why couldn't you talk about it back then? But she answered that question on her own to Mr. Sullivan on cross. Back then they needed her. They wanted something from her. She was an asset that they were using to make money. Once she's burned, she ain't anything to them. They don't need her anymore. It's on to the next one. That's the difference. The reason she couldn't go to law enforcement before was because she was still their asset, she was still their property, and they were not done using her. And if she had tried to prevent them from using her, from using her to make money, then the cartel members very well may have carried out the threats that they made against her and her family. I would submit that that element has been proven as well. Number 6, the trafficking methamphetamine was committed out of duress so as to avoid the emergency. Well, that's how she avoids them hurting her family. The thing that she did that made them start threatening her was say, I don't want to deliver for you anymore. That's what the threat's related to. So number 6 is proven. Number 7 is that the perceived harm that the defendant avoided outweighed harm caused by committing trafficking in methamphetamine. Look, if the threat is your daughter's going to be sold into human trafficking, or you take drugs to people that already want it and would get it from somebody else, even if you weren't doing it, I would submit that the harm threatened against her and her family was far greater than delivering drugs. And then number 8, the defendant ceased her criminal conduct as soon as the necessity or apparent necessity for the criminal conduct ended. Don't you think law enforcement would have told you if she was still slinging dope? I mean, they know that. They investigate. They have CIs. Like, that's how law enforcement works, especially on drug cases. That's not the evidence. Her testimony was she stopped that day because she was burned, useless to them at that point.
And since then, she hasn't done it. She did make it. At the end of the day, like, I'm not standing here arguing she's innocent in this. But did she intentionally cause this harm? I don't even think the state's going to argue that. Did she recklessly? It was stupid. It was negligent. But is it like you're just abandoning all common sense altogether? Again, levels of criminality. You know, a DUI is not the same thing as murder, right? There's levels of criminality, levels of stupidity. If we're talking about reckless, you at least have to have the predicate knowledge of facts that would make you think, I'm going to be threatened. My family's going to be threatened. She thinks she's just involved in some low-level dope slinging. She doesn't know that the people controlling this network is the cartel. That's why she didn't knowingly or recklessly create this situation. It's a higher standard than accidentally. It's a higher standard than stupid. And at the end of the day, like I said, what this case really comes down to, because the defense has the burden of proof, is just evaluate her testimony. Like, you use all those factors the court gave you, but use your own eyes. Like, at the end of the day, you get to decide if you believed what she told you. Like, I wouldn't be standing here asking this question, did she seem like she was being honest? If it didn't seem like she was being honest, the reason I'm saying decide the defense on that basis is because she comes off as credible. She comes off as truthful. And I think that the fact that I would submit that the fact that law enforcement corroborated that fear by wearing those masks at that meeting is the best evidence you can have outside of what she said about what was going on before her arrest. If those professionals see the danger, y'all should see the danger too and find her not guilty.
Oh, thank you, Your Honor.
They
Talk
basically
about this alleged meeting. No evidence that this meeting even took place. No evidence if it did take place, who was there, where it was. We have no evidence that any of that even existed. Mr. Prince wants you to put so much stock in this meeting and law enforcement wearing masks, and all you've got is Ms. Heath's testimony that this happened. You've got no evidence about it. You've not seen or heard any evidence about it. Mr. Prince made a comment about, why wasn't the investigator re-asked that question? Even if it did happen, you have no evidence whether he was even involved or not, whether he could even testify to what happened at that meeting, if it even happened. And I think that's important, because one thing that Mr. Prince told you is that the state can't, give you this information in a conclusory fashion when he was talking about the phone and whether there were threats in the phone or not. He said that Investigator Loach's testimony concluding there were no threats in that is not sufficient. But that's exactly everything that the defense wants you to believe, or conclusory statements without any proof or evidence whatsoever. This whole duress defense is a conclusory assumption that they want you to jump on. He wants you Mr. Prince made the argument that the phone's in evidence and you could have seen the whole phone. Well, the way that these trials work, these criminal prosecutions work, is none of this is a surprise. All the evidence that I have has to be turned over to the defense. They have time to look at it and review it. And he's got the ability to present any evidence that he thinks is necessary or sufficient. And in this particular case, because the defense has raised an affirmative defense, he has the burden to present evidence of that defense. And I submit to you that if there were threats and evidence, or evidence of these threats, that he equally could have shown those to you. The simple fact is there's been no evidence presented in this trial that Ms. Heath was ever threatened other than her own conclusory statements.
It's rare when the prosecutor can flip the burden like that, but he can here.
And that's important because Mr. Prince mentioned that, why would I be up here arguing does she seem credible? And does she seem credible is one factor that you can use to determine whether she actually is being credible and truthful. But another thing that you should consider is, does the witness's testimony that's given in court agree with the other evidence in the case? And I submit to you that Ms. Heath's testimony on the stand does not agree with the other facts and evidence. And I'm going to go through some of that in a moment, but I'm going to tie it in with one thing that Mr. Prince said. He said, why would she admit to getting into this voluntarily? Why would she admit to putting herself into this situation? Well, the simple fact is
she got caught.
That you deny what you can and you admit what you have to. And when you look at the other evidence in this case and compare it to whether her testimony agrees with the other evidence, she had to admit that. You can see those text messages. Madam Clerk, if I can have the screens, please.
You want me to move again? I'll be right there.
You can see in these messages where she's talking about the prices and asking her supplier, "You're lying to me. You're playing with me. I've been begging you." She has to admit that. She can't deny it. It's clear nobody would ever believe her if she denied that. Does her testimony agree with the other evidence? Well, you heard her testimony that I found out these were cartel, I got scared, and I tried to stop. Well, you've got the message from 2 days before she gets arrested, complaining about the supply. You heard her testimony that she's so scared because these people showed up to her work and took pictures of her daughter. Yet she continues to work and live in the same exact locations. Is that consistent with somebody who's afraid of these imaginary boogeymen? Mr. Prince mentioned the definition of imminent and impending, and I submit to you, you can use your common sense on what those mean. The judge will give you that definition, and like we both said, he will tell you that a threat of future harm is not sufficient for this defense to apply. And the simple fact of the matter is that the defense has failed to prove 3 of these 8 elements, at least, that the perceived harm of death or serious bodily injury was imminent or impending, that the defendant did not intentionally or recklessly place herself in a situation in which it was probable that she would be forced to choose a criminal conduct, that the defendant had no reasonable means to avoid the emergency except by committing the trafficking of methamphetamine. Because the defense has failed to prove those 3 things, your duty as jurors is to find the defendant guilty of trafficking. Now, Mr. Prince briefly mentioned that there was some reasonable doubt as to the elements. I don't think that there's any doubt that this bag of methamphetamine weighs more than 14 grams. You heard that testimony. I don't think you have any doubt that this substance, in fact, is methamphetamine. You heard that testimony. Mr. Prince alluded to some doubt that maybe this bag didn't come out of Miss Heath's vehicle and she didn't possess this bag that night. Again, let's look at the evidence. You saw the photos. Was the photo of the methamphetamine that came out of that bag or that box. And you can see the bagging is still in here. That's the bag on the left side of this photograph. You heard the testimony that this bag was collected from Miss Heath's vehicle, submitted to the Florida Department of Law Enforcement, and tested. Now, Mr. Prince made some questions, made some argument as to the discrepancy in the weights, but you also heard the testimony that the weights, the 1,200 amount that was given by law enforcement was the weight of the total package, including all of the baggies and everything that the methamphetamine was in, while the FDA analyst takes the methamphetamine out of those packages and weighs solely the methamphetamine. That's why there's the discrepancy between 1,200 grams and 984. There is no doubt in this case that this defendant committed this crime. And there is no doubt that when she did so, she was not under duress. And you don't have to take my word for it. Because like I said, does a witness's testimony today match the other evidence in the case? And I submit to you that Ms. Heath, she told you exactly why she was doing this the night she got arrested.
My name's My name's Sergeant Head. I just want to, you do my hand? Yeah. Super popular, very nice. Just been trying to pay my bills. What? EJ, what do you got in the car? Yeah. You have a camera? That's good.
Just trying to pay my bills.
Just trying to pay my bills.
That's what this was all about. And I get it. Times are tough. Everyone feels it. The gas pump, the grocery store. We're all going through that. But to prey on our community and to prey on people who suffer from addiction, to bring this poison to our streets, there were other ways Miss Heath could have chosen to pay her bills. She chose to go this route. You heard her testimony. Several months a year, her business does $50,000, $60,000 a month. That's more than a lot of people make in a year. She chose to prioritize making money.
Old time gamer, thank you very much.
The law.
Super sticker.
And I ask you to find the defendant guilty as charged. Thank you.
Members of the jury, thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. You'll get these instructions sent back with you. Christina Heath, the defendant in this case, has been accused of the crime of trafficking methamphetamine. Certain drugs and chemical substances are by law known as controlled substances. Methamphetamine is a controlled substance. To prove the crime of trafficking in methamphetamine, the state must prove the following three elements beyond a reasonable doubt. Christina Heath knowingly possessed or brought into Florida a substance. The substance was methamphetamine. The methamphetamine weighed 14 grams or more. To prove Christina Heath knowingly possessed a substance, the state must prove beyond a reasonable doubt that she knew of the existence of the substance and intentionally exercised control over that substance. Control can be exercised over a substance, whether the substance is carried on a person, near a person, or in a completely separate location. Mere proximity to a substance does not establish that the person intentionally exercised control over the substance in the absence of additional evidence. Control can be established by proof that Christina Heath had direct personal power to control the substance with the present ability to direct this control by another. If you find the defendant guilty of trafficking in methamphetamine, you must further determine by your verdict whether the state has further proved beyond a reasonable doubt that the methamphetamine weighed 14 grams or more, but less than 28 grams. The methamphetamine weighed 28 grams or more, but less than 200 grams. The methamphetamine weighed 200 grams or more. An issue in this case is whether Christina Heath acted out of duress in committing the crime of trafficking methamphetamine. It is a defense to the crime of trafficking methamphetamine if the defendant acted out of duress. To find the defendant committed trafficking methamphetamine out of duress, you must find the following 8 elements. The defendant reasonably believed an emergency existed. The defendant reasonably believed the emergency would cause death or serious bodily harm to herself or to another. The perceived harm of death or serious bodily injury was imminent and impending. The defendant did not intentionally or recklessly place herself in a situation in which it was probable that she would be forced to choose the criminal conduct. The defendant had no reasonable means to avoid the emergency except by committing the trafficking methamphetamine. The trafficking methamphetamine was committed out of duress to avoid the emergency. The perceived harm that the defendant avoided outweighed the harm caused by committing the trafficking methamphetamine. The defendant ceased her criminal conduct as soon as the necessity or apparent necessity for the criminal conduct ended.
That's going to get her.
Imminent and impending means the emergency is about to take place and cannot be avoided by using other means. A threat of future harm is not sufficient for this defense to apply. The reasonableness of the defendant's belief that an emergency existed should be examined in the light of all the evidence. In deciding whether it was necessary for the defendant to commit the trafficking methamphetamine, you must judge the defendant by the circumstances by which she was surrounded at the time the crime was committed. The emergency facing the defendant need not have been actual. However, to justify the commission of the trafficking methamphetamine, the appearance of the emergency must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed the emergency could be avoided only by committing the trafficking methamphetamine. Furthermore, the defendant must have actually believed the emergency was real. The defendant must prove the affirmative defense of duress by the preponderance of the evidence. The defendant has entered a plea of not guilty. This means you must presume, believe the defendant is innocent. The presumption stays with the defendant as to each material allegation and information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence to prove anything. The law does not require proof beyond all doubt on the part of a jury before it returns a verdict of guilty. A mere possible speculative, imaginary, or forced doubt is not a reasonable doubt. A reasonable doubt is not a guess or mere conjecture. Rather, it is a doubt based upon reasoning and common sense after careful and impartial consideration of all the evidence in the case. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If, after careful and impartial consideration of all the evidence, you have a reasonable doubt as to the guilt of the accused, it is your duty to find the defendant not guilty. On the other hand, if, after careful and impartial consideration of all the evidence, you are convinced beyond a reasonable doubt that the defendant is guilty, it is your duty to find the defendant guilty. It is to the evidence introduced in this trial and to it alone that you look for that proof. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted, as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence of the case? Whether the state has met its burden of proof does not depend upon the number of witnesses that is called or upon the number of exhibits that is offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of other witnesses. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. The juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The defendant in this case has become a witness. You should apply the same rules to the consideration of her testimony that you apply to the testimony of other witnesses. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law that is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are dependent upon you to make a wise and legal decision in this matter. This case must be decided only on the evidence that you've heard from the testimony of the witnesses and have seen the form of the exhibits and evidence in these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each of you must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged in the information or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. Verdict. We, the jury, find as to the defendant, Christina Heath, as follows. Check only one. The defendant is guilty as charged of trafficking methamphetamine. The defendant is not guilty. Special findings. Check only one. If you find the defendant guilty of trafficking methamphetamine, you must further choose one of the following. We find that the methamphetamine weighed 200 grams or more. We find the methamphetamine weighed 28 grams or more, but less than 200 grams. We find the methamphetamine weighed 14 grams or more, but less than 28 grams. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is elect a foreperson who will preside over your deliberations. The foreperson should see to it your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign the date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberation, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Till you've reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instructions I've given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, smartwatches, and other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. They will be secure. If you need to communicate with me, send a note to the bailiff signed by the foreperson. If you have voted, do not disclose the actual vote in the note. If you have questions, I will talk to the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items will receive into evidence as exhibits. You may examine whatever exhibits you think will help in your deliberations.
Except the
The
meth.
exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out of these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has a right to violate the rules we all share. Mr. Sullivan and Mr. Prince, those accurately reflect the instructions agreed upon by the parties?
Yes, sir.
All right, ladies and gentlemen, in just a moment, Deputy Dexter is going to take you back to the jury room. Mr. Causley, you are our alternate juror. So you will not go back to deliberate. I only need 6 jurors, but I pick all these juries on Monday. I have run out of jurors by the time I got to Thursday and Friday, even with alternates. I let the rest of you know that because I've sent a jury back in the back and they didn't deliberate because they're waiting for the other juror to get there. So Mr. Causley will not be going back. So you can go ahead and elect a foreperson. Deputy Hines, I'm sorry, I've changed up. It's Deputy Hines and not Deputy Dexter. But we'll follow him back and go ahead and start. Mr. Causley, if you just remain in the courtroom.
All right, the jury's headed out to deliberate. We're going to start the stopwatch.
And pocketbooks or purses.
It's our phone, watch, iPads, so okay, good. You already? Come on, get your notepads and bring them.
I'm sorry. Bring your notepads. This is the time you can use your notepads.
Bring your notepads, leave your purse and your wallet and your phone and your PIN. Deputy's going to keep track of all that stuff and enter it in a database.
Appreciate that.
All right.
All right, Mr. Causman, thank you so much for your service.
You can stick around
Did
or
not have this trial without alternates. And I'm not kidding. I've had to declare mistrial because I ran out of alternates and ran out of jurors. With that being said, that concludes your jury, sir. You're free to leave the courthouse and go about your week, or if you'd like to remain in the courtroom, you can remain in the courtroom and wait on the verdict. I'll see if I can't get you a sandwich. You want a sandwich.
Oh, alternates get sandwiches?
Thank you for your service, sir. Counsel, thank you for a well-tried case. We'll be in recess until we hear from the jurors.
He was taking his notes with him. Not allowed. All right. Now we're in recess until we hear from the jurors. The timer starts now. We've got 1 minute or 49 seconds in. Alternate gets free lunch. Take your prison purses. Oh my goodness. Free lunch. So now, what do we do? Do you want to go to lunch right now? Do you think we'll have a 10-minute verdict? Do we have a poll? We don't have a poll yet on that yet. Let's see where we're at. We have to sort of sit and wait because 14th Circuit went off the air, so I think we've got closing arguments. Do we have closing arguments in the... Let's see, we do. Hang on 1 second. They happened today. They're going on right now, maybe. Hang on. In the divorce case, they're in deliberation too. Let's go straight to closing, shall we? Do you guys, do we want the verdict? Do we want the closings in the divorce case? Yes, no, maybe so. Want to dance twice? No closings. We need closure. We need to know what happens to the puppy. I just don't want any more testimony. That was like a lot. All right, what's happening in there? This is closings. Jury's coming in. Judge is going to yell into his microphone. I'm sorry, he just does. Overmodulate.
Thank you, Deputy Gordon. Good afternoon, everyone.
Good afternoon, Judge.
Welcome back. We are ready for closing arguments or summations. You all can be seated. In the matter of Piner versus Terry. Talked about it with the lawyers. Mr. Polanco is going to go first. He's going to share with you the facts as he understands them to be. He may talk to you about the law, and you're free to listen to him about the law, but ultimately I'll be telling you what the law is that you must apply to this case, and I'll do that once the closings are done. I mentioned this in my opening remarks. It bears repeating now. You should feel free to be persuaded by what these lawyers tell you, but keep in mind what they say is not evidence. The evidence is closed. There's no new evidence. What we're doing now is connecting dots and making conclusions from the evidence you've already heard. Witness testimony and all the paper evidence. And every document that was admitted, you will have with you during your deliberations. All of petitioners' exhibits as well as all of respondents. So the lawyers will seek to be persuasive, be persuaded. That's okay. It's just not evidence. All right? Mr. Polanco, when you're ready.
Timer on the Clark case. We need some people to keep an eye on 14th Circuit for us.
Okay.
This might get a little spicy.
Okay, so good afternoon, everybody. Thank you for being so patient throughout these 3 days and listening to Christopher Terry's story. Ladies and gentlemen of the jury, as jurors, you've been asked to decide on 3 key issues. Number 1, what is the ground, meaning what is the reason for the divorce? Mr. Piner, on the one hand, seeks a divorce based on an irretrievably broken marriage.
That's cool.
Christopher Terry has counterclaimed and sought a divorce based on what's called cruel treatment. So that's the first question that you have been asked as jurors to decide. Second, how is the marital estate to be equitably divided?
The judge controls the camera.
The marital estate includes all of the things that we've been
He's
hearing
playing
about
with it
over
right
this
now.
past couple of days. And lastly, the third issue that you've been asked to decide upon is, should Mr. Terry receive alimony from Mr. Piner? So those are the 3 issues that you've been asked to decide. Now, the judge, after closing arguments, is going to give you what's called jury instructions. Jury instructions are statements of the law that will guide you as jurors to apply the law to the facts of the case. And he will define a variety of terms. So for example, one of them is the burden of proof. What does that mean in a civil case? The judge will state, for example, that each side has the burden of proving what he seeks based on the testimony and the exhibits. He will define that evidence can be circumstantial or direct, and that evidence can include the testimony of the parties. He will define that you, as the triers of fact, as the investigators of the case, if you will, are the ones that get to decide who is believable, who is credible in this case. Who do I believe about their version of what happened on X, Y, or Z day? You can consider based on your own experience, based on the observation of the party's demeanor, et cetera, and the testimony that you heard, you can decide, well, what is the motive for this person saying what he's saying, right? You can look into the bias or the animus of that person. That can include the feelings that the person has towards the other party, whether it's positive or negative, whatever the case may be. As I said, there are 2 grounds that are being alleged in either direction. On the one hand, irretrievably broken. On the second, the cruel treatment. And the judge will define what those terms are.
Bless you.
So that addresses the grounds, the first issue. The second issue, of course, is the equitable distribution of the marital estate. So for that, the judge will instruct you, for example, that you first have to define what encompasses, what's included in the marital estate and what's non-marital estate. The general rule, and I'm stepping outside of the jury instructions here for a bit, is that, of course, and everybody sort of heard this, is that property acquired prior to a marriage is usually separate property, right? Non-marital property. But, and this actually I'll talk about this in a minute when I start talking about the Nissan, there are actions that the parties can take, that the person that had the separate non-marital property may take, or they may take actions together, which may convert non-marital property into marital property, because of certain actions that were taken. So the judge will also give that instruction regarding non-marital property. And he will discuss the many factors that you will consider as you consider equitable distribution of the marital estate, whatever is in the marital estate. Whatever property was acquired during the marriage, as a general rule, was considered marital property. And that's the second issue to be decided. The third issue, as I mentioned, is the alimony. An alimony, the judge will define as an award for the support of the other while living apart. It is not a matter of right. So you may, but are not required to consider all the factors that the judge is going to give you in determining whether alimony is appropriate in this case. Okay, and then he will discuss the two types, of alimony, whether it's lump sum or cash form. And so those are the 3 issues being asked that we are asking the jury to consider. Now, after being very patient, we submit that Christopher Terry has met his burden of proving that this divorce should be granted based on co-treatment. Why? Because both the beginning of the relationship and the end of the relationship in 2010 and 2025, respectively, lack a proper justification. And I'll explain what I mean by that.
The beginning lacks justification?
In my view, there is no reasonable explanation for the events of 2010. There is no reasonable explanation for the events of 2025. When seeking to end his divorce from a person that he had been married to for 8 years, the petitioner who is seeking the divorce did not ask Mr. Terry for a divorce. He didn't ask him orally. He certainly didn't do it in writing, not even via text message. Instead, a year ago, Mr. Piner came to this courthouse, Fulton County Annex, maybe somewhere else, sure, and obtained an ex parte TPO. It was served on Mr. Terry the same day at their home in Alpharetta, where they had lived since 2016. The petition, which automatically grants a 30-day TPO on an ex parte basis, alleged numerous acts of family violence. Specifically, Mr. Piner listed these. Number 1, 2014, Mr. Terry slapped Mr. Piner in public in Gwinnett in front of a community health center. 2015, Mr. Terry strangled Mr. Piner. Those were the pictures that were submitted in P1. 2017, Mr. Terry threw a plate. Over the years, Mr. Terry punched, this is number 4, Mr. Terry punched holes in the wall, whether by punching or throwing things. Number 5, Mr. Terry regularly empties trash bags on his husband's head. July 2025, Mr. Terry threatened Mr. Piner's life multiple times. Police were never called for these death threats. Number 7, Mr. Terry put his hand over Mr. Piner's nose, obstructing breathing, usually when trying to call police. Number 8, July 6th, Mr. Terry was breaking things in the kitchen. Mr. Piner tried to call the police to prevent the call. Mr. Terry broke the phone. July 12th, Mr. Piner tried to call the police again. We do not know why. Mr. Terry slammed Mr. Piner's phone to the ground and scratched his hand. The same day, this is all included in what's been introduced as the TPO, which is my Exhibit 21, and I believe it was introduced by the petitioner as well as another exhibit. On the same day, meaning July 12th, Mr. Piner was trying to take a nap. Mr. Terry was screaming and wouldn't let him sleep. This affects the hearing. Mr. Piner called police. This call was evidently not interrupted because police arrived and took Mr. Terry to the hospital. So I submit that the allegations, even when taken at face value, are internally inconsistent. You cannot be screaming at somebody when you're trying to take a nap and you call police so that you can go to sleep and allow you to take the nap. And at the same time, you're trying to call police on the same day and the phone is broken. So either the phone is broken and the call is obstructed or the call goes through. Even when taken at face value, Mr. Piner's allegations are internally inconsistent. So far we have 10. Those we know from the TPO from July. But under oath, right in this very courtroom, he alleged other acts of family violence. Specifically, he added 5. He said that Mr. Terry used drugs, that he was regularly unfaithful and adulterous, that he did not get a job or even try, sprayed a bottle of Febreze, and threw the dog at Mr. Piner.
Southern Febreze what?
Now, in fairness to everyone, because I think we've all learned a lot together, at the outset, I do admit that the parties share some characteristics in common. However, I submit that that quality expresses itself in two very different ways. Mr. Terry's naivete is profound. It's palpable. You can just feel it. But it's also very good-natured. Mr. Terry weighs maybe 130 pounds and is fundamentally a very, very caring, loving, and sweet person. He is not a violent person. He's not the man that is being described to you. By contrast, the naivete from which Mr. Piner exhibits is, I don't know if there's another, it's
inauthentic.
There's something,
Use your
there's
words.
something mysterious about it. And you're being asked to judge his allegations based on that credibility. Okay. 7 days after Mr. Terry was served with the TPO on July 15th and he left, he had to sleep in his car, which was the Nissan 370 that he had inherited from his mother. He slept in that car for a week, and then when the car was stolen, he was left without a car, so he had nowhere to sleep. He was now functionally, completely, fully homeless. And so, so Mr. Pine received a text message at 1 p.m. which said, car stolen, help, and it had an address in downtown Atlanta. At 5 p.m., Mr. Terry walks into the house in Alpharetta, but Mr. Pine is accompanied by two people. They stop his entrance, and he leaves without incident. He's escorted out. A week later, July 31st, he gets arrested for violating the TPO, a charge that is called aggravated stalking. Now, Mr. Terry did not respond to the single text message, and it was a single text message asking for the help because the car, the Nissan, which had actually been placed under his name after the car had been sold back and repurchased. Now the Nissan had become marital property because it was sold to the dealership and then purchased back during the marriage. This is a car that is legally under the petitioner's name. So you would think that he would at least show some concern about what happened to him. After all, his name is on a loan that is related to that Nissan. But he doesn't. He doesn't show an ounce of care or empathy for the car because
empathy for the car?
He has achieved what he wanted, which is to get the spouse out of the picture. Now, when Mr. Terry is arrested on July 31st, this causes Mr. Terry to also miss the hearing that you get in Fulton County when somebody applies for an ex parte. You get a hearing where you get to come to court and say that's not true, that didn't happen, that the 12-month order should not issue. He never got that opportunity because he had been arrested, right? And so he spent 8 months in jail, getting out eventually on bond, wearing an ankle monitor that now prevents him from stepping outside of the apartment in which he stays. He stays broke. And so therefore he's legally and physically unable to get a job, even if he wanted to. So Mr. Terry has been placed in quite a very, very narrow space, right? He doesn't have room to maneuver. And he was served at the jail. So he learned about the divorce from the jail while he's sitting there for a couple of months, a month. He gets a sheriff to deliver these papers, and it's titled "Complaint for Divorce." And he reads it and he says, "This is my husband serving me these papers in the jail. He's saying that our marriage is irretrievably broken, that everybody gets to keep their stuff and kind of go their own way. I keep my Toyota Prius, you keep the Nissan. Although of course the Nissan has been repossessed and stolen. And I keep the dog.
It's hard to keep it now.
So at that point, Mr. Terry says, well, I really don't know what to do at this point. I'm going to have to get some help. And so he asks for help and he gets it. And that's sort of where I can. Going back to the statements about the acts of crime violence, excuse me. Not only do I submit that the statements are internally inconsistent, but I submit further that you should take them with a grain of salt for another reason still. Okay. When asked to describe very early on, when asked to describe whether Mr. Piner had anything good to say about these past 8 years or even longer, of dating time. He described the relationship in what I found to be a somewhat peculiar way. He said, we laughed and played video games together. It was a situationship in my mind. We were friends and roommates. I ended up living in his grandma's in separate rooms. The marriage was one of convenience, orchestrated so that Mr. Terry would not lose insurance. I wish him the best. Now, I submit that Mr. Piner is not credible. Full stop. That ends here today. Now, Mr. Piner, like Mr. Terry, took an oath to tell the truth, the whole truth, and nothing but the truth. It's an old concept that goes back to the 1200s. And in the old days, and this is somewhat interesting, I think, the reason we're asked to raise our right hand when we swear an oath is because the left hand was already taken. The left hand usually was tied to either a stone in the Roman times, the Jupiter stone in the Capitoline Hill, or in the Jewish tradition, it was usually, it was also a rock. Other religions have different things, like for example, garlic or onion. The point is that the stone represented the connection with the divine. It represents a connection with like another spiritual world, in which
where are we going?
You're basically saying that I am swearing that that whatever I'm going to say is true, and God cast me down if it isn't. Now, historically, humans were very religious. The people of the Middle Ages, for example, when they swore to tell the
no
truth,
objection here.
They had an inconsumable fear if they didn't tell the truth.
Tell us what to say on witch trials
eternal
next.
Separation from heaven. In my opinion, Mr. Piner was not entirely truthful about those 8 years of marriage. He also wasn't entirely truthful about the 15 of relationship. Now, just as much as the beginning and the end, the two sort of bookmarks at either end of this story were cruel. In my opinion, I submit everything in the middle was also cruel. And what do I mean by that? See, I'm not going to rely too much on exhibits, but I'll just try to see if I can pull one up.
Do I have to move?
Okay. In Respondents Exhibit 4, and let me see if I can zoom. This is dated October 2019, right? So this is 2 months before the marriage itself. There is a disagreement because Mr. Terry has gone elsewhere. He's gone to State Bridge Road. And this causes some sort of series of chain reactions that turns into this string of abuse. We're 100% going to break up. Mind you, they're not married yet. I pray to God that he convinces you to leave me. I would give my soul over to S willingly to live eternally forever in hell. Please, S, take my soul, etc., etc.
It says S.
Please leave my life. I will be a willing servant of S. This is 2 months before the marriage. Now, towards the end, and I believe it was Exhibit 20.
This was the foundation of their relationship? This is the beginning?
We see the same pattern. Of course, this is a month before the TPO a month before the TPO issues. There's these talks about let me see if I can zoom in a little bit closer.
Not zooming in, you're scrolling down looking for it. We can all see you scrolling down.
All right. Can you read that or? Okay, no matter how you word things, I'm not able to further support sin in my life. I hope you have a fantastic day. You're not loving me the way I want because I want my identity in Christ and not sin. A man cannot love another man the way a man can love a woman. Do you need moving boxes? So, this is, of course, a month before. This is June 19th. A month before the...
This is why it's important to prepare your closing.
The TPOs.
Now he's back on his phone. Not sure what he's doing there.
Once again, when seeking divorce, the petitioner didn't ask
His hands are in his suit
for a
pockets.
divorce. Can we just tell you? Talk about it. Okay.
I'm not going to count ums.
He just simply called the law. And the law showed up.
And the law won.
So, in my view, the only image that emerges inevitably is one of either cruel indifference or just innate cruelty. Given who both Mr. Piner and Mr. Terry are.
Go back to your cheat sheet. Scroll down.
Issue number 2, the equitable division of the marital estate. Now, at the outset, it's helpful to start with what doesn't belong there. So the personal belongings in the extra space storage in Alpharetta are not marital property, we said that. So that case. And nobody disputes that, we agree that Mr. Terry should get his personal belongings back, some of which were inherited from his mother in 2018. Now the marital estate. Is this a large marital estate? No. We're talking about a very limited number of things. We're talking about the Nissan. The Nissan 370 is a good example to start with because it was inherited by Mr. Terry in 2018 because his mother died before they get married. Then it's sold to the dealership, bought back, and therefore, because the commercial activity takes place during the marriage, it should be considered marital property. The Nissan is also in Ohio, repossessed. So, maybe out of reach.
Maybe.
The Toyota Prius was bought in 2019. It's used by Mr. Piner to drive to and fro work. I'm not saying that he needs to split a car in half, but it is valued at $9,000. The dog. It was purchased in 2019. You've heard testimony from either party as to who the dog truly belongs to. That issue is in your hands. Income and retirement accounts.
That's all you're going to say about
now,
it?
Mr. Piner generally.
That's the one thing your client wants.
Earns approximately $130 per year. at his job at Virtual Marketing LLC as a contractor for Pfizer. That turns out to be, according to his petitioner's exhibit number 15, which is the domestic relations financial affidavit. It's $11,500 per month. Out of that, $3,000 gets taken off for taxes, leaving $11,500. Out of that, leaving $8,500 net. He claims expenses of $6,000 per month, which does not include another $1,000 that he's paying to settle certain debts that he has with creditors, okay? So all in all, $8,500 minus $7,000 leaves $1,500 left over. Mr. Terry is asking for $1,500 per month for 2 years to get himself on his feet. I think that's appropriate. He thinks it's appropriate. Mr. Terry has never worked for anybody but his husband since 2010. He didn't get paid as an employee between 2010 and 2018. As a husband, I suppose we don't have to get paid under the labor laws, but that's the only job that Mr. Terry has ever had. That's the only experience, the only reference that he can actually put on a job application. Mr. Terry deserves alimony in this case. That's the third issue for you to decide. We hope that you agree with Mr. Terry's contention.
That was a terrible presentation.
Thank you, Mr. Polanco. Ms. Yarber, when you're ready.
Through your lawyer.
Thank you.
Who will probably give a more polished presentation.
Good afternoon, guys. Thank you so much for being here. Third day, we're about to be done. So I have several notes here that I've been taking. I know that y'all have been also keeping up with myself and counsel on what we're doing during the trial. I have several notes. I'm going to go through them in a concise manner so that y'all can know exactly what we're asking for, what our arguments are, okay? So we have spent 3 days here. 3 days of testimony, 3 days of exhibits, 3 days of listening to very different stories about the same 8-year marriage. And now it's you all's turn. So let me be clear about what we're asking you to do. We're asking you to, 1, deny Mr. Terry's request for alimony. 2, keep and let my client keep any debts that are in his own name. That's it. Let Mr. Terry pay for whatever is in his own name. 3, award my client the dog. So soon. 4, award my client his Toyota Prius. Is it Prius or Toyota? That's neither here nor there. Award my client the Prius. The opposing party does not need a car to go anywhere. He doesn't have a job and he's on house arrest. So keep that in mind when you're thinking about who to award the vehicle to. 5, we want the respondent, Mr. Terry, to pick up his stuff from storage by the end of this month. Okay, now here's why you, the jury, should grant what we want. You've been instructed that you must make your decision based on the preponderance of the evidence. So what that means is that you decide the case based on what is more likely than not. So the greater weight of the evidence, the same evidence that we've been showing you all on the screen, and the same evidence you're going to have when you go back to your deliberation room. That is the standard, and that is what the law requires. Now, what is the evidence? The evidence is the testimony you heard from the witness. The evidence is exhibits that were admitted. The photographs, the text messages, the financial affidavits, the protective order, the criminal pending charges, the receipts for the biohazard cleaning, all of that. The evidence is not what the attorneys say. If you want to take what I say, the evidence is not what the attorneys say. So the evidence is not even what I'm saying to you right now. The evidence is what you saw and heard in this courtroom via the exhibits and the party's testimony. So I'm asking you to look at all of that evidence and make a decision based on what you saw. So let me start with the most important thing. The most important thing you need to understand about this case is abusive and manipulative relationships seldom make sense because the victim often does whatever they can to limit the abuser's anger. That is my take on what we saw. So my client, David Piner, is a victim, period. He's a victim of physical abuse. He's a victim of emotional abuse. He's a victim of financial abuse. He is a victim of manipulation, and the evidence of that abuse is overwhelming. from what I saw. So you heard David testify about what the respondent did to him. You heard about the destruction of his CPAP machine, the machine that he needs to breathe at night. The respondent destroyed it. Mr. Terry destroyed it. Why? To control him, to hurt him, to show him who was in charge in that relationship. You heard about the slap in the face, the strangulation, the Febreze that was sprayed in his eyes. Can you imagine that? Someone spraying a chemical cleaner into your eyes. That is cruelty, and that is torture, and that is what my client had to deal with from his husband, quote unquote. You heard about the
Loves True Crimes. Thank you very much.
broken work laptop, and you also saw pictures
We're gonna
of
award
it
you the
that
puppy
we
dog.
provided on the screen showing that his work laptop screen was busted because the opposing party did that. Now, why would my client do anything to his work laptop if that's the only means of him having any income? It doesn't make any sense. The respondent broke my client's laptop. He sabotaged his ability to work. He sabotaged his livelihood. He sabotaged his income. And then he has the audacity to ask David to keep financially supporting him. You heard about the holes that the respondent punched in the wall, and you also saw the holes. You saw my client's bruised ribs from being hit with a water bottle.
I'm glad we didn't see that.
There was constant physical intimidation, the constant fear that my client suffered at the hands of Mr. Terry. Now, Mr. Terry also, you heard evidence, prevented my client from sleeping through the night by yelling, making noise, and intentionally keeping him up. All of this points to manipulation. And the emotional abuse, let's go to that. So, my client, David, he would purchase clothes for himself, simple, basic clothing. And the respondent would take those clothes, return them to the store to get the cash, and then spend the cash on himself. That is not a partner, that's a parasite. My client even said that the opposing party would pee around the house just like the dog did. What was the dog's name? Sozu, just like Sozu. So we basically had two Sozus in the house. Got it. The respondent would go nonverbal, refusing to speak to David until David agreed to move him into a new apartment. What's up with that? He used silence as a weapon. He used emotional withdrawal as a form of control. He manipulated David into doing what he wanted, period. And here's the thing that should make every single one of you angry. When David testified about the respondent, Mr. Terry, breaking his CPAP machine, Mr. Terry was sitting right there over next to me at this table in this courtroom, and he was smiling and giggling. While all of you all had to sit here for this 3-day trial that he requested, he's over there smiling and giggling. He does not care about what he did to David. He has no remorse. He has no shame. He sat there and laughed at the testimony about his own abuse, and that tells you everything you need to know about his character. And this is not new. So this has been going on for years. In 2014, the opposing party, Mr. Terry, was arrested for slapping David in public. That was before they were even married. He has been abusive for over a decade. It's 2026. So he is currently on house arrest for what he did to David. He has a nice little bracelet on his ankle. It is not like the bracelet I have on my ankle. He has an active protective order against him. A judge found that my client, David, needed to be protected from this man. That is how you get something like that granted for 12 months. You don't just get it willy-nilly. He has pending charges. Mr. Terry has pending charges for aggravated stalking against my client. He is a criminal, and he is a danger, and he wants you, the jury, to award him money. And he admitted it. So he admitted on the stand verbatim. He said that he goes through big emotions, quote unquote. That's how he describes it, big emotions. That's his excuse. So that is his justification, and that is the minimization. It is big emotions cause him to strangle his husband, spray chemicals in his husband's eyes, break his husband's CPAP machine. Big emotions cause him to punch holes in the wall that y'all saw. But big emotions do not give anyone the right to abuse another human being. So big emotions do not make you a victim, and they certainly do not entitle you to alimony, okay? Now, the opposing party wants this divorce to be granted on cruel treatment towards him, which is funny. He wants to stand here and claim he's a victim. He wants you to believe that David was cruel to him. Let me tell you why that does not even matter. Let me tell you why this has been a colossal waste of their time. So in Georgia, The practical difference between a divorce being granted as cruelty or irreconcilable difference is extremely minimal because the courts almost exclusively grant no-fault divorces. So while cruel treatment is a recognized fault ground, proving that it kind of requires airing out details in court, sort of like what you all saw, the irreconcilable difference ground or irretrievably broken ground for divorce is faster, cheaper, and yields the same result, which is getting them divorced. So we're here going back and forth about nothing that matters, mind you. Whether it's up under cruel treatment or irreconcilable difference, it doesn't matter. So we've been here for 3 days, 3 days of your lives, 3 days of testimony, 3 days of exhibits for what? To argue about cruel treatment when the result is exactly the same regardless. Got it. The marriage is over. Everyone agrees the marriage is over. The divorce will be granted no matter what. So the only question is whether you want to make David pay a man who abused him. So why are we here? Why did the opposing party request a jury trial? Okay, let me tell you why. The opposing party is a performer. That's the reason he requested a jury. He thought to himself, let me see how many people I can fool with my performance. I won't be able to fool the judge because the judge judges every day. His job is to judge, but a jury of my peers, I can fool them. And he performed. He performed for you. You all saw it yesterday. I saw it too. He was being asked questions, hard questions, tough questions about what he did to David, my client. And he's like, oh my gosh, I love David so much. I would never hurt him. He's my snuggle bug, etc. Meanwhile, he has on an ankle monitor for what he did to my client. That is a fact. So aside from his Oscar-worthy performance, the evidence showed the truth. The protective order, the house arrest, the pending criminal charges, the pending criminal conviction, the text messages where David was begging him to stop spending his money, the photos of the home in a state of biohazard by a man who also called himself a house husband. It's neither here nor there. He's a performer. He performed for you for 3 days, and bravo to him for having y'all here for 3 days. He got exactly what he wanted. He got a stage, he got an audience, he got 3 days of your attention, but do not let the performance fool you. Don't let the act determine your verdict, okay? Look at the evidence, look at the facts, look at the truth. There have been a lot of red herrings all through this 3 days. I'm about to point them all out to you. Let me actually tell you about everything in this trial that did not matter at all to what you all have to decide. Number one, the party's gamer profile history.
Hold on.
My client's ex-girlfriend.
Hold on. We need to do a quick check-in with Judge Clark.
For this one, I have to get 5 more to get to the 100 mark. And I've got 7
He tricked
more.
us.
So as long as I don't lose 3 in the next 6, I'll be at 90%, which is what I thought.
Okay, never mind. False alarm.
Coming in. I'll see if y'all can.
No, because you got all those people running the streets. You don't want to live there.
Yeah, let's tell them the record. Let's go ahead and.
Technically, it's only 20 minutes.
That's it. I'm gonna hit the button. I'm gonna hit the button.
Yeah. You know, I would be all for it or something like that. Just, you know, to get more experience and try different things. You know.
Do you think?
You know, I tried a case here, but it was they brought in a judge from Walton County. So it was an attorney out of Tallahassee, but a judge from Walton County, and it was like day one, I was like, oh, this is I'm used to kind of how things go, and I was like, it was an adjustment.
Yeah.
If you're getting slayed, they knew what they were doing. You better watch out.
Yeah, it's right there in the restroom. She's right here, so she's at the steps.
She's missing. I think we have it. I'm going to hit the button. What do you think? They wouldn't be back unless there's a verdict. There could be a question. They could want to read back. I doubt it.
they should do.
Prosecutor's shooting for that 90% conviction rate. If he gets 3 more.
Not just that, but also like, I feel like you realize, okay, I'm not going to waste my time on this one.
Well, yeah.
Okay.
The last judge, I'm from Quincy. The last judge that I practiced, a good bit from the Second Circuit, just died last week, or week before last.
Sorry to hear
Who's that?
Judge Gary.
Oh, Judge Garrett, I didn't hear that.
Who gets a bingo if the defendant runs?
It made me feel old. It makes me feel old.
If she
All the judges,
splits.
Judge Gary, Judge Bubba, Charlie McClure. I practiced a bunch in Hood, of all in Hood, and
Hood had the cigar on always, right?
Yeah. They both Hood and Judge Gary have died in the last 6 months, last 4 months.
All right. Got some motion. Here we go. Looks like she's coming in.
Mr. Miller, let's go ahead and get her in here, okay?
When are we going to break for lunch, Judge?
All right, Ms. Heath and Mr. Prince, Mr. Milton, Mr. Sullivan, we're all present. Deputy Dexter, from understand the jurors have reached a verdict?
Yes.
Let's bring them in.
This is one methed up case. We've got a defendant, the sole occupant of a vehicle, who admits to police she had a brick of meth in her car. What was her defense? She says, somebody made me do it. Let's see if the jury bought that or if they're going to send her to what would be a minimum of 15 years in prison. Jury's coming in right now as they take their seats.
All the jurors are present. Everyone can have a seat. Are you the foreperson?
Yes, sir.
I understand the jurors have reached a verdict. Is that correct?
We have.
You'll hand the verdict form to Deputy Dexter. It's Ms. Heath, Mr. Prince, and Mr. Milton. If you'll all have, stand, please. Madam Clerk, if you'll publish the verdict.
Circuit Court, 14th Judicial Circuit of the State of Florida, in Fort Bend County. State of Florida versus Christina Heath, case number 2025 CF 579. Verdict. We, the jury, find as the defendant Christina Heath as follows. The defendant is guilty as charged of trafficking methamphetamine. Special findings. If you find the defendant guilty of trafficking methamphetamine, you must further choose one of the following. We find the methamphetamine weighed 200 grams or more. So say we all, dated the 6th day of August 2026. Foreperson, James Conway.
You can have a seat. Madam Clerk, if you'll poll the jurors, please.
Okay, this is your verdict.
It is.
It was 45 minutes of deliberation.
Ms. Patterson, is this your verdict? Yes. Mr.
Yes.
Thank you. Say your name.
Merkel.
Merkel, thank you.
Mr. Merkel?
Mr. Roper, is this your verdict? And Ms. Ford, is this your verdict? Yes.
Ladies and gentlemen,
Did
I
she
wish
say
to
no?
thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you're at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere.
It will be up to you to decide whether to preserve your privacy as a juror. Ladies and gentlemen, thank you for your consideration. Thank you for your service. I know that everyone has somewhere else to be. I think Mr. Roper, you may be starting practice pretty soon. May have missed some of that. But you put all that aside and made yourselves available for jury service. Our system of justice would come to a grinding halt without citizens such as yourself. People can throw rocks at our justice system,
but we shoot back.
I would guarantee you that the vast majority of the world wish they could have this system. Their citizens come here and make these decisions. With that being said, that concludes your jury service. Remember to have take all your belongings, leave your notes or destroy your notes. If you'll follow the bailiffs in the back, they'll escort you to the parking lot. Thank you so much.
Jurors are done. They head out. Now we're basically right back where we were a couple days ago,
right.
which was about to plead guilty to this charge.
We prepared a sentence today.
Yes, sir. Yes, sir.
The score sheet? And what are the, I know there's a mandatory cost. What does that amount?
$250,000, John, and 15 years.
As for a civil judgment like the DSP.
Yes, yeah, I'll do all that.
Get the new
And
pair of
I have
bracelets.
Ms. Heath at about 30 days to show that as well.
Do you agree with that?
$250,000 fine.
All right. Mr. Prince? Yeah.
Do you want
The $250,000? Yes, I do. Thank you. All right. Does Ms. Heath wish to be heard prior to sentencing?
I'm sorry.
That's all she has to say. So I'm sorry. Lawyer's giving her some sage advice.
Ms. Heath indicates she's fine. Just have to be.
All right, Mr. Prince, I'm gonna, what I'll do is I'll allow the state to go first, and I'll allow you to respond to theirs to make your own order.
Yes.
Sullivan?
Your Honor, I mean, you heard the testimony. There is the minimum mandatory 15 years. I'm asking for a sentence of 20 years.
Okay.
She's asked
Mr.
for
Prince?
20 years.
Your Honor, at 15, the punitive sanctions imposed by the Minutemen are obviously incredibly significant, especially given a relative lack of history. I would say that 15 years is certainly great enough to impose a punishment contemplated by the statute, especially when taken in conjunction with the score sheet, which is less than half of, looked like it was about half or less than half of the total Minuteman sentence had to be. So I would ask the court to just impose 15.
Prosecution wants 20 years. Defense says 15. 15 is the minimum.
Yes, ma'am. You can stay seated or you can stand, whatever you'd like to do.
Yes, sir. I have found out while I was in this courtroom that my uncle is having open heart surgery and he's not expecting to make it. Is there any way I could go home and close out my business and come back in 2 days, 3 days?
No, ma'am. And I'm not doing that just anybody that's convicted. I remand them to custody. Okay. Regardless of the charge.
Yes, sir.
All right. Ms. Heath, you've been convicted by a jury of your peers of trafficking in methamphetamine, 200 grams or more. It's now my duty and obligation to sentence you. I've listened to the testimony. I've listened to your testimony. And what concerns the court the most is this is not an isolated incident. Maybe a part of a series of incidents. This time, you're adjudicated guilty of trafficking methamphetamine, 200 grams or more. You'll be sentenced to 20 years in the Florida Department of Corrections. Given credit for 30 days time served. I'm going to assess fines and costs of $1,303. Those include discretionary cost of $2 of local law enforcement education, a $65 assessment district court cost, and a $50 drug abuse trust fund payment, and a $700 discretionary fine.
a $250,000 fine, which is the mandatory fine for the trafficking in that amount. Those fines and costs are reduced to a civil judgment. There's no restitution after in the case. This is a 15-year minimum mandatory sentence. There's no restitution applicable. You have 30 days to file your notice of appeal if you wish to appeal your judgment sentence. If you'd like to have an attorney to represent you, you can't afford one. One may be if one to represent you at no charge. Good luck to you, man. You step over and big finger print it.
Yeah. So that's what would have happened a couple days ago, only it would have been 5 years less had she accepted the deal the prosecutors offered her. Instead, she said, we'll take it to court. Prosecution changed their tune once they got the conviction and said we'd like 20 years, and the judge granted it. So she got her day in court, but it cost her 5 years of her life, and I guess the fine would have happened anyway, $250,000 fine. What's the lesson to be learned? Don't get methed up with meth. Trafficking, especially in Florida, they take it quite seriously, and this is that's where she's going to end up for quite a while. So there we go. Now we're going to jump back to finish where we were just a minute ago. We're on 6.
Anything that happened before December of 2018 when they got married, doesn't matter. Whether they got married at an annex or their living room and the date that it happened in December, that went on for about 30 to 45 minutes. That doesn't matter. Whether they, any gay conversion therapy conversation, doesn't matter. Anything pertaining to God or Satan, doesn't matter. The respondent being served with the divorce papers in jail, doesn't matter. And counsel just said in his closing that my client did not ask his client for a divorce. That's not even a requirement. So it's just more of him spending time during this hearing on things that do not matter. You don't have to ask somebody for a divorce. If you want a divorce, just go file it. It's not a requirement. And honestly, a whole bunch of other stuff the opposing counsel and party were spending hours on. Hours of your time, hours of my client's time, hours of the court's time on things that do not matter. Hours of my time. Counsel also misrepresented just now in his closing argument the TPO ex parte hearing. So counsel stated just now in his closing argument that my client filed an ex parte protective order and then had him arrested so that Mr. Terry could not attend the ex parte hearing. Did y'all hear that?
Ex parte.
Counsel does not know what ex parte means. Ex parte, a Latin phrase, literally means for one party. So a legal proceeding that takes place for one party without the knowledge or notification of the other side. Oops. So he's like, oh, he filed an ex parte, my client wasn't able to go. It's an ex parte, he wouldn't be able to go. It's for one party. That's literally how it works. So none of that changes the facts. None of that changes the views. None of that changes the fact that the opposing party is a 31-year-old healthy man who refuses to work. Period. None of that changes the fact that my client has no ability to pay alimony. None of that matters to your decision. So why do they spend so much time on it? Because they have nothing else. They have no evidence. They have no case. They have no argument. They have tried to distract you all, confuse you, and make you think about anything other than the truth in this case. So the opposing party wants to be considered a house husband. That's what he called himself. That's the label he wants you to believe. Really, he's a passive moocher. That's what I would call it. You saw the photos. You saw the photos inside the home. The filth. It was filthy. It was messy. It was a biohazard. The opposing party claimed he did chores. Not a chore was done up in there. Okay. So much so that my client had to spend $1,600 for professional cleaning so that they would pass a fire inspection. He's talking about some. He took care of the home. He did not take care of the home. That doesn't even make any sense. And what was the respondent, Mr. Terry's, evidence to that? What did he introduce? What did he show you to prove his case? A picture of him and Sozo, the dog. And a lot of text messages where my client was telling him in all caps, please stop spending my money. Where's the rest of his evidence? We've been here for 3 days and we don't have any other evidence. It's mind-boggling. The respondent wants to be taken care of for the rest of his life. That's it. That is what this trial is about, nothing else. He wants you, the jury, to grant that wish for him. Let's not do that today. He was incarcerated for 8 months for what he has done to my client. That's 8 full months. That's like a January to an August. It's August now, so just all year he basically would have been incarcerated. And now he wants money from my client to get back on his feet. His words exactly, I put it in quotation in my notes. He wants to get back on his feet, but here's the thing, he was never on his feet, ever. So the evidence showed that before living with David, he was living with father and his nana back and forth. He was not self-sufficient then. He's never been self-sufficient. And when I asked him yesterday, right here in this courtroom, I said, what were your plans when you plan to, he claims he was planning to leave my client and, go do something else with his life, move on. I said, what was your plan to take care of yourself? He said he was going to rely on someone else. He said he was planning to move back in with his father in Arkansas. So he was never planning to get a job. He was never planning to be self-sufficient. This has never been his life plan. Grown man, mind you. 31-year-old grown man, mind you. So I also think that this is further shown by his family history. So he stated his nana was a stay-at-home wife. And his mother, before having him, worked in insurance. But once he was born, she transitioned into a wife and homemaker role. This is his words exactly. This is what he wants his life to be. He wants his life to mirror his nana and his mother at the expense of my client, okay? He wants to be a stay-at-home spouse or a stay-at-home divorce spouse. I don't know. Well, all of us gotta work. All of us are here dealing with this because he wants to stay at home. He wants David to work. He wants David to provide. He wants David to pay for everything. He wants a free ride, but that is not how marriage works. That is not how adulthood works. That's not how life works. This is the same man who said on the stand that one 45-minute Uber Eats trip exhausted him. His words verbatim, I'll do a long Uber Eats trip and then be like, ooh, I'm tired. He literally said that. While we've been in here for eight hours times 3. He said that. This man just don't want to work. So he is perfectly capable of working. He can drive, he can read, he can write, he can work a computer, he has a GED, he has experience as a personal assistant. Let him tell it. There's absolutely nothing stopping him from getting a job. His resume, the one he entered into evidence, he entered one more thing into evidence. It was a resume from 2014. Hope y'all remember that. His resume, the one he entered into evidence, conveniently showed that he stopped any type of work right before marrying my client. It showed he worked before the marriage and then nothing. David said that the marriage was an arrangement to ensure that Mr. Terry had health insurance, very scam likely, okay? It was a scam. The respondent, Mr. Terry, married David for benefits, for the health insurance, for the financial support, for the free ride, and now that the ride is over, he's trying to get more, okay? So let's talk about the law briefly. In Georgia, for alimony, you must show that one party has the financial need and that the other party has the ability to pay, okay? So it's a two-pronged test. We saw all those zeros on those financial and on that financial affidavit he submitted. I've never seen that many zeros in my life, honestly. So sure, he has a financial need, sure. But my client does not have the ability to pay any money to Mr. Terry. So I want you to remember my client's financial affidavit that was entered into evidence. I want you to look at the numbers. Numbers rarely lie. He makes $10,312 per month before tax, okay? And he may or may not get bonuses depending on if his boss likes him or not, whatever that means.
That's what the bonuses
so
are?
His net monthly income is $8,564 per month. His expenses are $7,200 per month minimum.
I've got to limit her a little bit.
So he's bringing in $8,500. His expenses are $7,200. That's leaving him about $800 to spare just for other expenses. So that does not include, well, let me tell you what his expenses that I calculated, what it actually does include. His monthly payment to creditors. So let me list all the creditors. Kohl's, Discovery Bank, or is it Discover Bank? I don't know. I don't bank with them. Truist, Ally Bank, a debt consolidation firm, so paying an attorney to try to get rid of some debt, Mission Lane, and American Express. So the outstanding balance, so not even including like the monthly fee adds up to $7,000, but the outstanding balance for all those creditors is $42,600. $638.26. So once he gets done paying all that per month, then we can look at how much it costs for his living expenses. So
Kaylee May,
it
you're
does
an
not include
OG.
that 7,000 figure. Does not include his rent. It does not include his vehicle payment for Prius. It does not include food. It does not include insurance. It does not include utility, whatever else you might come to on a day-to-day type thing. His current checking account balance with Discover Bank is negative $203.67. He's in the red. His checking account balance with Truist Bank has a current balance of 12 cents. 12 cents. I didn't even know that you could keep an account open with 12 cents. His checking account with Bank of America has a current balance of 2 cents. Where does the opposing party, Mr. Terry, expect him to get $2,500 per month to pay him for the next 3 years? Mr. Terry needs to get a job. And then the opposing party has the nerve to say that my client is hiding assets. Please tell me, if this man looks like he is hiding assets, everyone look at him. Does he look like he is hiding assets and purchasing Louis Vuitton? Please tell me. That's not even believable, like, at face value. There was absolutely no evidence. Mr. Terry said my client was buying Louis Vuitton. I would really like to see that. There was absolutely no evidence introduced from the opposing side showing that there's hidden money. No bank statements, no receipts showing luxury purchases, no financial documents showing money disappearing, nothing like that. So we're just in here playing a guessing game at his whim. Got it. So this has been a waste of time, honestly. Sorry to y'all. So let's consider the law again, briefly. Under code section, the code section that addresses alimony is 19-6-1. It covers alimony and it gives the judges a wide discretion to reduce alimony by weighing the conduct of the parties, if you will. So the only specific marital misconduct that acts as an absolute statutory bar for getting alimony is adultery and desertion. Okay? And guess what? The opposing party committed adultery. So David testified that Terry would go hook up with men on Grindr throughout their entire marriage. And Mr. Terry never said that he didn't do that when he got on the stand all day yesterday. So that's adultery. That's a statutory bar to receiving alimony anyway under Georgia law. So he'd be prevented from getting alimony because he was hooking up with men on Grindr. So even if you set aside the abuse, you shouldn't have set aside the abuse. But even if you do set aside the abuse, the opposing party committed adultery. He cheated on David. He went out and found other men, and now he wants David to pay him under the law. He's not even entitled to alimony just by doing that. So, all right, finally, the dog. So, whatever. The dog that Mr. Terry wants you to give him.
She should
This
know
is
the
the same
dog's
dog
name.
that's been in my client's possession solely since August of last year because the opposing party was arrested. He was in jail for 8 months, and now he's on house arrest in Statesboro. The dog has been with my client solely since August of 2025. My client has been feeding the dog, providing for the dog, ensuring that the dog is healthy, ensuring that the dog goes to the veterinarian. It's all up to date. And my client can actually pay to get those things done. David testified that the opposing party threw the dog. He threw a defenseless animal. He threatened to snap the dog's neck. That's what Mr. Terry did. He refused to feed the dog, saying God will provide for the dog, so he no longer needed to feed him. He didn't even have the money to take the dog to the vet. He can't feed himself, let alone feed the dog. He can't walk the dog. He's on house arrest. Why would y'all award him the dog? I'm not quite certain. This ties into his God complex, I think. The same reason he requested to have you, the jury, here for 3 days. 3 days that you could have been with your families or at work, something that he refuses to do. Because he thinks you all are going to award him a meal ticket and feel sorry for him. Let's not do that. My client is a good man. He's a hardworking man. He's a victim of abuse. You can tell that even just by the pending criminal charges, okay? He has been through hell. He's been strangled, slapped, sprayed with chemicals, manipulated, financially drained, emotionally destroyed, and now he's being taken to court for money in a 3-day trial. He stands before you asking for you to do the right thing. Just do the right thing. He's asking for a fresh start. All he wants y'all to do is grant the divorce, let him keep his stuff, and let him go on about his merry way. The opposing party, on the other hand, 31 years old, grown man. He is healthy. He's capable of working. He has no children. He has no disability. He has no excuse. He needs to support himself. Do not give him alimony. Do not give him the dog. He can't even take care of the dog. Do not give him David's car, please. And do not give him David's money. And also make him pick up his stuff from storage this month, please. He's taken enough from David, and he's honestly taken enough from y'all, to be honest. So with that, I believe the deliberation should be very short, please.
All right, so.
Thank you, Ms. Yarber.
We're now going to jump ahead.
So I need to give you the law now. Anyone need a break before we do that? It's okay if you want one. Mine is much less interesting than what they just shared with you.
There we go. We're going to jump ahead to the current time, which is jury deliberating for an hour and 20 minutes. And that's not actually a video picture of them deliberating. That's a stock photo of what a jury might look like if they deliberate. So now we're back in verdict watch. Man, we just want to know where the dog is. Hey, can I propose something? Here's what I propose. Third party. The dog has never met. Okay? Put a leash on the dog. Walk the dog as each person stands there. The dog gets to smell them, see them, and walk them to the other person, smell them, see them, and then go at equal distance away from the two. Okay? And then, like fighting it out in mutual combat, you then walk the dog away 100 yards away and release the dog. And you do your best to call the dog to entice it to come over. Wherever the dog wants to go is where the dog should go. Would this be a fair way to sort this out? And if the dog turns around and goes back to the person who walked it there, for heaven's sake, don't make it go with any of the other two. That's it. It's done. I'm like King Solomon in this one. I think there's an easy solution that will sort itself out. If the dog runs, let it be free. Give it a herd of sheep in the mountains, and it will be happy. Don't make it go back into that urine-filled anything. Yeah. Okay. That's how Judge Judy does it. Bring the dog. Oh my goodness. The dog might want to go with one of them. It might. Dogs are incredibly forgiving. They're better than their owners in many regards. But I don't think the jury should pick the dog. I'd put treats in my pocket, says Pat. Who's a good boy? All right. Jury is deliberating. We'll keep this on standby in the background. We might go somewhere else while we wait. We may get verdict music twice in one day. It's a thing. It could happen. Meanwhile, it is Thursday. It's Podcast Thursday. We can jump down to Texas. Check out what Judge Boyd is doing. Show them the thumbnail. Let me grab the thumbnail.
We stayed for a year, and then we moved back to the valley. Where we were living wasn't safe for him, so I let him stay with an aunt of mine. And he stayed there until third grade or fourth grade, and then we moved back to San Antonio. It's been back and forth.
I'm sorry, just to interrupt a little bit. You had mentioned something about, you said something that you would run and then you would move back. What do you mean by you would
I was
run?
in an abusive relationship for 30 years.
And so my next question was, you said it wasn't safe for Jose. Why wasn't it safe for Jose?
Because his dad is an addict. And there was times where he felt like he needed to protect me and would get involved.
Who would feel like he?
Junior.
Who's Junior?
Jose.
How old was he more or less when this happened?
The first time he saved me he was 3.
Okay, I don't know what's going on here. We're gonna bail for just a minute so I can show you the thumbnail for this case. Thank you, Red, for putting this one together. Piner v. Terry, the super duper messy divorce case, Judge McBurney's courtroom in Fulton County, Georgia, with the dog Sozu wanting out. Tumblr Troy, I don't have a deliberation timer on this one, only because I wasn't able to start it when they started. We know it's been about an hour and 20 minutes, though. So this is a great little thumbnail. I think I also owe you a bingo sheet, right? The update to the bingo. Have you updated the bingo thing, Red? If so, let me take a peek. I think it's being updated as we speak. Oh, there we go. Let's download this one. I think if you take this information that we're about to show you and put it into Bingo Baker, I think that's the term, you can make your own bingo cards. So far, that's the best we can offer. We're not offering bingo cards other than that. Put that one right there and go back up here. Okay, so this is these are the different items that would appear on a bingo card, and you can see don't talk over each other, need an IT assistant, shorts are underdressed, excessive coughing, the breakout room. That would be, I guess a sharp break would be on there. Take a sharp break. Child present with no sitter. All good stuff. All good stuff. So we'll see if we can. I think this is being posted over on the Facebook page as well. So we can check that out over there if you need a download copy. Just waiting for the judge to finish up what she's doing. Not sure what the case is. Let's see if there's anything else we can jump to while the jury continues deliberating in McBurney's court. They have a difficult job. It's not just as easy as saying, yes, you two should be divorced. That I think is a given. I think they also have to do a lot of math. Let's go check out Judge Ricky now.
Of a felony. Of possessing a firearm. You know better. And then it complicates things even more, Mr. Willard, is that not only were you in possession of a firearm that you shouldn't have, you had one that apparently had defaced identification marks so it couldn't be traced back to the holder of the gun, which the court considers a complicating factor in the case, despite the fact that the court has run the time concurrently with one another. At some point, Mr. Willard, you need to be held accountable for your choices. It does appear that these other courts just apparently tried to minimize the fact that you're not taking responsibility for your actions, ultimately, because you just continue to commit serial amounts of crimes. Greenwood, Neosho, Allen, and Butler. This court cannot see that this is a case for probation at this juncture. The court will invoke the special rule in this case and impose a prison sentence at this time as a result of the special rule application, which enables the court to do so. Because I think at some point, Mr. Willard, you need to be held accountable for all of your choices and all of your actions. And it doesn't appear that that's happening anywhere else in any other meaningful way. So the court does impose the 13-month prison sentence at this time. This court does find that the defendant has 4 days of jail time credit that would apply to this case. That's to be reflected by the sentencing journal entry. Court does assess $400 in KBI lab fees to this defendant and a felony docket fee. Any bids amounts are waived under the facts and circumstances of the case.
I think we need to go back and see what
These
happened
amounts are all immediately due, payable, and collectible. I don't think there's any other restitution request, so the court will make no other restitution orders in this matter. At some point in the future, Mr. Willard, you may have the right to seek expungement of one or more of these offenses. Certain statutory limitations do apply. If you have any questions about your right to someday seek expungement, you can address those questions to a lawyer and I'm sure get your questions answered. Under certain circumstances, Mr. Willard, a criminal defendant in Kansas, has a right to appeal their convictions to an appellate court having jurisdiction. And if you are unable to pay the cost of an appeal, you, the defendant, may request the court to appoint a lawyer to represent you on appeal and to direct that you be supplied with a transcript of trial court proceedings. Pursuant to KSA 22-3608C, you, the defendant, Mr. Willard, have 14 days after this judgment in court to file any notice of appeal with the clerk of the district court of Butler County, Kansas. You do have the right to appeal this sentence. If the court has ruled adversely to you at this hearing, I will remind you that there's prohibitions against a convicted felon possessing a firearm, and that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. All right, Mr. Storer, are you aware of other sentencing-related matters which the court needs to make a specific ruling on?
We're going to back up and catch the beginning of this if we
Sorry,
can.
Judge. No,
All right,
I don't.
thank you, Mr. Storer. Mr. Favre, are you aware of other sentencing-related matters?
Sorry,
which
Mr.
the court
Favre,
still
I'm
needs to
covering you.
address?
No, Judge, thank you.
All right. Mr. Willard, my hope would be that you take advantage of any treatment program alternative offered by the Department of Corrections. I also encourage you to earn every possible good time credit while you're there to earn your earliest possible release date.
He's not listening.
Because of the advocacy of your attorney in this matter, Mr. Willard, I have imposed the mitigated sentence, in other words, the least sentence without a departure that the court can grant in this case, and run your counts concurrently with one another. But it seems to this court, Mr. Willard, as I outlined earlier, that it's going to take a prison sentence for you to get your attention so that you don't possess firearms and you're not involved in any way with drugs or drug culture. Good luck with your achievements in the future, Mr. Willard. All right. Ms. Winter, thank you for your work in this case and for the patience of appearing multiple times for the sentencing.
Let's go back. I think it started at the very
Report
beginning.
from the Zoom location at the court security station at the Butler County Judicial Center.
See how his
Joseph
demeanor
Favre
changes.
appears as defense counsel. Cole
behind me.
Storer appears on behalf of the prosecution in this case. Docket notes indicate that the defendant appeared before this court back on May 19th. At that time, he entered a no contest plea to count 3, criminal possession of a firearm, a level 8 felony, and also count 4, defacing identification marks on a firearm, a level 10 felony. A pre-sentence report was ordered. Sentencing originally set for July 24. July 24 notes indicate that the defendant was in Allen County custody and therefore wasn't available for our sentencing. The matter was reset to July 30th. July 30th docket notes indicate that there was some sort of staffing or technical problem on Allen County Jail's end. He was still there, Mr. Willard. He again was declared unavailable. The matter was reset again to August 5, yesterday at 4 o'clock. This court waited for Mr. Willard to join the meeting for, I think, a full 30 minutes yesterday. Mr. Willard did not join the meeting, apparently considering some Allen County court appearance to be more important than the Butler one. And based on the advocacy of his attorney, Mr. Favre, this court did resolve doubts in favor of not entering a bench warrant issue at that time, but rather rescheduled the matter to today, directing counsel to notify Mr. Willard of his need to attend on date, time, and location, which Mr. Willard now has complied with. We're now before the court at this time for sentencing. Court has received a completed pre-sentence investigation report compiled by Tyler Winter, pre-sentence investigator from Court Services, who is present on this meeting with us. I trust each attorney has received a copy of this report, and I'll ask the state's attorney first, is there any objection to the criminal history which is stated in the report?
No objection from the state, Judge.
Any objection from the defense, Mr. Favre?
No objection, Judge.
The court will therefore adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing on the primary count is criminal history score E, and the court will proceed further accordingly. Mr. Storer, do you know of any legal reason why sentence should not be pronounced in this Willard case this afternoon?
No, Your Honor.
Mr. Favre, are you aware of any such legal reason?
I'm not, Judge, no.
Mr. Willard, do you know of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing at this time?
No, other than on treatment.
Right.
No, Your Honor.
The court will proceed further then. Counsel, I'm not aware that there's been a departure motion or any other sentencing related motion that's been filed in the case. Does the state have any such motion to pursue?
It is not, Judge.
Does the defense, Mr. Favre?
No, Judge.
Are there any victims or members of a victim's family who desires to address the court in relation to the Willard sentencing?
None.
Finding no such persons present, court will ask for recommendations from counsel regarding an appropriate sentence. We'll begin with Cole Storr on behalf of the state of Kansas.
Thank you, Your Honor. The state is recommending the standard number on both counts 3 and 4, that the counts run concurrently for a total underlying of 14 months. The state will ask the court to apply Special Rule 9, running this case consecutively to any prior case, but is not requesting imprisonment pursuant to that special rule.
Right, Mr. Storr, what cases would this run consecutively to in particular?
Oh, I apologize, Judge. It is Neosho County 22 CR 149. I believe that's the case. Asking for probation supervision by community corrections pursuant to the PSI with those standard probation conditions, and specifically the special conditions of meaningful participation and completion of the MRT program, no ownership or possession of any firearms, asking for a lab fee of $400. And I believe that's all, Judge.
So, Storr, this may not have been your case to handle by your office from its inception, but why is the state making a recommendation for probation in this case, rather than having this court invoke the special rule and incarcerate Mr. Willard? What's the rationale of the state for making that recommendation?
Your Honor, I'm just going off of what Mr. Sweeney recommended.
Very well. Mr. Favre, your recommendations at this time for an appropriate sentence?
Thank you, Judge. We are joining with the recommendation listed by Mr. Storr for the mid-box on counts 3 and 4, which would be a total of 14 months, run concurrently. Probation duration of 18 months. Mr. Willard is presumptive probation. There is, as the court noted, a special rule application that requires this case to run consecutive to the previously mentioned Neosho case. I will inform the court that it was contemplated part of this plea that the state would not recommend the discretionary portion of the special rule prior to Mr. Willard's recent struggles with being in Allen County and all the complications that have come from that. He actually was in good contact. He participated well in his hearings. And so I think that was a large part of this. This was a late 2025 case. It did not drag on very long before Mr. Willard resolved it. So, I mean, most of the dragging on has happened with the sentencing portion. So that is the reason why we had recommended the joint recommendation to not impose the discretionary portion. And I'll inform the court also that Mr. Willard, prior to his incarceration, was working. And as he mentioned, he has recently gotten into treatment, although I think that's a very recent development because he was just out of Allen County jail as of like a week ago. I spoke to his attorney there. So I think the treatment is new. I forget the location where he's doing it at. John, where are you doing the treatment at?
I'm doing it with Peggy. Well, her name is Peggy Collins.
Where, not who?
I'm not sure the name of it. I can't remember the name of it right now. I'm sorry, but it's Peggy Collins who runs it, who runs my treatment.
It's really impactful and it's working.
So, so we're asking the court to allow him to continue on that path and try to rebuild sobriety in the community. And so that's the extent of our recommendations.
Ms. Winter?
Yes, Your Honor.
Perhaps you can address a question for the court. I note that on his criminal history, he had a conviction in Greenwood County.
Yes.
Would a special rule application need to take into account the Greenwood County case as well?
I don't believe so, Your Honor. The only thing I know, it just prohibits him from being Senate bill eligible since it's a distribution. But he was convicted, I believe, in that case first. And then he was convicted in the Speller County case, I believe a week after.
That's bad.
Well, I was wondering if he was on bond in Greenwood County when this set of offenses were committed.
Okay. Now we see why the judge.
And with it being a conviction date of May 13 of 2026, is he on community corrections in that case now?
That case is still pending sentencing, Judge, in front of Judge Satterfield. It's set for sentencing.
All right, that's all we needed.
I want to say it's at the end of August.
Yeah, so he's gonna do 13 months in the slammer to wake him up and get him to pay attention to stop committing crime after crime after crime and county after county after county. All right, jury's still deliberating in McBurney, so we're gonna hold tight there. And let's see. See if we have anything else that's live. I want to know where the dog goes. Who gets the doggo? Let's go to Royal Oaks Traffic Court.
And that does the backup.
What?
I have to say, it never.
That's our timing is impeccable.
Take a short break.
Yeah, we took a very sharp break. Let's see. Let's try this one.
So I don't know if that is the fine or if that's just the bond. Okay, you're free to go make your phone calls.
Thank you.
You're welcome. Donald Gilmore. Mr. Gilmore, you have a motion to revoke your community supervision and cause number DC 2025 CR 2590 for a third-degree felony, possession of a controlled substance, penalty group 1 or 1B between 1 and 4 grams. At this time, you'll be held without bond on that charge. Do you have an attorney representing you?
It's Murray, Nancy Murray.
Okay. We'll appoint her to this case too. Do you have any questions? All right, you're free to go make your phone calls. Adam Grimaldo.
It's a nice little group.
Mr.
Texas Tech
Grimaldo,
getting
you've been
some
charged with
representation.
second-degree felony burglary of a habitation. I do find probable cause for that charge and set your bond at $15,000. You've also been charged with a Class B misdemeanor, possession of marijuana less than 2 ounces. I do find probable cause for that charge and set that bond at $1,000. And I do show Megan Saltzman's representing you on some other matters, so we'll appoint her as your attorney on these matters. Do you have any questions? You do have a couple city tickets. So if you'll have a seat, that judge will be right with you. Stephen Harrison. Mr. Harrison, you've been indicted in 2 different charges and cause numbers DC 2026 CR 1749 and 1755, both third-degree felonies for assault against a family or household member with a previous conviction. One alleged to have occurred April 14th of 2026, the other on April 16th of 2026. Each of those bonds has been set at $10,000. So $20,000 total on these 2 charges. And I show Robert Sullivan's representing you. So we'll appoint him on these 2 new charges. Do you have any questions?
That's all I got? Them 2?
For today, you may have other pending charges that I didn't go over. So you look on your
That's all I
tablet
got.
when you get back to your pod and it'll show all of your pending charges.
Excuse my language.
All right.
When I indicted, wait, so I got 2 indictments? Wait.
Yes.
16th of April?
Yes, one's on the 14th of April, the other on the 16th.
Jeez.
So I don't know. I didn't write down who the victim or the alleged
Were you
victims are. So if
expecting
you haven't
more?
been served copies of those indictments, stop by the processing desk. They can print those off for you. It'll say who the alleged victim is and how exactly they're alleging you assaulted them.
This court is
To the original,
Lubbock
my
County.
original indictment. I mean, I
It may still be pending.
Oh,
Yeah. So that's why you can either look at the tablet in your pod and see everything pending against you, or when you go to the processing desk to ask them for these indictments, if Mr. T Arena is out there, you know, who works for the courts, you know,
no, Fred. Fred, okay,
he can tell you everything pending against you.
okay.
You're free to go make your phone calls.
This court sponsored by
Ashley
Hammermill Paper
Hernandez.
Company.
Mr. Hernandez, you have a motion to revoke your community supervision and cause number CC 2026 CR 0371 for the class A misdemeanor driving while intoxicated. The blood or breath alcohol concentration of greater than or equal to 0.15. Your bond's been set at $8,000. Do you want a court-appointed attorney?
No, I have a lawyer.
You have any questions?
No.
All right, you're free to go make your phone calls.
There goes
Nathan
Texas
Herrera.
Tech.
Mr. Herrera, you've been charged with a Class B misdemeanor, reckless driving. I do find probable cause for that charge. Set your bond at $4,000. Do you want a court-appointed attorney? Do you have any questions? All right, you're free to go make your phone calls. Israel Morales. Mr. Morales, you also have been indicted in two different cause numbers. The
This court
first
is
is
so
in cause
efficient.
number DC 2026 CR 1748 out of the 99 District Court for a state jail felony of arson alleged to have occurred April 29th of 2026. That bond's been set at $3,000. Then you've been indicted in cause number DC 2026 CR 1750, also out of the 99th District Court for a state jail felony burglary of a building alleged to have occurred April 25th of 2026. That bond's been set at $2,500. It'll show Lacey Hillstrom's representing you.
Yes, ma'am.
Okay.
So one's on April 25th and the other one on April 29th.
Mhm.
And up here on these, they're both under 10,000, even added up together, they're both under 10,000. Am I still eligible for pretrial on these?
That's a good question. I would put in a request for pretrial services and they'll respond back to you.
They're showing something about, on my paperwork, it's saying something about enhancements.
Yes, bring it up here and I'll show you.
You may approach.
They're both saying the same enhancements though.
Yeah, so the enhancement paragraphs are stating you had these two previous felony convictions.
Right.
And so
But I feel they took care of that. They're trying to,
No, I know. Now that you've taken care of these felonies, though, they can enhance it when you get arrested again and get charged again. They can make the punishment range go from here to here. So just talk to Ms. Hillstrom about what that means as far as the punishment range.
that's what I was gonna ask. Initially, without the enhancements, what is these two?
So talk to Ms. Hillstrom. She'll tell you all about it, okay?
All right.
All right, you're free to go make your phone call. Jeremy Ortega. Mr. Ortega, you have a motion to proceed with adjudication of guilt and cause number DC 2023 CR 0793 for a third-degree felony, continuous violence against the family. You will be held
Continuous.
without bond on this charge. And I show Taha's representing you. Do you have any questions? You're free to go make your phone calls.
Good to go back to the set.
Johnny Tovar? Mr. Tovar, you had a warrant issued against you in cause number PFF 2026 MAG 2362 for a state jail felony theft, less than $2,500 with two or more previous convictions. The bond has now been set at $4,000. And I show Troy Nicholson's representing you.
Yes.
Do you have any questions? You're free to go make your phone calls.
Thank you.
You're welcome.
Texas has some younger judges. I think this is one of them.
All right, Judge McNamara will be right with y'all on your city tickets. Did you get her email? So I don't, you may want to.
Interesting. Another judge is going to pop in and handle the city tickets. Let's see. Judge Simpson, what's he up to today?
Afternoon, Your Honor. My state is appearing with Christopher Whitmore, who's president of Perryville Zone.
Whitmore, state your name.
Christopher Whitmore.
Oh, there he is. Okay. All right, what are we doing?
Judge, recently came in on this matter. Substitution was signed yesterday. I received a discovery. Needs some additional time in order to review it and decide how we're going to proceed.
Okay. Adjourn this matter out to September 3rd.
Is that Mr. Davis?
Yes, it is.
Mr. Davis, if you get a copy of your appearance to my office, we'll get you the videos as well.
Okay, thank you.
All right, September 3rd.
All right, thank you, Your Honor.
You, court calls case, People versus Davion Smetler.
Good afternoon, Your Honor. Vote for the people.
Smetler?
Yes, Your Honor.
Here you are.
Here somewhere. So,
Been one of those days. I'll pass this matter when he shows back in here, and I'll call it back up. I'll pass it, sir. I'll call you back up in a moment as soon as we find your attorney.
Okay.
Court calls case, People versus Drenda Miller.
We get the rare court recorder view.
Good afternoon, Your Honor.
That's
Reading for the people.
Assistant Public Defender Tanaza E. Carey Adams early on behalf of Miss I think it's Drenda. It starts with Vita.
The more you talk, the slower you walk. You think it'll appear. You'll eventually get here. That's okay. I saw the guy take off going to go look for her.
She was coughing, Judge, and she stepped out.
You should see her.
Ms. Miller, state your name for the record.
Drenda Miller. Is that with you?
My great nephew and my husband.
Which one was in the short? He just took off running out of here. That was you. Okay. Heard your name and he was flying. All right.
To the bathroom.
It's okay.
We're setting this matter for preliminary examination, please.
Discovery is complete.
To our knowledge, Your Honor, yes.
Are there witnesses available the 18th?
For best, Your Honor.
Set the preliminary examination August 18th, 2026, 9 a.m. before.
Okay.
Judge Moore.
18.
Thank
Thank you
you.
so much. Thank you.
Court calls case of the People versus Marcus Mudar.
Lieutenant Levo for Mr. Mudar. I haven't been able to reach Mr. Mudar, Your Honor.
You don't know where he is?
I'd like to, but unfortunately I don't.
If I didn't say anything, you just sit here and stare at me all day, wouldn't you?
No, Your Honor.
Okay. Bench warrant will issue for defendant's failure to appear in bond. We'll be setting him at a 10,000 cash surety.
Thank you.
Court calls the case of the People versus Deshaun Murray. Deshaun Murray. Where's Cannon?
Assistant Public Defender Hannah Apple appearing on behalf of Deshaun Murray. Your Honor, we're asking for an adjournment. Yeah.
I don't think it.
Oh.
Hi.
actually, yes, in the Jackson County Jail.
Oh.
Oh. Like those accommodations better. All right. We haven't been able to check Vine Link, but I'll adjourn it out to the 20th. Well, I'll adjourn it out to the 27th. Let's see if we can find him. And
Thank you.
Thank you.
Court calls the cases of the People versus Robin D. Nobles. 3 cases.
Assistant Public Defender Nicholas Butkovich on behalf of Ms. Nobles.
Hello, Ms. Nobles. State your name, please.
Hi, Robin Nobles.
How come Bukovich is having to cover for you?
I didn't realize we were in the 3 o'clock, Your Honor.
What?
Completely my mistake. No excuses. Asli Bashir on behalf of Rob Nobles. Your Honor, we're requesting an adjournment just so I can speak with Ms. Nobles. Is he's located at a treatment facility, and I haven't gotten a chance to speak with her about her case.
August 27th, 2026, 9 a.m.
Thank you.
Bond continue.
Thank you, Your Honor.
Thank you, Your Honor. Thank you.
Court calls the case, People versus Dylan Reynolds.
On behalf of people,
Assistant Public Defender Jay Bellinger on behalf of Mr. Reynolds, who should be in appearance via Zoom. Mr. Reynolds, can you please unmute yourself, state your name for the record?
Dylan Reynolds.
And Your Honor, we are seeking to set this matter for preliminary examination. That said, I have spoken with Ms. Zenda. I think that given the fact that the parties both live in Pennsylvania and my client has some work stuff, we were asking, I'm hoping for...
Live in Pennsylvania?
Yes.
Steelers or Eagles fans? Depending on where I said it.
Mr. Reynolds?
Yes.
Are you a Steelers fan?
Oh, no, I'm a Seahawks fan.
Okay.
And worse.
Okay. Your Honor, we were hoping to set the date for the preliminary examination on September 1st, if the courts would be available for that.
You want September 1st date? All right. So preliminary examination will be set September 1st, 2026, 9 a.m. Mr. Douche, before you leave.
Mr. What?
9 a.m. before Judge Perry.
Thank you.
Bond will continue.
Thank you.
Mr. Douche, to approach at a separate manner.
Oh.
All right. Judge goes in the sidebar. I think it's time to take a little lunch. We're still waiting for the doggo decision, as we're calling it. And Pepsi looks so refreshing. Not a sponsor.
Yes, ma'am. So demanding. Court calls the case, People versus James Robinson.
people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Robinson, who should...
What? Hold it. Coming up to do the case?
Oh, I'm so sorry.
Please. She ran all the way down that aisle. And,
by all means.
And she just stopped and headed the other way because...
I'm glad she's here and available.
Ow.
Not trying to take opportunities away for her to learn.
Yes, you were. Yes, you were. That's okay. I was going to let you do it anyway. Went back, sat down, bowed her head.
Aw.
Almost in,
sorry, Andy.
I'm almost in tears. Go ahead.
Your Honor, Amy Lucas requesting permission to practice pursuant to Michigan Court Rules 8.10 under the supervision of Assistant Public Defender Jay Bellinger.
Pick somebody else to be under supervision of, because he should have done that to you. Hannah Apple, go ahead.
Okay.
Permission to practice is granted.
Oh.
Okay, what are we doing in this case?
We're seeking to adjourn for continued negotiations.
Okay. That objection. Adjourn the matter to September 3rd, 2026.
Thank you.
Thank you. Thank you for appearing.
Thank you.
For appearing. You did a great job.
Was that for me? I'm sorry, James.
No. It is adjourned, sir.
All right.
September 3rd.
Thank you.
All right, thank you. Court calls the case, People versus Ashley Tree.
Ashley Fellows for people.
Asli Bashir on behalf of Ashley Threet.
Her name?
Ashley Threet. Your Honor, we previously adjourned the matter for screening for specialty court because of Ms. Threet has recently moved, and so we are seeking screening into another special court. I'm requesting
You got to go to another location, try to get her.
Yes, Your Honor.
starting over. All right. I'll adjourn the matter out to September 10th, 2026.
All right, thank you, Your Honor. We started the process.
92 days.
92?
Yes.
Congratulations. That's happier?
Oh, yeah. I feel like a different person.
All right. Well, you make sure to keep up the good work.
Oh,
Okay?
yeah.
It'll be 120 some odd days, but well, no. Yeah, something like that when you get back here.
Yeah.
All right.
Thank you.
Court calls the case. So the people versus Sarah Ward.
Spell it for the people. I'm so Hutchins on behalf of Sarah Ward, who I believe is appearing via Zoom.
Ward, can you state your name, please?
Sarah Ward.
Thank you.
Thank you, Your Honor. We are requesting an adjournment for discovery.
Matter to August 27th, 2026, 9 a.m.
Thank you.
Bond continued. Court calls case people versus Eric Woods.
Enzo Hutchins on behalf of Eric Woods. President, please state your name for the record.
Eric Woods. Thank you.
Your Honor, we'd like to set this for preliminary exam.
Discovery is complete.
Hello.
Procedural matters, and unfortunately you have not.
Hello?
Take a short break.
How does he do that? Hello.
Procedural matters, and unfortunately you have not.
Hello?
When are we going to break for lunch, Judge?
You don't put a diplomatic plate on a hoopty.
Remember in the beginning when we started 110 years ago?
Have them send someone with more experience.
Sorry, my food was cooking in the microwave. I couldn't leave it. It would burn.
I don't like podiums, Your Honor.
Well, I think the jury's going to be doing this for a while. We have the podcast tonight. I'm lucky it didn't start playing the next video, because that's like some gamers from England.
Take a short break.
I took a short break. Not a short break, just a short break. I think we've been through pretty much all of the courts that are available to us, and we're running out rapidly of options.
When are we going to break for lunch, Judge?
Let's see if there's anything here. There's a water main break in Hollywood. Looks like drinking water from the color. Okay, hang on. Let me see. I don't see the message. Love a good podcast verdict. Mod chat. Let's see. Haven't read this. The memorandum. The state filed a memorandum. This is a short one. It's only 28 pages. Basically telling the judge that this, in the Tyler Robinson case, that this is the easiest preliminary hearing he's ever had to see. It's the most obvious one. I put some pepper on my food, and it's making me sneeze.
Coming out and just pouring down the streets, and then again affecting some of the other roadways out here. But that dirty water coming out of that concrete right there, that's the scary part. That's going to be something that may be undermining that portion of the asphalt where those cars are sitting. Hate to see any vehicle get dumped into the water. Right now, though, you can see a lot of that mud and stuff out there, and this is going to be on Wonderland Elementary. And Dylan was just saying that there is actually more water coming out. This is the actual address that we got when from the assignment desk. When we were looking up the actual address, this is the actual address right there, and you can see the water coming out of there. But we've learned this. It will undermine a lot of that roadway and basically pop up in different spots. And we understand it. There is DWP arriving on scene. So
Division of Water Pressure
shut off very soon.
All right, so that's going on. California has plenty of water. Yeah, that was in LA. That was a quick one. Bad time for a police chase. All right, I've got food to eat. It's tuna casserole. It's not something fancy, but we are set up for the podcast at 8:30. Excuse me, 8 o'clock tonight. We've actually got a portal already built. The podcast is already put together, and we're planning on going there tonight. Until then, there's jury deliberating. We hope we'll get a verdict. Oh man, look at this video.
Really kind of get an idea how much water is just pouring out from underneath that asphalt slab.
The car is
and
going
you
to
can
collapse
see it.
into
It's
a
kind
hole.
of lifted, and that could be from the water. And remember, when we watched that stuff happening out there in the West Hollywood area, as soon as that water got shut off, a lot of that roadway collapsed, and some of those sidewalks just collapsed.
Yeah, that's going to be awesome. All right. Join us for the Not Relevant podcast tonight at 8 p.m. Yeah, that's Stu in L.A. Fox Local, I think, has it. I forget what channel that is. Because he's the guy. We're going to wrap up. Because we don't have anything else to cover. And y'all probably have things to do. Maybe they should put the water on the wildfires. There's a great idea. That's a great idea.
I'm wearing multiple hats.
Thurston went live. Just now. Thurston County Courts. What is the... What hearings are these? Let's see. Oh, this is in custody. Let's pop in real quick. Hang on. We're popping in. I'll move out of the way.
All right, we're going to get started on the Olympia and Lacey in custody calendar. Quite a few here. There we go. All right, let's start at Nisqually. Lacey, Ms. Crisco, I see you over there on the side. Who have you got?
Hi, Your Honor. This is Believe Fighties with me.
Do we have our interpreter as well?
Believe they're in person at the courthouse.
Oh. Do we have our Chuki's interpreter? All right. Yeah, just either one of these tables has a microphone on it. So what were you hoping to do today, Ms. Grisco?
Your Honor, first to address the Chuukese interpreter, I talked with the Chuukese interpreter before we came here. And it's more as standby in case there's a term that Ms. Faites needs help translating.
Okay, so you want to have interpreter on standby?
Yes, Your Honor.
Okay, are you okay with that?
I'm okay with that, Your Honor.
Okay, very good. Can I have you identify yourself for the record then?
Yes, good afternoon, Your Honor. Lester Muritok, Muritok, qualified Chuukese interpreter.
Thank you. All right, so Ms. Crisco, I think we I think it was at your request, put this case on today for disposition.
Yes, Your Honor.
All right. And I have some disposition documents here.
Yes, this will be for the case ending in 8822 for the physical control. It will be a change of plea. And then for the case ending in 5125 on the DUI, it will be a stipulated order of continuance for 24 months. And if completed and all conditions are met, it will be amended to a negligent driving in the first degree.
So that's how we know it's a Lacey case. All right, Ms. Eddy, you're offering an SOC on case 125?
That is correct, Your Honor.
Okay. All right, and
The
Ms.
judge
Faites,
just
can you
threw
hear me
shade at
okay?
Lacey for
Yes, Your Honor.
dropping the charges down.
I'm looking first at this stipulated order of continuance in the DUI case. Have you looked at that stipulated order of continuance agreement with your lawyer?
Yes, Your Honor.
Okay. So what this is a continuance of your case for 24 months without the case going to trial. You've agreed that you're going to complete some conditions, and it looks like those are mostly regarding not consuming alcohol and drugs and attending and participating in alcohol and drug treatment, doing a victim panel. And if you comply with all of the conditions that are set forth here, at the end of that 24 months, the prosecutor will change the charge from driving under the influence to negligent driving first degree, and that's what would go on your record. So does that sound like what you agreed to?
Yes, Your Honor.
Okay. And if you were to fail to comply with any of those conditions, then you would have a trial in front of the judge. There'd be no jury. And then the judge would only consider the police report in your trial and make a determination just based on only that police report, whether you committed the DUI. All right. So do you understand that you're waiving some rights to take advantage of this?
Yes, Your Honor.
Okay. Okay, then I'm going to accept your case for a continuance, a stipulated order of continuance on conditions.
I guess Lacey lets people off easy. It's 4:30. I think it's time to go home. Excuse you. You might need to take a sharp break. I think we're going to wrap it up. Let me have some time to prep before the podcast, and we'll end it here. So I'll play the music. I'll play the music again.
Take a short break.
There we go.
Thank you, sir. You're my new best friend.
What more do you need to see?
All right. As I clear my plate so it's out of view. Tonight when you go home, please hug the people you love, smile, someone make their day just a little bit better, and please stay safe until we go live again tonight, 8 p.m. That's in 3.5 hours. We'll portal over there so you can click the like button and you can be notified when we start. We'll go to the podcast tonight. Join us for that. It's going to be a lot of fun. I think I might head to the store and find some snacks to try. Nothing nasty. I think we need to try something good. So I'll head to the store, see if we can find something. Guys, have a good one. Thank you very much. We will see you tomorrow. Looking forward to some big cases starting as soon as Monday. It's going to be awesome. We'll see you guys. Bye-bye.